Check one.
मेरा पेज कहाँ है?
No, we don't have the extra list, sir. You do one thing.
हाँ, dignitaries across the globe लिख दिया है मैंने.
No,
पहले वो ऊपर तो आ जाए.
ठीक.
पहले ऊपर.
हाँ, dash में है. May I request the dignitaries to please come and grace the dais. Good morning, everybody.
And all the dignitaries of the dais. पहन दो. ॐ सहना भवतु सहनो भुनक्तु सह वीर्यं करवावहे तेजस्विनावधीतमस्तु मा विद्विषावहे. ॐ शांति शांति शांति. अर्थात ईश्वर हमेशा हमारी रक्षा करे, हमारे उद्देश्यों की प्राप्ति में सहायक हो और हम बिना किसी द्वेष के इसी प्रकार अपना कार्य करते रहें. ऑनरेबल मिस्टर सर, काइंडली बी सीटेड. ऑनरेबल मिस्टर जस्टिस सूर्यकांत, द चीफ जस्टिस सुप्रीम कोर्ट ऑफ इंडिया. ऑनरेबल मिस्टर जस्टिस विजय विश्नोई, जज सुप्रीम कोर्ट ऑफ इंडिया. ऑनरेबल श्री प्रेमचंद बैरवा, द डिप्यूटी चीफ मिनिस्टर ऑफ राजस्थान. ऑनरेबल मिस्टर जस्टिस संजीव प्रकाश शर्मा, the acting chief justice of Rajasthan High Court and executive chairman, Rajasthan State Legal Services Authority. Honorable Dr. Pushpendra Singh Bhati, judge, Rajasthan High Court and chairman, Rajasthan High Court Legal Services Committee, Jodhpur. Mr. Rajendra Prasad, Advocate General, Rajasthan. Dr. Nandini Gore, General Secretary, Nivaran. Honorable judges of Rajasthan High Court, all dignitaries of the dais, distinguished members of the judiciary from across the globe, learned members of the bar, esteemed dignitaries from Commonwealth nations, ladies and gentlemen. It is my privilege to extend a heartfelt welcome to each one of you to the keynote session of the core conference day of the Commonwealth Peace Mediation Conference. Today, it feels like the entire judicial galaxy has gathered at one place, with every distinguished legal luminary contributing to its brilliance, and the presence of Honorable Mr. Justice Suryakant, the Chief Justice of India, is adding a special radiance to this august gathering. भारतीय संस्कृति सदैव कहती रही है, संगच्छध्वम संवदध्वम समवो मनांसी जानताम, meaning thereby, let us walk together, let us speak together, let our minds be united. We shall now proceed with the ceremonial felicitation of our esteemed dignitaries on the dais with Safa and Planter. First of all, I would like to request Honorable Mr. Justice Sanjeev Prakash Sharma, the Acting Chief Justice of Rajasthan, to kindly felicitate Honorable Mr. Justice Surikant, the Chief Justice of India. Now I request Honorable Dr. Justice Nupur Bhati, Judge, Rajasthan High Court, to kindly come on the stage and felicitate Honorable Mr. Justice Vijay Vishnoi, Judge, Supreme Court of India. Now I request Honorable Mr. Justice Ashok Kumar Jain, Judge, Rajasthan High Court, to kindly come on the stage and felicitate Honorable Deputy Chief Minister Shri Prem Chand Bairwa. Now I request Honorable Mr. Justice Yogendra Kumar Purohit to kindly felicitate Honorable Mr. Justice Sanjeev Prakash Sharma, the Acting Chief Justice of Rajasthan and Executive Chairman, Rajasthan State Legal Services Authority.
Deputy Chief Minister Mr. Bairwa, E-A-I-R-W-A. Prem Chand Bairwa. Sorry, full name is Prem Chand.
Now I request Honorable Mr. Justice Bhuvan Goyal, Judge, Rajasthan High Court, to kindly felicitate Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court. Now I request respected Member Secretary, Rajasthan State Legal Services Authority, Shri Hari Om Atri, to kindly felicitate Shri Rajendra Prasad, Advocate General, Rajasthan. Now I request Shri Ajay Singh, Registrar cum PPS, to Honorable the Acting Chief Justice, Rajasthan High Court, to kindly felicitate Dr. Nandini Gore, General Secretary, Nivaran.
Thank you.
Thank you, dais. Thank you, everybody, those who felicitated our dignitaries on the dais. And now we begin our day's proceedings. But before that, let's all arise in the respect of singing our Rashtrageet Vande Mataram. Thank you, everybody. May I now request Mr. Rajendra Prasad, Advocate General, Rajasthan, for his welcome address. May we have you, sir?
A very good morning to all. Honorable Mr. Justice Suryakant, the Chief Justice of India, whose leadership of Indian judiciary comes at a defining moment in the evolution of our justice system. His Lordship has consistently championed access to justice and transformative role of mediation in strengthening the rule of law. It is a matter of immense pride for Rajasthan that His Lordship has graciously accepted the invitation to deliver the keynote address today. Honorable Mr. Justice Sri Vijay Vishnoi, Judge Supreme Court of India, a son of this soil, a great jurist with a pleasant persona. Honorable Mr. Justice Sanjeev Prakash Sharma, Acting Chief Justice of Rajasthan High Court and Executive Chairman RSLSA, whose vision has been instrumental in bringing this conference to fruition. His Lordship's tenure has ushered in a period of remarkable transformation for the Rajasthan High Court, a testament to his keen grasp of both the letter of law and the lived realities of people it serves, which has inspired far-reaching reforms in judicial functioning. Sri Deputy CM Sri Berwa, who represents the cause of those who needs mediation and justice the most. Honorable Justice Dr. Pushpendra Singh Bhati, Judge Rajasthan High Court and Executive Chairman of the Rajasthan High Court Legal Service Committee, a man with futuristic vision and an adjudicator who consistently fosters constructive dialogue, honors diverse perspectives, and guides parties towards common ground. Honorable Srimati Nandini Gore, the General Secretary Nivaran, who has been working for long to establish mediation as means of justice. The Honorable judges and esteemed dignitaries and delegates from Commonwealth countries, Honorable judges of Rajasthan High Court and the other high courts, the office bearers of RSLSA, learned office bearers of members of Commonwealth and members of Commonwealth Lawyers Association and Supreme Court Bar Association, learned advocate friends, judicial officers, and distinguished ladies and gentlemen. It is a great pleasure and honor for me to extend a warm welcome to all of you to this Commonwealth Peace Mediation Conference 2026 on peace mediation and the rule of law. Before I proceed further, I would like to acknowledge and express my heartfelt appreciation to Commonwealth Lawyers Association, Supreme Court Bar Association, RSLSA, Rajasthan High Court, and Nivaran, mediators of the Supreme Court of India, for playing a pivotal role in bringing together this august gathering of eminent jurists, legal professionals, and mediators from across the Commonwealth countries for this conference. I wish to especially acknowledge the efforts of Sri R. Santhana Krishnan, Life President of Commonwealth Lawyers Association and President Nivaran, as well as Sri Aruneshwar Gupta, Vice President of Nivaran, the intellectual driving force behind this conference. I invite you all to join me in giving them a well-deserved round of applause. The Government of Rajasthan is proud to support this initiative and to partner with institutions committed to advancing mediation as an instrument of justice, harmony, and social progress. Law and justice are not static concepts frozen in time. They are living traditions continuously reshaped by the societies that practice them. From the earliest civilizations to the present day, every era has left this imprint on how we understand justice, each generation refining what come before. We the Indians have cherished from time immemorial the ideal that is ayam nija paroveti ganuna laguchetasam udara charitanam tu vasudeva kutumbakam. This is mine, that is his, say the small-minded. The wise believe that the entire world is a family. This civilizational ethos would find renewed expression in this conference on peace mediation. The choice of Pink City as venue by the organizers is very apt, as Jaipur is land whose history teaches us that enduring peace is secured not merely through victory in battles and wars, but through the wisdom and harmony to resolve differences and conflicts with dignity. We know that as law became codified, reduced to statutes, sections, and precedents, something subtle was lost along the way. Justice delivery, in its pursuit of certainty and uniformity, began to lean heavily on the mechanical application of rights and duties as written in the books of law, often at the cost of human element that justice was originally meant to serve. The people behind the dispute, their circumstances, their responsible relationships, their underlying needs became secondary to the legal category their grievance fell into. This tendency finds its deepest expression and clearest expression in the adversarial system, a framework inherited from common law traditions. Peace mediation offers a fundamentally different philosophy. Rather than asking who wins, it asks what do both parties actually need and how can those needs be met together. Mediation looks beyond the immediate dispute to the long-term relationship and sustainable resolution of underlying interests. It is not concerned with declaring a victor, but with crafting an outcome where both parties emerge with their core interests protected, an outcome that is durable, precisely because it was built collaboratively rather than imposed by the system. I must also clearly draw distinction between mediation simpliciter and peace mediation upon which the galaxy of the intellectuals present today would deliberate in this conference. While mediation focuses on resolution of specific disputes between the parties by reaching to a mutually acceptable agreement through elements of counseling. Peace mediation is a transformative concept which incorporates elements of continuous education, training and capacity building to promote peace and understanding in the communities, groups, organizations, and even nations to resolve conflict. It involves a more comprehensive approach addressing underlying issues and root causes of the conflict, implementation of laws by executive and enforcement thereof by judiciary is the presently prevalent way of ensuring rule of law. Peace mediation as an innovative way of establishing sustainable peace by promoting understanding between the parties so as to primarily avoid possibilities of conflict. In this way, peace mediation addresses broader issues and promotes long-term peace as a foundation for establishing rule of law. I am conscious that this conference is not the culmination of our efforts, but rather the beginning of a much larger journey. We have reached an important milestone, but this is merely the tipping point. The real work begins now. Before I conclude, I wish to express my deepest gratitude to each one of you for gracing this occasion with your presence. Your willingness to share your knowledge, experience, and expertise will enrich these proceedings immeasurably. Your participation is a testament to our shared commitment in the strengthening of rule of law and advancing the cause of peaceful and effective conflict resolution. To all our distinguished guests from across India and around the Commonwealth, I extend a heartfelt welcome to the Pink City, Jaipur. I sincerely hope that your stay here is both professionally rewarding and personally memorable. On behalf of Government of Rajasthan, it is my privilege to extend our warmest hospitality to each of you. I wish you all a fruitful conference, stimulating deliberations, and a pleasant and memorable stay in Jaipur. Thank you, and I wish the conference every success. Jai Hind.
Thank you, sir. Thank you, sir, for your enlightening welcome address. It is now my distinct honor to invite an eminent jurist whose profound legal insights continue to enrich Rajasthan judiciary. May I respectfully request Honorable Dr. Justice Pushpendra Singh Bhati Judge, Rajasthan High Court and Chairman, Rajasthan High Court Legal Services Committee, Jodhpur, to share his thoughts with us. My Lord, your insights into the evolving landscape of mediation and access to justice are eagerly awaited.
My Lord, Honorable the Chief Justice of India, Justice Suryakant Sahab, who is not only having the captaincy of the Indian judiciary and Indian legal system, but also has won hearts and minds as an acclaimed man of stature internationally, as I have seen in last few months in company of national and international conferences, the respect that he commands all over the world. My Lords, Justice Vijay Vishnoi Sahab, our very own Rajasthan High Court judge, now adorning a feather in the cap of Rajasthan High Court, now in Honorable Supreme Court. My Lord, my brother Justice, Chief Justice Sanjeev Prakash Sharma Sahab, the Acting Chief Justice, who is guiding us through tremendous times of energy, revolutionizing the Rajasthan judiciary to the best of his capacity and in a very grand manner. The Deputy Chief Minister of the state, Bairwa Sahab, whose presence here will enhance the power of the day for the mediation. My friend, Advocate General Sahab, with whom I had an opportunity to work while I was representing the state, Rajendra Prasad Sahab, his subtle style of dominance is renowned in its own way, and he has created a lot of goodwill for the state on his own strong shoulders. Madam Neelkamani, she is a renowned lawyer and a panelist with me in the afternoon, this afternoon session. We have international community here, so welcome all. Justice Dilip Nawaz Sahab, Supreme Court Sri Lanka, Justice Vashisht, Bahamas, Justice Patel, Zambia, and my dear brothers, Justice Kosi from Telangana, my dear brothers, sisters, respected colleagues, district judges, DLSA members, judicial officers, lawyers, eminent lawyers from Supreme Court Bar Association members, and all the gracious and grand gathering which is here before me. It is a grand day for Rajasthan. I must assure my guru with whom I began my practice in 1992, that is Mr. Anweshwar Gupta, and also Santhana Sahab, both of them on behalf of Nivaran and Commonwealth Lawyers Association, that you have, sir, chosen a right place, because Rajasthan is not an ordinary territory. Not only in this big, majestic country, India, Rajasthan is a state which is bigger than 126 countries. So that is the kind of territory where you are launching this great program in a new dimension. And I must congratulate the organizers for this, including Rajasthan High Court. Now, bigger than 126 countries is one thing, even so much so that it is bigger than Britain, it is bigger than Japan, it is bigger than Poland. So that is the kind of state that we are sitting in, and that is where we are launching ourselves. So your presence here, as I saw in the morning headlines, everywhere the Chief Justice of India's statements and the other colleagues, whoever, respected colleagues who were on dais, it has been very grandly reported. And I understand that the cause of mediation, not only in India, not only in Commonwealth countries, but in Rajasthan will take deeper roots on this day. I also wish to share a small incident of mediation. While me and my friend Lakshman Munari Sahab were having a division bench, my Lords the Chief Justice, the point was that there was a couple of days we were working with them, and we happened to successfully mediate. The whole point was that at the end of the proceedings, this was a small child whose custody matter was at stake. So this child asked the courtmaster, "Can I meet the judges on the dais?" We have never met anyone on the dais while the adjudicating or going on proceedings. But the smile on the boy's face prompted me and Lakshman sir to ask the boy to come in. So he came with a paper flower and he thanked us for partly reuniting his father and partly giving him to his mother. And that smile I will ever remember in my life. I have recorded in my judicial order also that we permitted him to give this small paper flower gift, which reflects the power of mediation. I fairly remember that in 2012, Rajasthan, Vishnoi Saab and SP Sharma Saab and all my respected colleagues who are sitting here will remember, first time the mediation was introduced in a large way in Rajasthan. At Jodhpur, there were huge speeches, and we were the lawyers, and we protested to the best of our capacities that it would not be proper to have an alternative to litigation. It was not good to have things which would not be conducive to the then lawyers. So, but the time has gone ahead. Things have traveled. The society and the civilization has moved ahead. Then came the time when we were trained. Justice Neena Bansal came from now at Delhi High Court. She was trainer at that time. She came, and me and Justice Baljinder Sandhu and some of us, we got trained as trained mediators. And first time I realized that 40 hours training, that training of mediation had made me a better man, a better lawyer, and a better human being. And I realized that it was not a mediation training alone. I realized that it was in fact a personality development course that we were given opportunity by the High Court to go into. And that was the way we could do it. And that's the way it progressed. It slowly has come a long way. Mediation has come a long way. It has been legislated upon. It has been, now there is a wide prevalence of mediation. Last weekend, we had the opportunity to be nominated in a United Nations conference headed by our Honorable Chief Justice of India, where he addressed the international community by saying that this is not a mere mediation, but it is a process which is at the genesis of the constitutional values that we are having. And a large message was given to the international community by the Chief Justice of India in their presence. It was the 60th birthday of Uncitral. I quote what the Chief Justice of India said: mediation is not merely an alternative to adjudication, but a constitutional value in itself, one that reaffirms our collective faith in compassion, consensus, and the healing power of justice. Me, Justice Mukesh Rajpurohit, and Justice Goyal, along with our acting Chief Justice, also heard a short story from the Honorable Chief Justice of India on last Sunday. The story was about Shakyas and Kolias. Shakyas, and I'll share it, it is only a 30-second story. Shakyas and Kolias, as the Chief Justice of India told us the story, stories are easy to remember. They are two communities and tribes who were fighting over a Rohini river which was between their tribes. So the water got scarce, and as the scarcity grew, both the tribes started agitating, and while the agitation went on, the anger converted into a readiness for armed conflict. And that time Lord Buddha came in, and he said the scarcity in Rohini is nobody's job, it is nature's job. You have to live peacefully. And if you have to live peacefully, you have to mediate. And thus, with the mediation of Lord Buddha, a single question was asked: want to live without water, or you don't want to live at all? And that question resulted into both the tribes coming to a mediation table and sorting out the difference. The message of the story of the Honorable Chief Justice of India was: scarcity in Rohini river remained, tribes were same, everything remained there, nothing changed, but mediation changed everything. The armed conflict was averted, and both the tribes happily lived thereafter. While I was preparing for the afternoon session, it was regarding the workplace, my lords, and workplace, one only line I will say from that session this: I realized that the ILO and the UN bodies say that mediation not going well is something worth $10 trillion. So this whole program which was there also of the international community headed by our Chief Justice, was in fact a message to the international community that while trading and while demolishing the international borders for personal economies, for economies of each nation, we need to go in a large way for mediation, which is not only a tool of peace, but also a tool of rule of law. I also realize in my understanding as a student of law, that peace and mediation are going hand in hand. We see the worst warring things going on. US and Iran are regularly warring, regularly bombing, regularly missiling each other, but at the same time, both are talking. Both are some mediator is coming in between, and they are talking. The talks are also going on. Similarly, I realize that in Ukraine-Russia war also, similar things are happening. They are talking also and they are warring also. I realized the same thing in the Operation Sindoor. When we were anxious and stressful in Galwan, still our DGMOs were meeting with the China DGMOs. And therefore, mediation and talks and peace have to go hand in hand. I would also not hesitate to, because it's a very short time and I have to come to the last thing which I'll share is a small story, which is my favorite story. It was not a story, in fact, it is a two-line. It is from The Arms and the Man of the Bernard Shaw. There is a famous term, the chocolate cream soldier. Who was the chocolate? It was the Blunchley. Many of you would have read that book because it is widely acclaimed. And her and his heroine, the Raina, where midnight he came in and she said, "You are carrying bullets and guns entering my room." He said, "Check it." She checked it. And instead of bullets, there were chocolates. So she named him Chocolate Cream Soldier because even in war, you require chocolates. Even in the hardest times, we need harmony, we need chocolates, we need peace, that is the idea of rule of law. I thank you all for patiently hearing me. My regards to all the dignitaries who have come from outside to have made this Rajasthan state feel special by all of your presence and the message given to the whole community, internationally, nationally, and statewide, of the grandness and majesty that mediation enjoys. Thank you. Jai Hind.
Thank you, my Lord. We are deeply grateful for such an enriching perspective, one that reminds us that justice at its best is not merely delivered, but discovered together. Thank you once again.
Now, may I request Honorable Mr. Justice Sanjeev Prakash Sharma, the Acting Chief Justice of Rajasthan and Executive Chairman RSLSA, to share his views. May we have you, sir?
Our esteemed Chief Guest, Honorable Chief Justice of India, Mr. Justice Suryakant, Honorable Mr. Justice Vijay Vishnoi, Judge, Supreme Court of India, Honorable Mr. Justice EHM Dilip Nawaz, sitting off the dais, Judge, Supreme Court of Sri Lanka, Honorable Mr. Justice Vashisht Kokaram, Judge, Appeal Court of Bahamas, Honorable Ms. Justice Abhanaya Patel, Judge, Supreme Court of Zambia, Shri Premchand Bairwa ji, Honorable Deputy Chief Minister of Rajasthan, Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court, Honorable Judge, Justice Sam Koshi, Judge, High Court of Telangana, my esteemed brothers and sisters, judges of Rajasthan High Court, Shri Rajendra Prasad ji, Advocate General of Rajasthan, Shri Aruneshwar Gupta, Senior Advocate and Vice President Nivaran, Dr. Nandini Gori, Secretary Nivaran, distinguished judges from across the Commonwealth, my esteemed colleagues of the Rajasthan High Court, other representatives of the Commonwealth Lawyers Association, learned members of the Bar Association and Nivaran, eminent mediators, officers from the registry. It is my privilege to welcome you again to this deliberations today, the Commonwealth Peace Mediation Conference. We move from inspiration to engagement, from ideas to practical pathways that can transform lives, institutions, and societies. The theme of today's working session reflects a profound truth. Peace is not merely the absence of conflict. It is the presence of understanding, dignity, and trust. Mediation is the bridge that makes that possible. It's a matter of immense pride for us to inform this august gathering that Rajasthan has 181 mediation centers all across the judicial districts. Almost 2,500 mediators have been impaneled. These mediators have undergone 40-hour trainings under the aegis of the Honorable Mediation and Conciliation Project Committee, Supreme Court of India. It is also a pioneering step of the Rajasthan State Legal Services Authority that we have introduced a dedicated online mediation platform for mediation across all the mediation centers in Rajasthan. This is a self-designed and self-operable online platform for mediation being monitored by the State Legal Service Authority. Further, we are also grateful to the state of Rajasthan, as Rajasthan is among the few states that pay a high honorarium to mediators for successful mediation. Rajasthan is the first state where the Legal Services Authority has the privilege of inviting honorable former judges to a 40-hour mediation training program, which was attended by 30 retired High Court judges during the month of June 2026. In July 25, the state government had enhanced the honorarium to 7,000 rupees per case. We also pay an amount of rupees 3,000 for mediation in a case if it continues for 3 sittings at the mediation centers. Because of all the above administrative, financial and technical upgradations in Rajasthan, under the aegis of RSLSA, it performs immensely well as the mediation for the nation 1.0 and 2.0. Today, we will begin with a very significant session dedicated to healing the first institution, mediation for family harmony, dignity, and continuity. The very title of this session reminds us of timeless truth, that before we belong to a society, before we become citizens of a nation, we first belong to a family. It is within the family that values are nurtured, trust is cultivated, and the foundations of peaceful society are laid. The family is the first school of compassion, the first forum of dialogue, and the first institution where human relationships are shaped. When harmony prevails within families, societies flourish. When families fracture, the consequences extend far beyond the walls of home. They affect children, communities, workplaces, and ultimately the nation itself. Family disputes are unlike ordinary civil disputes. They cannot always be measured by legal rights alone. A judicial verdict may determine legal rights, but it cannot always restore trust or rebuild relationships. Mediation, however, creates the possibility of healing, where litigation often marks only an end. With regard to mediation, yesterday the learned Solicitor General of India was referring to Lord Krishna, who was one of the best mediators in the world. In the entire Mahabharata, he had been trying to mediate between Kauravas and Pandavas. In fact, in sermons of the Gita, he mentions of not getting agitated and not agitating others as the highest form of life. That is Shlok 12.16. The teachings of Gita can be used for mediation purpose also in our daily lives. The agitation works like game of passing the buck. For example, we gather agitation from the superior in the workplace and pass it on to some junior or to a family member at home. But as Lord Krishna says, neither to take agitation nor to give it. While awareness helps us to get ourselves free from agitation, our compassion helps us to ensure we do not agitate others, and that is why it is said that awareness and compassion are two oars of a boat in the journey of life. With this perspective, if we look at the family, we find that the mediation at the family source is the first is by the mother. When two children fight, then it is the mother who acts as a mediator and mediates between them. If it is not solved, then the second mediator is the father. The mediation between the mother and the children also is mediated by the parent, father, elder one. So from there, if we have learned how to mediate, and especially in our Indian civilization, I think we must take it further, and that too to solve the legal problems. I may tell you that at that time I was appearing in the Supreme Court as a lawyer. One case came up from Rajasthan. It was one of my friend's case. His father had two younger brothers. So there was a shop for which they had been fighting for getting it evicted from the tenant. And the elder brother had filed a suit for getting it evicted, and ultimately he won. Then he moved for execution, and ultimately in execution, what the tenant did is that he locked the shop and gave the keys to the youngest brother. Now the result was that who would get the property and who would take the possession. All three of them moved an application before the High Court. And in the High Court, the honorable judges said that, all right, you get it decided from a civil court. Until then, all three of you may put a lock on this shop. Now this became a big problem, so I took it to the Supreme Court. I remember that time Honorable Chief Justice of India, Shri R.M. Lodha, was heading the bench, and he immediately asked me, is mediation not there in Rajasthan? When I said, yes, sir, there is no mediation process being started in Rajasthan. He said, how come? We have already set up a mediation center at Delhi, so why it's not in Rajasthan? And that's how directions were issued in that case itself for starting mediation centers in Rajasthan, and the mediation process has started from there. And I'll tell you that that case was taken up in mediation. All the three brothers sorted out their problems, and all of them started living peacefully, and till date they are all living very happily. That is how mediation works. In Rajasthan, initiatives such as Sulha WhatsApp chat bot is a fine example of how Rajasthan High Court is embracing innovative and technology-driven approaches to make mediation more accessible and effective. In every family court, a separate mediation unit with specialized mediators in the field has been established by RSLSA, apart from ensuring the availability of counselors appointed for mediation in family matters. Have we ever tried to understand why family disputes are increasing so rapidly? There may be many reasons, but one important reason is that today materialism is replacing other divine values like truth, respect, tolerance, contentment. Nowadays, everything is measured in terms of money. Why do people not resign from their jobs after every disagreement or conflict at the workplace? Because they understand the value of what that job provides. Unfortunately, we often fail to recognize the immense value that a family brings to our lives. In the words of George Bernard Shaw, a happy family is but an earlier heaven. एक सुखी परिवार स्वर्ग का पूर्वाभास मात्र है. At the workplace, even if someone is senior to us by just a day, we acknowledge that seniority and extend due respect. Yet, when we come home, we sometimes forget the value of experience, age, and mutual regard. If we could bring the same culture of respect and adjustment that we practice at our workplace, perhaps many families could be saved from breaking apart. Children are often the silent sufferers of prolonged family disputes. When parents resolve their differences through mediation, they are not merely settling a legal dispute, they are safeguarding a child's future, emotional security, and faith in relationships. There can be no greater service to justice than protecting the interest of the next generation. The discussions today will also remind us that mediation is not confined to homes. Its principles are equally relevant in criminal justice, also as an instrument of restorative justice where the law permits, particularly in disputes that are essentially personal in nature. In the sphere of commerce, mediation strengthens business confidence by offering certainty, preserving commercial relationship, and supporting cross-border trade. In an increasingly digital economy where transactions travel faster than legal systems, mediation provides a flexible and future-ready mechanism for dispute resolution. Our workplace sessions will explore how mediation nurtures respectful professional environments, strengthens institutional trust, and resolves employment conflicts while preserving human dignity. Healthy workplaces, like healthy families, are founded upon communication, empathy, and mutual respect. Similarly, in infrastructure and public projects, mediation can become a powerful instrument for nation building. Timely resolution of disputes ensures that roads, hospitals, schools, and public infrastructure are completed without prolonged litigation, ultimately serving the larger public interest. In fact, at the last conference which we had in Delhi, it was also mooted that before even going for arbitration, the matter should be sent for mediation. And I have started that in Rajasthan, and I have sent several cases where applications have been moved for under Section 11 to first get them sorted out through mediation, and then we will appoint an arbitrator later on. So we are trying to do that something, and we'll have much more discussion coming forward. Thank you very much.
Thank you, my Lord, for such an insightful and thought-provoking words. Your words have reminded us that mediation is not merely an alternative dispute resolution mechanism, but a pathway to lasting peace, social harmony, and meaningful access to justice. Now, it's my privilege to invite Dr. Prem Chand Bairwa, Honorable Deputy Chief Minister, Government of Rajasthan, to address this august gathering. Sir, please.
भारत माता की। कॉमनवेल्थ पीस मेडिटेशन कॉन्फ्रेंस इसकी नॉट सेशन में मंच पर विराजमान भारत के माननीय मुख्य न्यायाधीश न्यायमूर्ति श्री सूर्यकांत जी, हमारे राजस्थान उच्च न्यायालय के कार्यवाहक मुख्य न्यायाधीश माननीय न्यायमूर्ति श्री संजीव प्रकाश शर्मा जी, भारत एवं राष्ट्रमंडल देशों से पधारे माननीय सर्वोच्च एवं उच्च न्यायालय के न्यायाधीशगण, विभिन्न देशों के प्रतिष्ठित न्यायविद, संवैधानिक पदाधिकारी, विधि विशेषज्ञ, विद्वान अधिवक्तागण, कॉमनवेल्थ लॉयर्स एसोसिएशन तथा अन्य अंतर्राष्ट्रीय संस्थाओं के सम्मानित प्रतिनिधिगण, देवियों एवं सज्जनों, आप सभी का इस राजस्थान की पावन एवं ऐतिहासिक धरती पर मैं हृदय से आपका स्वागत करता हूं, अभिनंदन करता हूं। पधारो हमारे देश की समृद्ध परंपरा का निर्वहन करते हुए हमें अत्यंत हर्ष और गर्व है कि विश्व के विभिन्न देशों से पधारे विशिष्ट प्रतिनिधिगण की गरिमामय उपस्थिति में आयोजित ये राष्ट्रमंडल शांति मध्यस्थता सम्मेलन 2026 जयपुर की वैश्विक न्यायिक संवाद और सहयोग के एक महत्वपूर्ण केंद्र के रूप में स्थापित कर रहा है। आप सभी का हमारी इस गुलाबी नगरी में हार्दिक स्वागत एवं अभिनंदन। आज जब पूरा विश्व विभिन्न तनावों, संघर्षों और न्यायिक जटिलताओं के दौर से गुजर रहा है, तब पीस मेडिटेशन एंड रूल ऑफ लॉ जैसे विषय पर विश्व भर के न्यायाधीशों की नीति निर्माताओं, विधि विशेषज्ञों और मध्यस्थता के अग्रणी विद्वानों का एक मंच पर एकत्रित होना अत्यंत सार्थक और ऐतिहासिक है। ये सम्मेलन केवल विचार विमर्श का अवसर नहीं, बल्कि ये वैश्विक शांति, न्याय एवं सहयोग के लिए साझा संकल्प का प्रतीक है। भारत की चेतना सदैव वासुदेव कुटुंबकम के आदर्शों के से अनुप्रमाणित रही है। हमारा राजस्थान में भी सदियों से संवाद, सहमति और मध्यस्थता के मध्यंतर विवादों को समाधान की समृद्धि परंपरा रही है। यही कारण है कि यह सम्मेलन हमारी संस्कृति, विरासत और आधुनिक न्याय व्यवस्था के मध्य एक सशक्त सेतु का कार्य करेगा। यह हमारे लिए अत्यंत गर्व का विषय है कि आज देश की न्याय प्रणाली को माननीय मुख्य न्यायाधीश न्यायमूर्ति श्री सूर्यकांत जी की दूरदर्शी एवं प्रेरक नेतृत्व प्राप्त है। मध्यस्थता त्वरित न्याय तथा संवैधानिक मूल्यों के प्रति आपकी प्रतिबद्धता के लिए भारतीय न्याय व्यवस्था को एक नई दिशा प्रदान की है। मुझे ये बताते हुए भी प्रसन्नता है कि राजस्थान उच्च न्यायालय के कार्यवाहक मुख्य न्यायाधीश माननीय न्यायमूर्ति संजीव प्रकाश शर्मा जी के नेतृत्व में राजस्थान न्यायिक नवाचार, मध्यस्थता और विधिक सेवा के क्षेत्र में निरंतर नए आयाम स्थापित कर रहा है। इसके साथ ही मैं राजस्थान राज्य विधिक सेवा प्राधिकरण के उल्लेखनीय योगदान की भी विशेष सराहना करता हूं। लोक अदालतें, निःशुल्क विधिक सहायता तथा मध्यस्थता के माध्यम से RSLSA ने लाखों लोगों की त्वरित, सुलभ एवं सौहार्दपूर्ण न्याय व्यवस्था उपलब्ध कराया। यह इस तथ्य का जीवंत उदाहरण है कि मध्यस्थता न्याय को केवल शीघ्र ही नहीं बल्कि अधिक मानवीय और स्थायी भी बनाती है। मैं विशेष रूप से उन सभी विदेशी न्यायाधीशों, संवैधानिक पदाधिकारियों, विधि विशेषज्ञों, शिक्षाविदों तथा अंतर्राष्ट्रीय संगठनों के प्रतिनिधियों का अभिनंदन करता हूं, जिन्होंने विभिन्न देशों से यहां उपस्थित होकर अपने अनुभव, ज्ञान और सर्वोत्तम प्राप्तताओं को साझा करने में सहमति दी है। आपकी सहभागिता इस सम्मेलन में वास्तविक अर्थों में वैश्विक स्वरूप प्रदान करती है तथा विभिन्न न्यायिक प्रणालियों के मध्य सहयोग, विश्वास और परस्पर सीखने की भावना भी सुदृढ़ करती है। संयुक्त राष्ट्र के सतत विकास लक्ष्य, शांति, न्याय और सुदृढ़ संस्थाओं के प्रति हमारी राज्य सरकार पूर्णतः प्रतिबद्ध है। हमारा विश्वास है कि न्याय केवल न्यायालयों के निर्णयों तक ही सीमित नहीं होना चाहिए, बल्कि उसमें संवाद, करुणा, सहमति और सामाजिक स्वार्थी भी समावेश होना चाहिए। मुझे पूर्ण विश्वास है कि सम्मेलन के विचार विमर्श, अनुभवों के आदान प्रदान और विभिन्न देशों की सहभागिता से तैयार होने वाला ऐतिहासिक जयपुर डिक्लेरेशन ऑफ पीस मेडिएशन राष्ट्रमंडल देशों से ही नहीं बल्कि वैश्विक समुदाय के लिए भी शांति, न्याय और प्रभावी मध्यस्थता के क्षेत्र में एक महत्वपूर्ण मार्गदर्शक दस्तावेज सिद्ध होगा। अंत में मुझे सभी से आग्रह है कि इस गंभीर वैचारिक विमर्श के साथ साथ जयपुर एवं राजस्थान की समृद्ध सांस्कृतिक विरासत, ऐतिहासिक स्थापत्य, लोक कला तथा हमारी आत्मीय तिथिक देवोभव की परंपरा का आनंद अवश्य लें। मैं कॉमनवेल्थ लॉयर्स एसोसिएशन, निवारण सुप्रीम कोर्ट बार एसोसिएशन, राजस्थान की न्यायपालिका, राजस्थान राज्य विधिक सेवा के प्राधिकरण तथा इस सम्मेलन को सफल आयोजन से जुड़े सभी सहयोगियों को हार्दिक अभिनंदन और स्वागत, धन्यवाद। मंच पर विराजमान श्री जस्टिस विजय विश्नोई जी, संजीव प्रकाश शर्मा जी और जस्टिस पुष्पेंद्र जी भाटी जी और राजेंद्र प्रसाद जनरल एडवोकेट जी और नंदिनी जी, आपका भी बहुत बहुत अभिनंदन, बहुत बहुत स्वागत, धन्यवाद। जय हिंद।
बहुत धन्यवाद सर। हम बड़े आनंदित हुए जब आपने राजस्थान के हमारे जो स्वागत करने की परंपरा है, पधारो हमारे देश का आपने जिक्र किया। आपके विचारों से हम बहुत अनुग्रहित हैं। नाउ मे आई रिक्वेस्ट ऑनरेबल मिस्टर जस्टिस विजय विश्नोई, जज सुप्रीम कोर्ट ऑफ इंडिया, for his special address. May we have you, sir?
Honorable Justice Suryakant ji, Chief Justice of India, Dr. Premchand Bairwa, Deputy Chief Minister of Rajasthan, Honorable Justice Sanjeev Prakash Sharma, Acting Chief Justice, Rajasthan High Court, Honorable Justice Dr. Pushpendra Singh Bhati, Chairman Rajasthan High Court Legal Services Committee, Jodhpur, my sister and brother judges from Rajasthan High Court, Shri Rajendra Prasad ji, Advocate General, Rajasthan, Dr. Nandini Gore, Secretary Nivaran, distinguished guests coming from the Commonwealth countries, ladies and gentlemen, and the fellow advocates. It is my profound privilege to stand before you and address this gathering, and I am particularly honored to have that we have gathered here in Jaipur, a city that embodies India's rich tradition and dialogue and consensus to deliberate on a theme that is very close to the heart of our justice system: peace, mediation, and the rule of law. At the outset, I would like to mention the contribution of the organizers of this conference, Rajasthan Legal Services Authority, under the aegis of High Court of Rajasthan, in collaboration with Commonwealth Lawyers Association, the Supreme Court Bar Association, and Nivaran, for their commendable work in bringing together professionals from the different countries under one roof for this Peace Mediation Conference. All these conferences, regional hubs, and countless professional exchanges help us in reinforce the idea that knowledge should flow beyond the borders. I am also pleased to welcome Honorable the Chief Justice of India, Honorable Justice Suryakant. Coming from the grassroots level and having been plight of litigants in their early days while practicing as an advocate, Honorable Chief Justice of India has pleased consensual dispute resolution at the center of judicial reform, envisioning a forum where mediation and arbitration are the first instincts, not the last resort, thereby offering dignity and speed to the litigants. While performing the idea of Swadeshi jurisprudence, Honorable Chief Justice of India has advocated that India's legal system and the constitutional texts are rooted firmly in the Indian philosophies, culture, and tradition. Similarly, mediation is also not an entirely foreign maneuver for us. Long before the mediation took its current form in India, we had panchayats, which though have largely been formalized now, alongside kullas, which family or clan councils had, and pugas and shrenis were associations of merchants or communities for amicable resolution of the disputes. Now I am telling you a reality that I belong to the rural India, and still in the villages, if there is any dispute arises between the relatives, neighbors, or between the two villagers, the attempt of all the seniors and the villagers is always to first sit together and settle your disputes. It is inborn in our Indian culture that every dispute is first attempt should be to decide it through the conciliation, mediation, and or whatever with the intervention of the others to settle it peacefully. Now, apart from the feasibility of the mediation, there is one aspect that lingers around, which is what we largely perceive dispute resolution as an adjudication of rights and liabilities driven by rule of law. For long, we have equated the rule of law with the adjudicative process, where judges publicly declare what the law is, who has what rights, and how these rights must be vindicated. Nonetheless, the rule of law has now evolved significantly, and access to justice is now recognized as one of its most important tenets. Our constitutional principles embodies access to justice as one of the fundamental bedrocks protecting the rights of the masses. And when we speak of disputes and justice system, we must begin by acknowledging that the human reality behind it. We need to understand the pain of litigation, who waits for justice. Indeed, we have often heard that delayed justice is meaningless, but this is not merely a statement to be quoted. Rather, it's a cry from our soul of every common citizen who knocks on the door of our courts hoping for a resolution. This is precisely where mediation comes into picture, because while litigation always creates a win-lose situation, mediation always ends in win-win situation. But here comes the main question: how do you take an unwilling horse to the pond and make it to drink water? The answer to this is that once you take a horse to the pond through mediation, it might not drink water, but it will at least take a step further and reach till the pond. This happens because of mediation. Both parties craft their own solution, which means that no one feels defeated, the dispute is resolved, and more importantly, relationships are preserved. This is not just a legal process, it is deeply human one. And in contrast, if we see a court battle, even the victor often walks away with bitterness, having won the case but lost the peace. After all, what is the point in having rights if you cannot enforce them? And what is the value of law if you cannot afford to approach the court? The inability to access justice does not harm one individual, rather it erodes public confidence, makes people cynical, and reduces the rule of law to little more than a theoretical construct. This is where the promise of mediation comes into play, not as a replacement for the courts, but as a companion and bridge ensuring the justice is not a distant dream, but a lived reality for every common citizen. We see this comprehensive agenda spanning across various panels in this conference, ranging from family and community, dispute to commercial conflicts, workplace, harmony, environmental justice, and international peace building. And these themes demonstrate that mediation is not an alternative, but a universal tool. It is the engine that powers consensus, the bridge that restores trust, and the foundation of sustainable solutions. And it ensures that rule of law moves from a theoretical concept to a lived reality, because it empowers communities at the grassroots, foster harmony in workplaces, and resolve complex commercial disputes with efficiency and confidentiality. This conference, in particular, significant as it aims to culminate in adoption of the Jaipur Declaration on Peace Mediation 2026, and this declaration will be a testament of our collective commitment to mainstream mediation as an essential pillar of justice and international cooperation. It builds on a rich tradition of peaceful resolution present in cultures and civilization worldwide, emphasizing resort, consensus building, and retroactive justice. And as we move forward, we must see peace mediation not as a concession, but as a cornerstone of effective governance and rule of law. It is how we build peace, strengthen our institution, and ensure that justice is accessible to all. So let our work here in Jaipur to be a powerful catalyst for a future where dialogue prevails over conflict and where rule of law is upheld through the collaborative spirit of mediation. Thank you. Jai Hind.
Thank you very much, sir. You brought out the fact that Indian villages have conventional wisdom, which in fact was also quoted by Walter Isaacson in the biography of Steve Jobs. When he was asked at what different he found when he visited India, he said that while Western countries might have their logics, Indian villages especially, he said that they had conventional wisdom and which was far, far above the Western logic. Thank you very much, sir.
Ladies and gentlemen, we now arrive at the moment this entire gathering has been eagerly awaiting. It's our profound honor and privilege to welcome our distinguished guardian of justice, whose wisdom and unwavering commitment to the rule of law continue to inspire the nation. May I respectfully invite Honorable Mr. Justice Suryakant, the Chief Justice of India, to kindly grace all of us with Lordship's keynote address.
Thank you. My esteemed colleague, Justice Vijay Bishnoi, Judge Supreme Court of India, Dr. Premchand Berwaji, Honorable Deputy Chief Minister, Rajasthan, Justice Sanjeev Prakash Sharma, Acting Chief Justice, Rajasthan High Court and Executive Chairperson of the Rajasthan State Legal Service Authority. We have three distinguished judges, senior judges from Commonwealth jurisdictions, Justice Abha Nair Patel, Judge Supreme Court of Zambia, Justice Dilip Nawaz, Judge Supreme Court of Sri Lanka, and Justice Vishist Kokaram, Judge Court of Appeal from Bahamas. Justice Pushpinder Singh Bhati, Senior Judge, Rajasthan High Court and Chairman of the Rajasthan State Legal Service Authority. Very distinguished judges of the Rajasthan High Court, senior judges from various other high courts who are also gracing this occasion, learned justices and judicial officers and legal officers from various jurisdictions, Commonwealth countries who are participating in this event, Sri Rajendra Prasad, Learned Advocate General Rajasthan, Dr. Nandini Gore, General Secretary of Nivaran, Registrar General and other officers of the Rajasthan High Court, Member Secretary and other officers of the State Legal Service Authority, very distinguished senior advocates from the Supreme Court Bar and from the Rajasthan High Court Bar, members of the legal fraternity, learned mediators, distinguished delegates, friends from media, my dear students, ladies and gentlemen. Very good morning to all of you. Speaking on a subject which is very close to my own convictions and that I hold to be the very future of dispute resolution not only in India but beyond its shores is extremely satisfying. It's a privilege to expound upon it before an assembly which is so adept at the craft of drawing estranged parties back to a common table. I have had the honor of delivering innumerable addresses upon mediation, its many facets, its advantages, and the case for embracing it with a greater conviction. Yet, I confess with no small candor that I never truly tire of the subject. If anything, it re-energizes me every time, and gatherings such as this one stand as a testament to that, is mediation only. Mediation remains a discipline deserving of far deeper study, one that discovers almost daily fresh and more compelling avenues of application. All of you have heard many a times that old story of the orange quarrel between two sisters. The fact was that one wanted only peel, the other was keen in the juice, but the mother didn't know, and in her anxiety to buy peace for both of them, she cut the orange into two pieces, thinking that both will be happy. But that decision led to unhappiness and dissatisfaction among both the sisters. Because both sisters had quarreled over the whole orange, when each in truth had desired an entirely different half of it. Had anyone paused to ask why each daughter wanted the orange, rather than merely how much of it she wished to claim, the mother could have given each daughter the whole of what she truly needed, and there would have been nothing left to divide, left alone to quarrel over. I return to this story so often because it captures in a single image what several volumes of negotiation theory labor across chapters to argue. And what it says, that disputes are so frequently waged over positions, over the visible shape of the orange, when the truer and more abiding settlement lies concealed in the interest beneath, in the reasons the fruit mattered in the first place. So, my dear friends, this metaphor very clearly explains the distinction that I wish to draw. It is that litigation is built to adjudicate positions. It asks who owns the orange and answer with a verdict, a half each, maybe an injunction or a decree. Mediation, on the other hand, poses an altogether different question. It asks what each party truly needs. And time and again it discovers that what happened an irreconcilable conflict was never one of substance at all, but merely one of assumption. This parable carries no ancient pedigree, and I make no claim that it does. Yet it points to something far older than itself. The instinct to ask why a claim is made rather than resting content with the claim alone. That very instinct, I will show, runs deep through our own civilization's approach to resolving disputes. Yesterday, in the inaugural session, it was very aptly highlighted that mediation is something in the veins and in the history of India. If you remember India, then you start remembering the Ramayana, the Mahabharata, and the our historical stories. And every story tells a new dimension of mediation that I need not to repeat. It was very well thoughtfully referred yesterday in the inaugural address. But let me tell you, out of this very history, a brief reference to Kautilya's Arthashastra. That was, of course, centuries later. Kautilya prescribes 4 modes of governance and rule of law. And in Hindi, he calls them Dam, Dand, Bhed. 3 he prescribes. 4th is the ultimate verdict of the king. Dam, Dand and Bhed. So what is Dam? Dam is incentives or price. Sam, Dam, Dand and Bhed. 4. So the Sam is persuasion or conciliation. Dam was incentives or price. Dand was punishment or force. And Bhed was division or exploitation. That was the rule for the king, that divide and rule for the king. So when Arthashastra, Kautilya, one of the best philosophers I have ever read in the history, he talks of the first option he gives of Sam, persuasion or conciliation. So basically the principle of mediation is originating from that very philosophy which really ultimately led to the laying down of the codified principles of governance, and governance in which the rule of law plays a vital role. You go to another history after that, hundreds of years after Kautilya, then comes another philosophy, that hierarchy of adjudicating bodies, Kula, Shreni and Puga, and thereafter the king's own verdict. Again 4 principles, and the first principle again talks of sitting together, resolving your disputes among yourself. And post in the previous century, before and after independence, all of us have read about Rashtrapita Mahatma Gandhi reflecting upon his own years at the bar and ultimately confessing that the most satisfying experience as a lawyer was when he could mediate between the parties or could contribute in an amicable settlement between the parties. What we glean from this is that long before mediation, as rightly pointed out, acquired a statute in India in 2023 and maybe in other jurisdictions before that, mediation has been running into our veins and it's a part of our culture. Now, not only that it's a part of our culture, but fortunately, the legislature and the judiciary both have played a vital role in developing mediation as a part of our decision-making process in India. The Parliament added Section 89 in the Code of Civil Procedure, but mere addition could not really work well. And all of you know, those particularly practicing in India, that before the Supreme Court really interpreted that section in Salem Bar Association matter, which really give a breathe and enforcing power to this provision, it was like a dead provision before that. Then came AFCON infrastructure judgment, M.R. Krishnamurti judgment. The court ventured into and really brought the provision of mediation from one field to another. It started in pre-mediation in the Code of Civil Procedure. It was shifted to marital disputes, and then eventually through Krishnamurti, it was shifted to claim cases, motor accident claim cases. So this widening of the scope of mediation, introducing it in different branches of litigation, identifying the areas where it can work well, is something, a judicial innovation that with the passage of time the Indian Supreme Court has drawn. There is another judgment, some of you must have seen it, Motiram's case. The court fortified the very aspect of maintainability of confidentiality during mediation session. When mediation was widened and in different branches it was introduced, particularly in the commercial litigation, the confidentiality becomes a vital issue. And the businesses will be very reluctant to go before a mediator sharing their internal information unless you give a kind of a guarantee, assurance of confidentiality. And therefore, through a judicial dictum, the court introduced the principles of confidentiality as a mandatory part of mediation. I believe that each of these judgments was at its core a vindication of the rule of law rather than a departure from it. The rule of law does not demand that every grievance be adjudicated. It demands only that every citizen enjoy timely, accessible, and dignified recourse to justice. This judicial persistence has since found, of course, legislative and institutional expression. As I said, the Mediation Act eventually in 2023 has come for the first time with a comprehensive statutory architecture for voluntary, court-annexed, and community mediation alike. Alongside these developments, the Supreme Court, through its Mediation and Conciliation Project Committee, we have a separate dedicated committee on mediation and conciliation, and some of the senior advocates who are actively associated as members of that committee are also present here. That committee and the mediation centers that are now attached with all the high courts and the district courts and of course in Supreme Court itself. We have now been able to train a generation of mediators and steadily strengthened the physical and procedural infrastructure available to disputing parties. This endeavor, my dear friends, found still further expression in the Mediation for Nation, that campaign we started when I was Executive Chairperson of the National Legal Service Authority. We launched this project and movement in April 2025, and the effect was that by the end of the year, we were able to tackle and identify 110,000 cases which were referred to mediation, and out of which 78,000 cases were amicably settled. And this resolve, as Justice Sandeep Mehta yesterday pointed out, my brother Justice Sandeep Mehta is also a member of that committee which I have constituted. Now we are organizing this Samadhan Samaro in Supreme Court on 21st to 23rd of August this very month. And our purpose, we have not traditionally and conventionally, as we used to fix at a permanent Lok Adalat or national Lok Adalat. Instead of that, we have really widened the scope and we have given a very expensive nomenclature to the event as Samadhan Samaro. So it's not that we are confining to one mechanism. We are going to adopt all kind of possible tools for the amicable settlement of disputes. That will include a permanent lok adalat, that will include the mediation, that will include the conciliation, and that might include a kind of the oldest and conventional method of panchayats between the families. So all these mechanisms are going to be used for the purpose of making it a successful story, and the way the committee has worked so hard with the active support of the Supreme Court Bar Association and Supreme Court Advocates on Record Association, I am absolutely confident that this Samadhan Samaro will have outstanding disposal of cases through the conciliation process. Mediation, my dear friends, in India, for a long associated chiefly with matrimonial reconciliation, but with the passage of time, mediation has, as I said, expanded its scope. Now, the multiple corporations are having separate mediation cells. Insurance companies have also set up their own mediation panels. We have been able to persuade even the banks and the non-financial institutions, non-banking institutions, also to set up their own mediation cells to resolve the disputes which are absolutely commercial in nature. And with the passage of time and with the structural mediation formation at different levels, I can say that we are not confined to the court yards only where to resolve the family disputes. Rather, we have been able to now break the boardrooms, and the transition has been a natural one for the underlying wisdom that preserving our relationship often serves interest better than simply vindicating our position. These principles we apply with equal force whether the relationship between spouses or between shareholders. So this is how mediation has now traveled a long journey from family disputes to the commercial disputes and of high-end commercial disputes. The frontier need not end here. Infrastructure and construction contracts, notoriously prone to litigation over cost overruns and delay, claims that can freeze a project for years, stand to gain considerably from dispute resolution boards and mediation clauses built into the contracts from its very inception. A complete shift is now taking place. Initially, every agreement, bilateral agreement, tripartite agreement, all any kind of agreements will have a clause of arbitration. That used to be the conventionally the clause will be added. Nowadays, that shift is there. Now there is a clause of mediation. So it's all, particularly in India, the infrastructure development that is taking place in terms of the large-scale, massive constructions of highways, roads, projects, power plants, the buildings, commercial places. In there, this kind of disputes are very common, and for that now mediation is being opted as a very effective modicum of dispute resolution. All of you are aware of the benefits of mediation. I can only sum up in 2 lines by saying that durability of human relationship plus resolving a dispute in a language of your own choice with cost proportionate to the dispute instead of an overburdened docket, the timely resolution, a lasting relationship are wonderful benefits of the mediation. I am quite sure that this conference where you are going, as I explained yesterday, variety of subjects on which you will deliberate with respect to the attracting mediation as the most preferred. That's why I don't use the word as alternative dispute resolution. Way back I said that instead of it should always be treated as the most preferred modicum of adjudication. And I am quite sure that through these deliberations, you will be able to carve out a new path, a very innovative ideas, how to implement mediation into those areas where still people feel reluctant, and maybe that since you are picking up even the criminal jurisprudence also with reference to the principles of mediation, I am quite confident that that is an area where through judicial interference, we have been able to laying down principles and a jurisprudence that is now well established in India, that based upon the settlement between the parties, some of the criminal cases which are not heinous in nature and which are the offensive which you don't treat them to be against the society, those matters we have amicably closed, whether the High Court exercising its inherent powers or the Supreme Court exercising its powers under Article 142 or other inherent powers. But I am quite sure that in such type of petty offences where the initial or the genesis of the dispute lies in a civil matter and that results into sometimes criminal proceedings between the parties or criminal cases between the parties, I am absolutely confident that even those matters can be amicably resolved under the aegis of mediation, and such kind of pathways you will be able to find out, resolve and lay down in this conference. My all the best wishes once again for the success of this conference. Thank you very much. Jai Hind, Jai Bharat.
क्षणम अपि सज्जन संगति रेखा भवती भव अर्णव तरणे नौका, अर्थात सज्जन और ज्ञानी लोगों का कुछ क्षणों का साथ ही हमारे लिए बहुत कल्याणकारी सिद्ध हो सकता है. Thank you, my Lord, for your enlightening address and invaluable guidance. We sincerely appreciate the time you have graciously shared with us. I'm certain that profound insights you have shared today will leave a lasting impression and serve as a guiding light for all of us. Thank you once again.
We now move on to the souvenir presentation to our dignitaries on the dais. So first of all, may I request Honorable Mr. Justice Praveer Bhatnagar, Judge, Rajasthan High Court, to please come on the dais and felicitate Honorable Mr. Justice Suryakant, Chief Justice of India. Thank you very much, sir. May I now request Mr. Justice Ashutosh Kumar, Judge, Rajasthan High Court, to please come and felicitate Honorable Mr. Justice Vijay Vishnoi, Judge, Supreme Court of India. Thank you very much, sir. May I now request Honorable Mr. Justice Chandrasekhar Sharma, Judge, Rajasthan High Court, to please come and felicitate Honorable Deputy Chief Minister Dr. Prem Chand Bhairava. Thank you very much, sirs. May I now request Mr. Justice Pramil Kumar Mathur, Judge, Rajasthan High Court, to please come on the stage and felicitate Honorable Mr. Justice Sanjeev Prakash Sharma, sir, the Acting Chief Justice of Rajasthan High Court and Executive Chairman, RSLSA. Thank you, Honorables. Thanks to both of you. May I request Honorable Mr. Justice Chandra Prakash Shrimali, Judge, Rajasthan High Court, to please come and felicitate Honorable Dr. Justice Pushpen Singh Bhati, Judge, Rajasthan High Court. Thank you, Honorables. I request Sri Chanchal Mishra, Registrar, Rajasthan High Court, to come on stage and felicitate Rajendra Prasad, Advocate General, Rajasthan. Thank you very much, sirs. Last, I request Sri Ramesh Chand Joshi, Director, Rajasthan State Legal Services Authority, to please come on stage and felicitate Dr. Nandini Gore. Thank you very much.
Every memorable gathering concludes with gratitude. It's my privilege to invite Dr. Nandini Gore, General Secretary, Nivaran, to propose vote of thanks.
I hope you can see me. Honorable the Chief Justice of India, Justice Suryakant, Honorable Mr. Justice Vijay Bishnoi, Judge, Supreme Court of India, Honorable Justice Sanjeev Prakash Sharma, Acting Chief Justice, Rajasthan High Court, Honorable Deputy Chief Minister of Rajasthan, Sri Premchand Bairwal, Honorable Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court, Honorable Mr. Rajendra Prasad ji, Advocate General for the State of Rajasthan, Honorable Judges of Supreme Court from different continents of the world, Honorable Judges of the High Court from various High Courts of India, including Rajasthan High Court, Honorable District Judges, Honorable Judges from different continents of the world who are attending this function, Judicial Officers, Law Officers, Mr. Rakesh Kumar Khanna, Member MCPC, and also a part of Nivaran. All the lawyers, mediators, friends, volunteers, and media people, thank you very much for coming and attending this function. आप सबका पिंक सिटी जयपुर में बहुत बहुत स्वागत है. It is our privilege to welcome you all for this Peace Mediation Conference 2026. This conference is held under the aegis of Rajasthan State Legal Services Authority, RSLSA, Honorable Rajasthan High Court, Commonwealth Lawyers Association, Supreme Court Bar Association, and Nivaran. Thank you, RSLSA and Rajasthan State Legal Services Authority and Rajasthan High Court for giving us this privilege of enjoying this pink city. We are deeply proud that this global conversation on peace and mediation is taking place here in Jaipur. Jaipur is not only a city of magnificent structure and heritage, it is also a city built on the principles of planning, harmony, and peaceful coexistence. More than 300 years back, in 1727, Maharaja Savai Jai Singh Ji II, who was the real ruler of Amber, he wanted to change the structure of the city because there was a shortage of water and the city was very congested. So he deputed his chief architect, Mr. Vidyashankar Bhattacharya. He was his chief architect to build this city on the basis of Vastu Shastra and Shilp Shastra. So his vision at that time has culminated into this beautiful city. And this endeavor and vision makes Jaipur the perfect host for this distinguished gathering. We are proud that representatives from all the Commonwealth jurisdictions have come together with a shared commitment to promote mediation and signed the Jaipur Declaration, to build an architect of trust and to take mediation to our communities where it can strengthen relationships, resolve conflicts, and foster lasting peace. From the city of Jaipur, we will offer the world not just cherished memories, but a lasting roadmap for peace, dialogue, and justice. We are deeply honored and incredibly grateful to our Honorable Chief Justice of India, Justice Suryakant, who is with us, sir. Sir, your presence is a powerful testament to the changing paradigm of the Indian legal landscape. Thank you very much for your visionary keynote address, which beautifully captures your lifelong advocacy for institutionalizing the consensus and to see that less litigation is there in our country. Sir, you have frequently reminded us in your global addresses that mediation is no longer just an alternate to litigation. Instead, it has evolved into a robust, autonomous pillar of commercial and social justice. Your powerful perspective resonates deeply with us today, as you said that option for mediation is not a sign of weakness, but a hallmark of commercial sophistication, financial wisdom, and strategic mentality and maturity. Your call for a multi-door courthouse system and an architect of trust, core concept which beautifully blends arbitration, mediation, and digital dispute resolution with supervision, with a single purpose of building trust so that the parties believe in fair and timely resolution. Thank you, sir, for leading the nation from a culture of litigation to a culture of resolution. Your leadership is crucial in driving the structural shift and providing the court and mediation, which are not competitors but are friends. They are complementary systems that sustain one another. Your diverse insight turns this conference into a powerhouse of actionable ideas to help reduce judicial pendency across towns and streets. As the Honorable Chief Justice has many times observed, that the true beauty of mediation lies not merely in resolving disputes, but in transforming relationships and securing durable and lasting closure. Sir, on behalf of Nivaran, mediators of Supreme Court of India, it will be our endeavor to work relentlessly towards the cause of mediation under the able guardianship and leadership of our President, Mr. Santhan Krishnan. As we dive into the upcoming sessions on different divergent topics from environment to infrastructure, I urge all the participants to take advantage, learn from the master classes on mediation from the world's best experts and exponents. Let us embrace it as an art of peace building with patience, empathy, and open mind. Please immerse yourself in the legendary hospitality of Jaipur, guided by the timeless philosophy of Padharo Mare Desh. We hope that amidst the intense panel discussions, you will find time to experience the vibrant colors, some shopping, taste of the traditional cuisine like dal bati churma, ghevar, mawa, and Rajasthani mithai, and the scenic beauty of Jaipur. Thank you all once again. Let us collaborate, connect, and make this peace mediation conference a resounding success. Jai Hind, thank you.
Thank you, Dr. Gore, for so graciously acknowledging the presence and contribution of everyone who has made this conference a great success. As we conclude this keynote session, let us carry with us a renewed commitment, dialogue over discord, understanding over confrontation, and peace over conflict. May I request everyone present here to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you very much. We now, before proceeding to high tea, which I'll request everybody, the judges will proceed towards the dome area and the other dignitaries will have in the pre-conference hall. Yesterday we had some inconveniences to our esteemed dignitaries and judges. So once again I request to please the others to have in the pre-conference hall and while judges proceed towards the dome area. Thank you very much. And a last request to all the dignitaries and judges to please sign against their name on the Jaipur Declaration, which is just kept on the left-hand side. It is for the honorable judges of the Commonwealth countries and on the High Courts of India, the members of Registry, the members of CLAs and Nivaran. Thank you very much.
Mr. Gokul Narayan, Advocate Mediator, Ms. Shireen Khajuria, Senior Advocate, Ms. Priya Hingurani, Senior Advocate. It's my privilege to extend my heartfelt welcome to all of you. With the successful conclusion of the keynote session, we now begin the first technical deliberations of the Commonwealth Peace Mediation Conference. Our inaugural working session, Healing the First Institution, Mediation for Family Harmony, Dignity and Continuity, focuses on the institution from which every society draws its strength, the family. This session will explore the transformative role of mediation in resolving matrimonial, child custody, inheritance, and intergenerational disputes, reaffirming that the true success of justice lies not only in deciding disputes, but in preserving human relationships. We are privileged to have Honorable Mr. Justice Anurup Singhi, Judge, Rajasthan High Court, as the session chair, and Ms. Veena Rally, Mediator Samadhan, as the chair of this session. Before handing over the proceedings to the coordinator, we shall proceed with the ceremonial felicitation of our esteemed dignitaries on the dais. First of all, I would like to call Mrs. Geeta Chaudhary, Secretary DLSA, Kota, to felicitate Honorable Mr. Justice Anurup Singhi, Judge, Rajasthan High Court. Now, I would request Srimati Samiksha Gautam, Secretary DLSA, Savai Madhopur, to felicitate Ms. Veena Rally, Mediator Samadhan. आपको नाम समझ में नहीं आएगा. Now, I call upon the stage Srimati Komal Motiar, Secretary, AP and ADR, Rajasthan State Legal Services Authority, to felicitate Mr. Gokul Narayan, Advocate Mediator. Now, I would request Mr. Bharat Bhushan Pathak, Secretary DLSA, to felicitate Ms. Shireen Khajuria, Senior Advocate.
Good.
Now, I'll call upon the stage Shri Hanuman Sahai Jat, ADJ, Bandikoi, to felicitate Ms. Priya Hingurani, Senior Advocate.
मैं बोल देता हूँ.
Now, to conduct the proceedings, it's now my privilege to invite the coordinator of this session, Ms. Prabha Swami, Advocate and Mediator, to kindly take over the proceedings.
It's on.
I'll start again. Good afternoon, everyone. A very warm welcome to all our distinguished dignitaries, delegates, and participants to this first session of the Commonwealth Peace Mediation Conference 2026. This session is titled Healing the First Institution, Mediation for Family Harmony, Dignity, and Continuity. I am Prabha Swami, and I will be your coordinator for this session. I'm an advocate on record in the Supreme Court of India. I'm an empaneled mediator and a founder member and treasurer of Nivaran. I have great pleasure in introducing our distinguished sessions chair and speakers for this session. Our sessions chair is Honorable Mr. Justice Anurup Singhi, who is a sitting judge of the Rajasthan High Court. Justice Singhi is a chartered accountant and has also cleared the final examination of company secretary. He practiced law from 2001. During his years at the bar, he appeared before the Honorable Supreme Court of India, the Rajasthan High Court, and various courts and tribunals across Rajasthan. He actively undertook pro bono matters and appeared in several public interest litigations concerning issues of significant public importance, including prison conditions and the enforcement of the right to education. He has been associated with the adjudication of matrimonial and family disputes, welfare of children, with amicable resolutions being a guiding consideration. Our chair is Ms. Veena Ralli, who has over 4 decades of legal practice as an advocate in the High Court of Delhi. She is a highly accomplished mediator and a member of the Overseeing Committee of Samadhan, the Mediation and Conciliation Center of the Delhi High Court. She is a senior trainer with the with the Mediation and Conciliation Project Committee of the Supreme Court and has trained a large number of lawyers, judicial officers, and counselors. She has received several awards in recognition of her deep knowledge and vast experience. Ms. Shireen Khajuria is a senior advocate, a certified mediator, mediation trainer, and an arbitrator with over 35 years of legal experience. She served as a law officer with the United Nations Compensation Commission, Geneva. She is on the panel of arbitrators of the Indian Council of Arbitration. She regularly conducts lectures, writes, and conducts training programs. She is also founder trustee of Nivaran. Ms. Priya Hingorani is a senior advocate with over 3 decades of practice and has led numerous pro bono public interest litigations. She is a trained Supreme Court mediator. She has addressed national and international conferences on various social and legal issues, and several of her papers have been published. She has held several distinguished leadership positions in the Supreme Court Bar Association and is currently in many organizations. Mr. Gokul Narayan is a mediation exponent and legal educator. He is co-founder and director at Settlewise Now, where he leads the organization's mediation practice. He has led the conception of India's first competition dedicated entirely to mediation advocacy and has created and curated courses in this discipline. He is also CEO of the Asian School of Cyber Laws. I would now request Ms. Veena Ralli to kindly take the chair, introduce the topic, and lead us into this highly relevant session. Over to you, Ms. Ralli.
Prabha. Today's topic, and particularly this session, which was supposed to start in the morning, in the afternoon now, is on family, harmony, dignity, and continuity. We are part of the family first by our birth. Gradually, we become members of many more families, and one of the family where we are all together today is mediation family as well. You know, in our cultural ethos, the family is not merely a social unit. It is a sanctuary of shared values, identity, and generational continuity. Yet today, when family ties fracture over inheritance, matrimonial strain, or partition disputes, our default instinct drives us to adversarial system, where we all know that there is a profound and painful paradox. In a formal court battle, a legal victory always and almost rather always comes at the absolutely cost of the human relationship. When family conflict reaches a critical flashpoint, the first causality is on the communication. In the Indian legal landscape, during the prolonged battle, parties retreat behind legal counsel, translating personal emotional pain into strategic affidavits and hostile cross-examinations. The court environment inevitably forces the conflicting parties to publicly exaggerate faults and attack each other's integrity just to win over the other. In doing so, the dispute ceases to be about resolving grievance. Basically, it becomes an escalating war. The winner at times, we see, becomes a loser. This phrase we have heard many a times, but we as mediators have experienced it when parties talk to each other and they feel that they have started the conflict spiral to spread, and it has become difficult for them to come out of it. It is more like that everybody has spoken about Gita and Mahabharata and Ramayana. Even Abhimanyu's, if we look at the example of Abhimanyu, Abhimanyu knew how to go into the conflict spiral. He knew to go into that area, but was difficult for Abhimanyu to come out. That is sometimes we have seen parties saying in front of us, I want to get out of this conflict spiral. Help us to do that. What are the possibilities when two parties generally get married? Generally, when we talk about family, we limit it only to matrimonial. But I feel family is all type of relationships. Let us just talk about family in matrimonial relationships first. What happens when two people get married? They may slowly merge into one richer world. We see many such examples in our elders, in our ancestors. The second option may be, they may orbit near each other, maybe even for 40 years, without ever feeling the bond. Or they may get into head-on collision. We often deal with the last situation where there is a head-on collision, where the parties orbit near each other for a good number of years, and one of them ultimately says, enough, I can't bear it anymore. A couple having got married after a long span of courtship also gets shattered over trivial issues and spend good number of years in court fighting who is right, fighting over custody, while other child quietly grows up believing that living in this conflict is the only way of life. What that child will learn, we forget on that. We just make it a point to win through the child as well, while claiming the custody and rather treating them as possessions. Another situation where we have experienced an elderly parent wins a maintenance case, but loses the emotional support of the very children against whom the order has been passed. Two brothers who have been sharing everything during their childhood, all of a sudden becomes enemies when they talk about sharing of the properties, because maybe one thinks I need or I deserve more than the other one. But can we honestly say that their needs have been fulfilled if there is a judgment passed by the Honorable Court? The relationship is nowhere seen when the judgment is passed, because it is looking at the past, what has been done by whom, and it imposes responsibilities and liabilities. Only the process of mediation tells us what is right. I'll just say two lines in Hindi. यूं ही एक छोटी सी बात पर ताल्लुकात पुराने बिगड़ गए. यूं ही एक छोटी सी बात पर ताल्लुकात पुराने बिगड़ गए. मुद्दा ये था कि सही क्या है, पर हम सही कौन पर अटक गए. We as human beings, we see things from our perspective. This is right, and that's end of it. We do not want to see from the perspective of our other relatives and close by people whom we love from the bottom of our heart, and we forget what lies ahead. Sometimes we feel that I am very happy because I have seen my opponent suffering, but we have seen even those people suffering a lot, having sleepless nights, because the conflict does not bring peace. The conflict only brings disasters and endless worries for both the parties. Today I have with me my esteemed colleagues who are renowned mediators and have been doing a lot of work. Shireen, may I just ask you, The topic of the discussion of our session says, healing the first institution, the institution upon which every society rests. What have you to say how mediation works over litigation while building castles of families?
Thank you for your question, Veena ma'am. And thank you, Prabha, for your gracious introduction. I'm grateful to the organizers for giving me this opportunity to be a part of the discussion today. Families, as you mentioned, ma'am, are the first institutions that we inherit. And this is the institution on which societies across the Commonwealth rest. But families also have disputes. Unlike commercial disputes, however, family disputes do not end with a judgment. The family relationships continue. Parents, though separated by law, will continue to be parents to their children. Siblings continue to take care of their aged parents, and they are also connected through their bonds, and they are also connected through their parents, through their social history. So it is in these circumstances, in view of the continuing relationships that are there in families, that we need something which is different from the traditional litigation. We need something like restorative mediation, and contemporary mediation in fact follows this. So it is not just that the settlement is the end of the dispute, whether it is by court or by a mediator. We're looking at something beyond that. It is restoring relationships, giving the parties an opportunity to be heard, and also ensuring that there is a settlement which is by actual consent and not just because it is forced by somebody. Litigation asks who is legally right, but in mediation we ask who has been hurt, what is the hurt, and how can we resolve it. We change the focus from position to interests, from blaming to accountability, and instead of looking at short-term gains, we are looking at long-term solutions of working together. The advantage of mediation can be remembered through the 4 C's. One of them is control. It is voluntary, and we control the process and we control the final outcome of it. The second is cost-effective. Mediation is cost-effective, as we all know. It doesn't get prolonged like litigation or even arbitration. The third is creativity, because families can design their own solutions and their own plans for parenting. It also saves any confidential information which needn't be written down, unlike in judgments. The question, I would say, ma'am, is not really whether the mediation is always better than litigation, but how can we, as practitioners of mediation and litigation, use the best features of both to enable the families to build a better home. The courts are indispensable in cases of urgent protection, injunctions, enforcement, or where we need a precedent, also maybe where there is domestic violence. The ideal family justice system would allow movement between the 2 processes. In fact, across the Commonwealth, we have seen pre-litigation mediation. We've also seen where litigation has started but has been suspended by the courts so that mediated settlements can be arrived at. So when we move from one process to the other is where I would say the process is effective. I would just like to share a brief incident which happened recently. In fact, it was a case with which a lady came to me. She wanted a relinquishment deed signed. Her brothers had asked her for it. They wanted the family property to be relinquished in their favor. Her daughter, who was an advocate, had a bit of a concern. She was worried that the liabilities which the brothers may have incurred in the meanwhile might lead to litigation against her in future. I suggested what I thought was the best option, and I said, let's have an indemnity bond in addition to the relinquishment deed. But the brothers rejected it outright. They thought that she was just being greedy. I realized that it was actually a problem of perception, so we decided to call upon the brothers and their advocate and have a joint meeting. I just kind of changed and reframed the context. I mentioned to them that your sister actually loves you a lot. She's not interested in a penny. She is only concerned for her children that their future is not harmed because of any litigations that may happen because of some transactions that have happened between you. It did turn the tide. I wouldn't say that it settled the matter immediately. It took us many months of working, but it opened a gateway for communication. It was finally settled, but what I would say, what was important is not the final settlement, but the fact that the mother understood the daughter, that the daughter wasn't really wanting anything for herself specifically. The daughter understood her mother's love and affection of a lifetime for her brother, and the siblings communicated once again. So the restorative practice is not really about persuading a person to give up their legal rights or to give up fairness in return for a relationship. But both of them have to be harmonized, otherwise the conflicts would continue. I would like to just conclude by saying that I believe that mediation does not replace the legal rights or the courts or even the advocates. A lot of advocates worry about it, that mediation is going to replace them. No, we need all of it. It only complements them. It is a set of skills that just changes the way we handle the situation, whether as advocates or maybe even as judges. The future of family disputes, I would say, not just mediation, lies in integrating both the systems through early court referrals and appropriate sensitive court referrals, besides, of course, trained and skilled mediators. Thank you, ma'am.
Thank you, Shirin. In a formal court's battle, a legal victory always comes at the absolute cost of the human relationship. How do you feel mediation can help in preserving relationship, or at least it can stop further damage to the relationship? Priya, you have experienced this both as a counsel and as mediator. Do you feel the mediation should be the first step in all family disputes before parties approach court? Why?
Absolutely.
Or why not?
Thank you, Veena-ji, and a very good afternoon to everyone. I know we are sitting between the lunch and us. The session is there in between. So I'm going to give a very brief answer because I think in this room, everybody who's here is a trained mediator across jurisdictions, has had as much experience as we, the dais, have had. Maybe some have had more. But I know when I started mediation in 1998, we were trained in 1998, there were very few people who actually understood the concept of mediation, and it was the vision of our courts, of our honorable judges who actually started the concept of mediation, particularly in Delhi. Having said that, I think it's very important in family matters to have pre-litigation mediation. And it's important for us now to revisit the Family Court Act, to see how we can bring about the changes in that, to incorporate pre-litigation mediation as a mandatory clause. We don't have it, though it does envisage that we must have mediation, conciliation right in the beginning. But somehow, in the courts that we go every day, it just mechanically and automatically, they issue notice, they give a date, maybe send it for a counselor or to the counseling counselor attached to the family court. But actually, the concept is not very clear and it doesn't start. Mediation doesn't start at that stage. So it's very important for us to bring about some change in the Family Court Act, one. And number two, I think it's very important for us to create awareness about the concept of mediation. As has been said by the Honorable Chief Justice of India and the speakers yesterday and today, it's very important to go back to the panchayats, to go back to the far-flung villages and the districts to reinforce the concept of what you may call it panchayat, you may call it mediation, you may call it community mediation, and we need to emphasize more on that, and I think it should be our motto at the end of the conference to work to take it to the farthest district or the village of the country from the top to the bottom so that they can understand and then they participate. Unless they don't understand, because a lot of time when we do our opening statements in mediation, it takes some time to explain to the parties that why it is important, why they should feel comfortable, what about the confidentiality clause. So all these aspects come in the opening statements, which all of us are mandated to do. Some of us do it, some of us don't do it. But I think it's absolutely important to make the parties feel very comfortable right at the beginning about what they are in for. The other question, Veena ji, that you said, healing. Yes, of course. Mediation is the platform, the neutral platform, the platform where healing starts. Healing, and then peace, and then closure. I think these are the three fundamentals of mediation that we have in India or across the country. And across border, I have some states like the United Kingdoms, actually they send matters for arbitration. That they have the concept of arbitration in UK for family matters, which somehow I don't think would work in India, but I'm still trying to understand how it works, because again, arbitration is adversarial. It is not, sitting across with mutual. But matters in UK, rather than going for mediation, are really recommended for arbitration, particularly custody matters, particularly maintenance matters. So there are different concepts across the globe. I think we really need to understand and look at them. But as far as India is concerned, I think it's very important for us to look at pre-litigation mediation in the matrimonial matters. Thank you.
Thank you, Priya. I really agree with you, and one of the judgment, Justice Ranjana Desai of Supreme Court also said that even if the parties have been referred for counseling, the parties must give an opportunity to mediate, because the party autonomy the parties get in mediation does not work sometimes even in counseling. Thank you, Priya. Now I have Gokul with me, and I think Gokul will just tell us, whenever there is a conflict, the first casualty that happens is on the communication. He is a very good communicator, that's why I'm asking him this question. Sometimes it results into complete silence. And as you know, silence is not empty. It has sometimes oceans in it. What have you to say, and what do you do when one party adopts it as a strategy in negotiation even?
Thank you so much. Good afternoon, everyone. Before I start saying what I decided to say, first of all, I'm very overwhelmed with the members of this dais, because I had not expected to be seated with such luminaries, and I mean it in the most humble and genuine manner possible. But also the fact that coming to this conference, I've realized that just introducing myself as a mediator is not good enough anymore. I'm surrounded by litigators and court-annexed mediators, and I realize that I don't share anything in common with any of them. So the entire foray of private mediation happens to be structured so differently and so uniquely in India. We're not like UK, we're not like the US. We're trying to find our way into what private mediation should look like, and we are stumbling our way, but yet we get up and stride forward. But on that note, the question that Veena ma'am has asked is a very relevant question. I personally am a person who shudders at the thought of silence. I'd rather occupy with noise than wait for the silence to sort itself out. But in my experience, I've broadly divided the entire idea of silence into three basic categories. Number one, protective silence. This is where the parties are feeling overwhelmed with the experience that they have had, and therefore are protecting their interests and not speaking too much. The other is exhausted silence, where they've given up, thak gaye hain, haar gaye hain, hatash ho gaye hain, and therefore they're quiet. The last one, which becomes complicated, especially as a mediator, is strategic silence. देखते हैं बोल क्या रहे हैं, देखते हैं दूसरी साइड क्या बोल रही है. The problem is, very often dispute resolution in its collaborative sense is not understood by the parties, and I apologize before saying what I'm going to say next, is mis-explained by their advocates to them also. The fact that it's a confidential system, it's a confidential process, doesn't dawn upon them very easily. I've always said this, silence becomes a problem because people don't trust the process. When will people start trusting the process is when there is a give and take. अब सोच के देखिए उदाहरण के तौर पर अगर एक parties, husband and wife were in a car, mediators also in the car, और सारे झपटा मार रहे हैं steering wheel पे, गाड़ी आगे नहीं बढ़ेगी, accident ही होना है, ये तय है. It is necessary that we will end up into an accident if somebody does not relinquish control. So it becomes very important for us to understand that as important as it is for a mediator to gain the trust of the parties, it is for the parties to relinquish control of the dispute so that the mediator can guide them towards a solution. I therefore always precede the idea of silence to understand if we have been able to establish trust or not. If the silence prolongs, it in all probability is strategic, but my resolution should be that if it is based on exhaustion or protective silence, then I must gain the trust of the parties such that they are able to comfortably break that silence, trust in the process, and move ahead to allow the mediator to work towards a solution. I hope that makes sense.
Yes,
Thank you.
Thank you, Gokul. This is what I expected from you, because in your own way, you can just tell us how communication works in mediation, and basically you have to separate the person from the problem. Absolutely. Look at the problem and not the person. Thank you for your comments. Yes, Priya. In your field particularly, you are an expert in this field, both in mediation and as a counsel. Of course, you do many more type of other matters as well. In matrimonial relationship, we often find one party staying in India and one abroad. We call it cross-border disputes. How do you as counsel and mediator reinforce the benefits of mediation in such parties and ensure such mediated settlements are followed by all concerned parties, even in foreign jurisdictions?
Okay, so I think all of us are aware of the concept of mirror orders, and which is now becoming very, very prevalent. And especially after our Supreme Court judgments where the courts have really felt the importance of mirror orders. My experience has been that it is very difficult to explain to the parent who has the custody and the custody has been given to the other parent for either summer vacations or for relocating, to accept the fact that the child will come back to the parent who has the custody or not. So it's and you know, when you are doing these matters in court, it's a different way of explaining to them, because these matters don't come before the mediator or in mediation when it's a concept of taking mirror orders from courts. So very seldom that we get matters in mediation where there is a concept of mirror orders being echoed. It's only when we are in courts and we are litigating these matters that we are able to get this recorded in the order of handing over custody or visitation, that a mirror order from the other jurisdiction should be taken, which also takes a lot of time. So I must tell my friends here that in this last 2 years, I've had to do 3 matters where we needed to take mirror orders, and especially in the US and UK, we've had this experience that it would take about a month to get these mirror orders, and it's only then that the court in India would allow the child to travel. And of course the mirror orders come, of course there is some confidence in it, but I don't think particularly in mediation proceedings this is discussed or it is recorded in the mediation settlements. I have not come across, many of my colleagues ever mentioning that they are recording the concept of mirror orders in mediation proceedings. I think that's something we should look at and make people aware when we are in mediation, because when they talk of custody or visitation, when we make up the whole concept, a separate schedule of that, we don't advise them or encourage them to look at this aspect. So I think that's something where we need to work on. It is not very difficult to get mirror orders, but I find in India, vice versa. I just am doing a matter at the moment where we have to get mirror orders from 2 jurisdictions, Andhra Pradesh and Chhattisgarh. Now, for the first time, it is very difficult to explain to the family court judge in Andhra Pradesh, where I went, the concept of mirror order. So I think it's very important for the judicial academies also to kind of take these issues up when they do training for the family court judges or the PDJs who have the jurisdiction as to what is the concept of a mirror order and why they should not delay it. Because every time it is delayed, the parties get anxious about it. So this is an experience I've had in Andhra Pradesh, and took me 3 hearings to explain to the Honorable Court that this is permissible, this can be done, and you should not give long dates in this, give short dates so that it can be implemented. So these are the issues which I feel need to be looked at, addressed, and I'm sure we'll get the experiences from the audience when we do our question-answer sessions. Thank you.
Thank you, Priya, sharing particularly with this mirror order, because this question we have faced many a times. When settlement will take place, it will go back to court. The settlement merges into the court order. How do we make it binding beyond the jurisdiction of our own country? So thanks for sharing your thoughts on this. Gokul, I would like you to throw some lights on this. In matrimonial dispute, the worst affected are the children. Please help us understand, how do you handle custody battles where one parent successfully alienates the other parent from the children, and getting custody becomes an ego, then paramount consideration like welfare of the children? What role can a counselor play in such situations?
Thank you for the question, ma'am. The experience that all of you as mediators may have had in the context of child custody matters and divorce in court-annexed mediations could be very different. I have been at the receiving end of a court-annexed mediation when I was going through my divorce, having had a child at that point of time. And to say the very least, my experience wasn't very pleasant. That led me to understand a few things about child custody matters. They are exceptionally, in my view, complicated. As a mediator, what I am forced to check during child custody matters is whether the parties who are coming in for the mediation are doing lip service to the idea that the child is their top priority. Very often, I come across situations where parents say that they have the best interest of the child at heart and the child is their top priority, but their conduct shows otherwise. As soon as we start talking about the interest of the child, the conversation very often shifts to what the parties have experienced from each other, wherein we must, as mediators, remind them that even if the parents have had agency in either getting into marriage and exercise the continuation of that agency to get out of marriage, the child has none, zero agency in that entire process. They are silent collateral damage to an accident they did not choose to be a part of. And that is something that every individual, every parent, every client who comes in for mediation must be cognizant of. So my job as a mediator, I believe, is to genuinely, silently, but authentically test what the parties are actually trying to do, whether they actually have the child's interest at heart. I had a very, by the grace of God, had a very amicable divorce, have a fantastic relationship with the mother of my child, and have managed to co-parent our child for the past 10 years. It's difficult, it's a process that happens, and this is where the use of a psychologist at the time of divorce really, really helps. I have never, the training that I went through, and I thank Bruce Edwards, Leila Olapalli, and my mentors to have taught me that never to confuse myself to be a counselor or a therapist. I'm not one. My expertise does not lie in therapy, and therefore to take the role of a therapist to try and counsel disputing parties how they should parent would be folly. So very often, very strategically, you must call in a child psychologist, especially if the children are young or you see that they are extremely vulnerable in their responses to you. Don't try and resolve the problems that the child is having. My approach has been to simultaneously run the conversations with the child psychologist with the work that I'm doing as a mediator. This is the liberty that I have as a private mediator to try and bring all these aspects into the mediation process. It's very, very clear in my mind. What I provide to you is the solution or the guidance to move towards a solution in the form of an amicable divorce. I do not provide therapy services, although the success of therapy and the ability to communicate with the child will significantly reduce the damage post-divorce. Divorce या तलाक तो आपका हो जाएगा. आप माँ बाप बनना बंद नहीं करोगे. You have to be the child's parent for the rest of the child's life and the rest of your life. Do not damage it because of myopic thinking. I think it is imperative, and I'll end with this, I think it is imperative that where children are concerned, specialist help is sought strategically, honestly, and directly, such that the interests of the child can be kept paramount in a difficult situation like a divorce.
Thank you, Gokul, and I really appreciate the way you have expressed through your personal experience as well. We all need courage to express, but I really admire your comments on this. And you have given two thoughts to me now. You use the word parenting and co-parenting. So the word custody is nowhere in picture when the settlement takes place. Then visitation changes into access to the child. Duties, rights turns into duties towards the children. And of course, maintenance turns into child support. And the most important thing which you have highlighted is, there is a thin line difference between mediation and counseling. We as mediators sometimes cross over that border jurisdiction and we become counselors for the parties. We should hold our hand at that point of time and take the help of specialists in the field. Thank you so much for your comments. Let me just now again bother Shirin. Shirin, deep-seated cultural dynamics such as patriarchy, age hierarchies, or all economic disparities often create heavy power imbalances in family mediation rooms. What specific techniques do you use to level the playing field so that a settlement reflects a genuine consent, informed consent of the parties, rather than forceful submission to the process?
So I would begin from the position that neutrality of a mediator doesn't mean that I'm just a passive observer to somebody dominating the process. Inequalities, in fact, lead to agreements which are without consent. So I look at, not in favor of the weaker person, but I look at how to try and make them equal. So I try and see that they have a space which they feel they are safe in expressing themselves. There is some opportunity from them to maybe have private sessions, and also that the decisions that they take are independent. The other thing that I watch out for is maybe the fear that they have, exhaustion, which could be even before coming over to the mediation table or during the mediation table. Dominance by various people, as you mentioned, maybe because of the age, because of patriarchy, etc. Just watch out for that. The first thing that I would do is identify as to where is the power imbalance coming from. Is it because they have somebody who's older because of the age? Is it because there is a belief in the society that one party is the one who has to make all the sacrifices? Is it because of maybe the parents, or is it because there could be threat of some litigation? Is it because the person feels used? Is it there's a stigma in the society? So there are various things which could happen. So what we just try and do is firstly identify where is it coming from. Sometimes I've also found that I can just make out it kind of is instinctively, you can see that there is some fear in the person who's there before you. So I have a session with them singly, even before I have a proper substantive session with the two of them, to try and find out where is it coming from and where I ask them open-ended general questions. After that, I would take them maybe into individual private sessions. And in private sessions, I would again ask them open questions as to, who do they fear? Do they think that if they agree to a certain thing, somebody is going to pressurize them and would not let them agree? Do they fear for their physical safety? In fact, if it's a case of physical safety, then I might even think about terminating the mediation. Or what I would do is call the two parties at separate times physically, because very often the parties come physically. So if it is so, I wouldn't call them on the same day, because just by being present together at the same time, there is often a fear that is there in them. So if a VC is not possible, then just call them on different days. So those are some of the techniques which I would use. I would also sometimes, I find that in fact, there is imbalance from the same party side, like the party is fearing not the other side, that the other side is, is dominant, but could be her own brother, could be her mother, it could be her lawyer. So what I do is then I segregate them. I have a lot of small private sessions with each one of them first, and just try and do a batna and a watna, which I find is any case is very, very useful with every party. And after that, I would put them together, the same party together, and then move ahead. Also in the Batna and the Vatna, I would be a little careful that the party who feels little lesser, so to say, doesn't feel threatened that she has to agree to something. And it's not that when I'm going through the Batna, she feels, oh, I'm possibly showing her all the negatives of it. So just be a little careful on that. The other thing which, in fact, Gokul also mentioned for, that he would have a counselor, I very often suggest to them third parties to take advice from. So besides maybe a counselor, it could also be maybe a valuer or a property dealer or an accountant or somebody else. So yes.
Thank you, Shirin. With your expertise, I think you have handled many matters. Let us now, with sir, we can ask them if any questions from the participants. Yes, please. I think somebody needs to give them the mic.
Good afternoon, madam. Good afternoon, respected dais. I come from Kerala, and I represent as a resource person of the Kerala State Legal Services Authority. And during the discussions, I found it very interesting to hear about the child custody issues, especially what Mr. Gokul Narayan was highlighting. We actually back home, we have a facility provided by the Kerala State Legal Service Authority, which is called the Child Legal Assistance Program. It's called CLAP. We have a child support lawyer exclusively for the child, because what we normally find is whenever the child is between the warring parents, the child's voice is completely unheard. So what the child wants, what the child wishes, and child's wishes need not be akin to the best interest of the child as well. So in order to balance that, it was a suggestion given by an amicus in a child custody matter way back in 2023, which has later become a judicial order by Honorable Justice Muhammad Mustaq, as he was then heading the matrimonial bench. And later, it was a direction given to the KELSA, that is the Kerala State Legal Service Authority, to have
may I just intervene for a minute?
Yes.
We really appreciate that Kerala has got this facility called CLAP, and I think it can be a idea for other states to follow. We will focus on questions if we have. Or, yes, please. Ma'am, we'll just, because we're running against time. These are the indications coming. Yes, please.
Yes. Good afternoon, the panelists. The question is for Mr. Gokul, and all the panelists can also answer. So here we are focusing on the role of mediators in making mediation successful. When we are a mediator, we take a back seat and we try to facilitate. I want to understand from the panelists that when there are advocates who are coming with their clients, how advocates play a role, because advocates don't take a back seat, it seems. They sometimes have the intention to let the matter go on. Of course, they give a chance to the mediation to test, experiment, but I think there should be some mechanism to also educate lawyers to facilitate mediation so that it becomes more successful.
Gokul would answer? It's addressed to Gokul.
Sure, ma'am. I'll try and answer that as brief as possible.
No, we are there for you.
Thank you for asking that question. It almost seems as if I have planted this question there because Jonathan and I have created a course on mediation advocacy, teaching advocates how to be a part of a collaborative dispute resolution process. You're absolutely right. As a mediator, I can do precious little if the advocate does not play her or his role properly. The aim of any dispute resolution mechanism is to help the parties arrive at a resolution. The means to an end can be litigation, it can be negotiation, it can be mediation, it can be anything. But if the stakeholders, and an important stakeholder like a lawyer doesn't understand her or his role, I as a mediator can do precious little to guide parties to a resolution. So you're absolutely right. Training of mediators is as, if not more important than training of lawyers is as, if not more important than training of mediators, because mediator आपको इस देश में कम चाहिए, वकील जो collaboration समझ पाए, उसकी बहुत ज़्यादा सख्त और बहुत ज़रूरी आवश्यकता है. So absolutely right, I couldn't agree with you more.
So I'll just say in one sentence, the matter that settles because of the lawyers involved, and that matter that doesn't settle, less said than better. Yes, any other question?
I would just add to that by saying that I think when in mediation, it's the parties who play a more important role than the lawyers. So I think if the mediator is experienced and the mediator has the trust and the power, I wouldn't use the word power, but the trust and the confidence of the parties, irrespective of the lawyers, the matters do get settled.
Yeah.
Thank you, Priya. Any other question?
Yeah.
Yes.
It is, I am Rajat Bindal.
Which side, please?
Yeah.
Yes, please.
Yeah. I am Rajat Bindal. I am practicing basically in District Court, Bareilly, UP. My question is that we were just talking about cross-border child custody disputes. Now the problem is that when Indian court passes a child custody order, it's not been implemented by foreign courts. Why we are not a signatory to Hague Convention? That's the main hurdle. If we sign the Hague Convention 1980, these problems will evaporate. Thank you.
Priya ji, you made a answer.
You're absolutely right. We need to think about what we need to do about the signing of the Hague Convention. But irrespective of that, we have got orders. If you get it recorded in the order here by the Indian jurisdiction, by the courts here, that you will get a mirror order there from the foreign jurisdiction, whatever foreign jurisdiction it is. You do need time. That's the only factor which comes in our way is the time, because the foreign jurisdictions need at least 15 to 20 days after you get a certified copy, but the consent has to be there as well. So when these matters that we have been doing, we make sure that if the other parent wants visitation or to take the children for a holiday or to relocate in another jurisdiction, they have to agree in the jurisdiction in India that they will assist and they will participate and they will cooperate in getting the mirror order there.
I think rest of the questions we can take over the lunch during the lunch. Huh?
There's one.
Because
There's
Pooja
one
has
last
been
question.
very
Pooja has been
enthusiastic.
asking.
And thanks to Justice Singh, he has noticed you. Please go ahead.
Pooja.
No, let others also know what you are asking.
Thank you so much for a very interesting panel discussion. Priya had mentioned about matrimonial matters being sent for arbitration in the jurisdiction of UK and Europe. So isn't it pertaining to prenup matters? Should we not have it in Indian jurisdiction? Would it not be worth its salt if prenuptials were made? Then 498 at least would go, and 406 like cruelty plus misappropriation. And sorry, I'm using IPC. I still cannot offhand remember the BNS.
Is looking into considering the fact that we should have prenuptial agreements in India as well as we have in other jurisdictions. But till that doesn't happen, the issue at the moment is that we have to, abide by what is the law here at the moment. Yeah, we have to.
I mean, since we are discussing,
yeah,
then
but the concept of arbitration in UK is that it is like an arbitration, commercial arbitration in India. The costs are very heavy.
Yeah.
The person who invokes the arbitration has to bear most of the costs, and the arbitration is about, it's actually adversarial, and it's about the custody and the maintenance, so it actually will not work in our jurisdictions.
True.
Ask your question, sir. You had some question? But let us be short and crisp in replying also.
Who asked?
The gentleman standing there in
Jamshed.
Yes, that's what I'm saying. Let's be precise.
No,
yes, sir, we'll take over. Yes, please.
I'm not asking any questions. In fact, I wanted to give you a few suggestions to make the things easy for the mediators.
That can be taken up later.
We have been talking about the benefits of mediation, but nobody has spoken anything about when the matter is referred to a mediation and the matter is before the mediator. Problem there is conduct of the parties, which is a problem with the confidentiality part. Alimony, which is being demanded in crores these days. Third is, there should be a code of conduct imposed upon the parties when they agree to go for mediation. Brainstorming is for you to do. This cannot be decided here, but these two are my suggestions. There were others also.
Just one line on this. We have a long way to travel further to get to what you are saying, where parties themselves start behaving as if it is for their benefit. Of course, the success of family mediation depends on trained mediators, public awareness, institutional support, and most importantly, a willingness among parties to choose dialogue over hostility. So till the time we achieve that purpose, maybe we will be struggling with such type of situations. Thank you everybody here as my panelists, but this panel was having discussions in the auspicious presence of Justice Anurup Singhi, and he also has a lot of thoughts on this subject. I would like Justice Singhi to share your thoughts on the subject.
In the given time frame.
Sir, all for you now.
Am I audible? With the given audience, I thought to stand and deliver. A very happy afternoon. From what I wrote on my own, I have made 2 changes. As against good, I have converted it to happy, and as against morning, I have converted it to afternoon. Why I say happy? Because as a lawyer, which I was, and as a judge, the most important thing is that as a lawyer, we are required to be immaculate with our prayer. And as a judge, we are told that look at the prayer first. So, bottom line of our life is, in my opinion, is to be happy. And I think it is there that the mediation plays an immaculate role. It keeps you happy. A decision, right or wrong, in a law may not be making you happy. It might be impeccable in law. You might not feel happy. But a settlement in a mediation will certainly make you happy. So a happy afternoon to all of you, to each and all. I'll try to curtail those 5-10 seconds by just addressing everybody. I am amongst a very august dais and a more august gathering. As we draw this session to a close, it is both a privilege and a pleasure to reflect upon the rich and meaningful deliberations that have taken place today. We heard case studies, statistics, doctrinal analysis, but beneath all ran a single, quieter theme, that the family is not a legal fiction to be litigated, but a living relationship to be protected. Let me begin with a very old saying, blood is thicker than water. It is a phrase we use almost too comfortably, yet its wisdom is profound. It is a reminder that the bonds of family, howsoever strained, howsoever bitter the dispute is, carry a weight which no decree, no judgment, and no order can ever truly replicate or replace. And this is where mediation comes into picture. A litigation decides who is right. Mediation settles what can be saved and then groomed. A courtroom, by its very nature, is designed to adjudicate and determine the legal rights and liabilities. It may produce a successful litigant, but the law has to declare one side legally entitled. Mediation, on the other hand, is different. In mediation, every party has the opportunity to emerge with dignity intact. A mediation room, done well, produces two people who can still sit at the same table without the air turning eyes. While mediation undoubtedly reduces the pendency of cases before our courts, its true rewarder is measured not merely in disposable statistics, but in the endorphins and dopamine which it generates by replacing bitterness with dialogue, resentment with understanding, and estrangement with reconciliation. The root of every family dispute, in my humble view, lies in one simple word: me, M and E, where M stands for money and E stands for ego. Because families fracture over inheritance, maintenance, property, and fear of receiving less than what one believes he deserves. And ego, because families fracture over the needs to be declared right, the inability to forgive and forget. And the tragedy is that both money and ego are ultimately negotiable, whereas the relationships they destroy often are not. Perhaps, therefore, the letter M needs to be turned upside down to make it W. We must become we, where W should stand for worthy and E for easy. And that simple transformation captures the true philosophy of mediation. And I am of the firm belief that we, W-E-We, always include M-E, me. The family settlement arrived among families after years of differences reflects the wisdom of choosing consensus over confrontation. Though justice never be compromised in the name of settlement, however, there are cases where it is a case of misunderstanding and not cruelty. It is those cases where justice should be done by way of a mediation. Mediation is something which is immaculate, can travel far beyond what a justice delivery system is. The 4 C's of mediation outline the core benefits of resolving a dispute outside the court: communication, collaboration, confidentiality, and compromise. As I'm running short of time, there are many more things which I thought to share, but I know I am the only barrier between lunch and you all sitting out here. So I would only humbly request you to be having more wisdom, because we as judges, lawyers, mediators, and more of as an individuals. Let us not only be literate, let us be the one who are educated. And education is not merely of being right or wrong. As Madam Ravi said, we are now who is right. So we should travel to what is right. And I take a step forward from that. What is right for me and for us, that is also important. As Madam Shireen said, harmonization. Harmonization is the end goal. In every relationship, adjustment, harmonization is the key to that. Madam Priya said that overall awareness and Family Courts Act needs to be reconsidered. Yes, truly it should. In the evolving game, in the evolving world we are in, these things are required to be looked into. And as Mr. Gokul said, importance of silence. That is absolute understanding which is required, where what to speak, what not to speak. And silence is a real gold. So with all that, with this August gathering, I humbly request you all to carry some more wisdom with all what the learned speakers have said. And I extend my heartfelt gratitude to all the distinguished speakers for the depth, honesty, humanity they have brought to this session. Thank you all. Thank you so much.
This has been a highly enlightening and a thought-provoking session. I would like to extend our heartfelt thanks and deep appreciation to Justice Anurup Singhi, Ms. Veena Ralli, Ms. Shireen Khajuria, Ms. Priya Hingorani, and Mr. Gokul Narayan. Thank you so much.
Thank you, the dais. Honorable, I must tell you, in fact, you are not between the dignitaries and the lunch. It is the arrangers who are between them. So they have asked me to take one more session, and after that there will be a lunch. So you have to please bear with us. We'll have one more session, but then before we begin the next session, we'll have a souvenir presentation to our dais.
As we bring this enriching session to a close, we now have the privilege of expressing our heartfelt gratitude to our distinguished dignitaries through a ceremonial presentation of souvenir as a token of our respect. First of all, I humbly request respected Member Secretary, Rajasthan Legal Services Authority, Shri Hari Om Atri Sir, to kindly felicitate Honorable Mr. Justice Anurup Singhi, Judge, Rajasthan High Court. Now I call upon stage Ms. Sonal Parikh, Secretary DLSA, Byawar, to kindly felicitate Ms. Veena Ralli, Mediator, Samadhan. Now, I request Shri Ram Kishan Sharma, Secretary DLSA, D, to kindly felicitate Mr. Gokul Narayan, Advocate Mediator. Now, Now, I request Mr. Vineet Kumar, Secretary DLSA, Salumbar, to kindly felicitate our speaker, Ms. Shireen Khajuria. Mr. Vineet Kumar. Now, I request Mr. Kiran Kumar Chauhan, Secretary DLSA, Dungarpur, to kindly felicitate our speaker, Ms. Priya Hingorani.
ठीक है.
First you will start, felicitate, then coordinate to begin.
Thank you very much. With this, we come to an end of the session. We once again thank the dais, honorable, and all the resource persons and then all the experts over there. Thank you very much, sir. Thank you very much, madam. We now begin with the next session, which is, the topic is retribution, from retribution to restoration. And it is my esteemed pleasure to please invite Honorable Ms. Justice Abha Patel, Judge, Supreme Court, Zambia, as the session chair. And also I will request Mr. A.J. Jawad, Registrar, International Arbitration Mediation Council, to please come. Mr. Prashant Barua, Bangladesh, who is settled in UK, to please come. Ms. Wimbai Nyamba, Legal Practitioner, Zimbabwe. And Mr. Jitendra Sharma, Senior Advocate, to please come and grace the dais. The coordinator for this session is Ms. Pragya Baghel. She is an advocate and she is also an esteemed mediator. May I also request you, Ms. Pragya Baghel, to please come. Thank you very much. May I request Mandvi Ragini, DLSA Bikaner, to please come on stage and felicitate Ms. Wimbai Nyamba, Legal Practitioner, Zimbabwe. May we have a round of applause, please, for our esteemed dais who's on the stage, because... And lastly, may I request Mr. Jitendra Sharma, Senior Advocate, to come on stage and felicitate... Sorry, Ms. Pallavi Sharma, DLS Judge Jaipur, to come on stage and felicitate Mr. Jitendra Sharma. Thank you, everybody. Ms. Pragya Baghel, the stage is all yours. Thank you very much. Wish you a good session.
Thank you. Happy afternoon to all of you, as my earlier speaker had said. So very welcome to all of you to session 2. We have all heard and watched, honored to have with us a truly distinguished panel bringing together different perspectives from the bench and the bar, spanning India, Zambia, Bangladesh, and Zimbabwe. It is my privilege to introduce the chair for this session, Honorable Justice Abha N. Patel, Supreme Court Judge of the Supreme Court of Zambia, having arisen from the High Court and the Court of Appeal before her elevation to the apex bench. She was in private practice for almost 30 years before ascending to the bench, a fellow of the Chartered Institute of Arbitrator, and until recently a member of the UN Global Mediation Panel. Justice Patel brings a rare dual perspective to today's discussion, deep grounding in adjective justice alongside sustained expertise and experience in alternate dispute resolution. We welcome you, ma'am. Now, allow me to introduce to our speakers. The first speaker is Mr. A.J. Javed. He is a registrar IA MSc. He is a seasoned advocate with 38 years of experience in the legal field, a distinguished senior mediator, trainer with over 20 years of expertise in civil, commercial, international, and matrimonial mediation. He has served as a senior mediation training with MCPC of the Supreme Court of India and with the Tamil Nadu Mediation and Conciliation Center at the High Court of Madras. He is an accredited mediator with Singapore International Mediation Institute. He has coached winning teams at the ICC Paris, ICC Asia Pacific Mediation Competition, and writes frequently on ADR for publication like Live Law. Welcome, sir. The second speaker is Mr. Prashant Bhushan Barua. Barrister Prashant Bhushan Barua, educated and trained across the dual jurisdiction of Bangladesh and the United Kingdom. Advocate of the Supreme Court of Bangladesh, he divides his time between court practice and academia, holding a professional position at Port City University, Bangladesh. Alongside his court practice in media law, human rights, and constitutional law, Mr. Barua is a member of the Chartered Institute of Arbitrator, served the global mooting community as a judge for the Oxford Prize Media Law Moot and the Jessup International Law. A well-known television commentator in Bangladesh on law, politics, and contemporary affairs. We welcome you, sir. Third, we have a permanent Secretary Law, Zimbabwe, Wimbai Nyamba. Wimbai, ma'am, a distinguished Zimbabwean lawyer, leader, and public servant with an illustrious career spanning over 2 decades in legal practice, governance, and public administration. A graduate of the University of Zimbabwe, she founded V. Nambia and Associate in 1997, building into one of the Zimbabwe's most respected law firms. She has served as a president of the Law Society of Zimbabwe, president of SADC Lawyers Association, vice president of the African Bar Association for Southern Africa. She serves as a permanent secretary of Zimbabwe's Ministry of Justice, Legal and Parliamentary Affairs, the Ministry of Chief Administrative Officer. Her contribution have been recognized through numerous national and international clothes, including recognition among the 50 most influential women in Zimbabwe and among the Southern Africa's most influential female lawyers. Welcome you, ma'am. The fourth speaker, and the most strongest one, which I would say, our own Mr. Jitendra Mohan Sharma, sir. He's a distinguished senior advocate at the Supreme Court of India with over 4 decades of experience in litigation, constitutional law, dispute resolution. He began his career in 1979 at the District Court, Meerut, and has been practicing before the Supreme Court of India since 1991. He's qualified as an AOR in 1992 and was designated as senior advocate by the Supreme Court in 2013. Apart from his litigation practice, Mr. Sharma has made significant contribution to the field of mediation. He has been member of the Supreme Court Mediation Center since 2009. We welcome you, sir. Now with this, I hand over my 3 R's to Abha ma'am. So I formally hand over the proceeding to Justice Abha Patel ma'am. So now it's yours to guide. Thank you.
Thank you very much. Good afternoon, everybody. Can you all hear me? Yes? Okay, so we come to you in peace, and we simply apologize that we now stand between you and your lunch. But I think in part of a mediated settlement, it was agreed that we have this session and then we proceed to lunch. So I simply say thank you for giving us your attention, and it's great to see the hall looking relatively full. So please don't start walking out, because I can see all of you. So, as chair of this session, it's our privilege to be here before you today. And we're going to speak about a very sensitive topic. And I think it's a topic that is a little bit uncomfortable to speak about as well. And perhaps as we go through this, I might invite some of you to just think of yourselves as the victim. And maybe others could think of themselves as the accused. And others could think of themselves as the adjudicators in what is a system of tension and the push and pull that comes with a discussion such as this. As chair of this session, I will briefly introduce the topic in three parts. First, the scale and causes of pre-trial detention. Secondly, the role of mediation, plea bargaining, and restorative justice in easing systemic pressure. Thirdly, the safeguards that are required to ensure that restorative processes protect victims, preserve public confidence, and remain appropriate to local legal traditions. The questions in your mind should already be, is this attainable? Or is this utopia that we seek to describe? We all know the presumption of innocence is the bedrock principle of most criminal justice systems around the world. And this presumption protects an accused's constitutional rights and provides safeguard from arbitrary and excessive state action. Despite this almost universal acceptance, the presumption is commonly disregarded in practice. Today, it is estimated that there are over 3 million people, all of whom, remember, are presumptively innocent, languishing in pre-trial detention around the world. Unfortunately, the vast of the pre-trial detention population are the world's poor, who often have no access to meaningful legal service. And importantly, the global pre-trial detention crisis is not a byproduct of choice or desire, but rather a symptom of insufficient resources and capacity within the criminal justice chain of any jurisdiction. With today's crime rates, the average country processes tens of thousands of criminal cases per year. Criminal trials, as we know, take significant time and resources to hold, and quite rightly so if we are going to preserve the rule of law. But at that volume, there is simply no way to provide a speedy and fair trial to everyone concerned. What then is the answer, you might ask? Can justice be achieved by exploring whether dialogue, accountability, and restoration can coexist with deterrence? Can we reconsider the future of criminal justice through the lens of healing, responsibility, and societal reconciliation? Whilst it is commonly accepted that mediation and plea bargaining remain the most integral ADR mechanisms for increasing access to justice and decreasing case backlog time to trial and prison overcrowding, local values and customs and traditions must, I submit, be an integral part of any solution that any jurisdiction is going to carve for itself. Let us be clear, there is no one-size-fits-all approach when it comes to criminal justice solution. What works in the US or what works in Europe need not and should not be haphazardly copied and pasted. Current events in the world tell us that this is not an academic issue, but this is a live issue which threatens the very fabric of our society. Two notable examples come to mind. A recent BBC News broadcast spoke about challenges in Haiti, and it described juveniles in conflict who were incarcerated when they were young youths of 14 years of age. The same juvenile now is a young adult. He's 22 years old and has not yet appeared before any courts of law. There are no dockets, there are no files, there is simply nothing. The country does not have the resources to deal with such matters. These youths have lost their childhood and continue to be held on charges that are simply unknown. If you were that accused person, what would you want your state to do for you? In the United Kingdom, as recently as last week, an early prison release policy was meant to come into effect in September 2026, which has now been placed on hold by the new Prime Minister, Andy Burnham, following the outcry from the public with specific reference to the death of PC Andrew Harper in 2019. Victims and their families are outraged at the possibility of an early prison release for the perpetrators of what is considered heinous offenses. The tension at the core of early release schemes are almost always driven by prison capacity, a systems management response. But if you were the victim or the victim's family, is that the answer that would satisfy you? That we have to let these individuals go because there is a crisis in the prisons or in the capacities? Restorative justice, as we will hear from the distinguished panel, by contrast is victim-centered. It asks what the victim, or in the case of a homicide, what does the victim's family need to feel that justice has been done, acknowledging participation and a due sense of proportionality? These two logics do not share an objective. Capacity-driven release is simply population math. Restoration justice is relational and individualized and needs to suit the circumstances. When a government uses restorative language to justify what is actually capacity release, it risks instrumentalizing victim rhetoric to legitimate a decision made for administrative convenience. We will hear about the African context, and I think much of the continent has had its share of indigenous dispute resolution traditions. The Gacaca courts in Rwanda are a famous example. And these post-genocide Gacaca courts remain the most studied large-scale experiment in blending accountability with restorative processes. We can talk about the Nuremberg-style tribunals. We can talk about South Africa's Kenya and Trust Reconciliation Commission. We can talk about Sierra Leone's special courts. The central policy challenge is balancing restorative justice with victims' rights, deterrence and public confidence, judicial oversight and safeguards against coercion, especially in serious crimes or cases involving power imbalance. I hope I've given you food for thought and not thinking about the food that sits waiting for you outside. I'm going to stop here now. I have a very eminent panel, and I know you want to hear from them as well. So allow me to call on Mr. Jawad, who will be our first speaker this afternoon. He has been introduced, and he will bring to us a fascinating concept of nature versus nurture as he takes us down this journey of what or who makes a criminal. Mr. Jawad, we welcome you.
Thank you, ma'am. Good afternoon to everyone, and apologies for making you sit here. So the Honorable Chair, my esteemed co-panelists, and distinguished members of the audience, I am grateful to CLA, Nivaran, and the Rajasthan State Legal Services Authority for giving me this opportunity. So when I was asked to be a part of this panel on the topic that you see on the screen, or you see only me on the screen, I'm sorry. From retribution to restoration, reimagining justice through mediation, I enlisted the help of my young colleague, Jana Ganesan, to help me with the research. She gave me a very scholarly treatise running to almost 20 pages, which is not surprising as she's a qualified psychologist and a mediator. But then I had a problem. Our chair, Honorable Chair, had issued a mandamus giving all speakers only 7 minutes each, and rightly so. So I did not want to be hauled up for contempt before a Zambian court. So therefore I enlisted the help of another colleague of mine, Mr. Claude, and requested him to give me content for 7 minutes. So to reduce the whole thing to 7 minutes, with some scope for a little ad-libbing and, saying something from my side, so that I comply with the mandamus. And here's what I got. So let me begin with a simple question. When does a crime actually begin? Does it begin when a knife is raised, when a shot is fired or when any act of violence is committed? Or does it begin much earlier? Inside a home where violence is a normal day-to-day routine, a childhood that is shaped by neglect and deprivation, a community where trauma quietly becomes a way of life. I'm not saying that trauma is an excuse for committing a crime. Most people who suffer adversity never offend. But trauma does shape the ground on which choices are made. We usually meet crime at the end of its journey. But what if the offense before the court is only the final chapter of a story that began years, even decades earlier? Then justice must ask not only who committed the crime, but what produced the circumstances in which that crime became possible. For all its force, retributive justice rarely answers that question. So let me bring this closer home. In Mumbai's Kamatipura, one of the oldest red light districts in Mumbai, researchers have documented children growing up amid commercial sexual exploitation, violence, and exclusion. Many live in one-room homes where their mothers do sex work, witnessing raids and abuse before they are old enough to understand any of it. And they endure a quieter violence too, which is called a stigma. Mocked in classrooms for their mother's occupation, they withdraw from school, rarely able to complete their education. So now let us pause and imagine one such child, a child who witnesses exploitation every day, who never receives counseling, never knows a stable home, never forms a secure attachment, never learns emotional regulation, never experiences dignity. 20 years later, that child enters the criminal justice system. Again, this is not to excuse crime, but to say that a society committed to the rule of law, my friend Mr. Ganesan will be very happy that I mentioned the rule of law here, but must also ask whether it met its own responsibilities before demanding accountability from others. And Kamatipura teaches the lesson. Environment is not destiny. Organizations like Kranti, which is an NGO which works with these children, which support the daughters of sex workers, have shown that early intervention changes life trajectories. Young women once expected to remain trapped in exploitation now pursue higher education, fellowships, and leadership. Trauma creates vulnerability, intervention creates possibility. And here science offers its most hopeful lesson. We long believed that the adult brain was fixed. Once it reaches a certain stage, it stops growing. And if you ask my wife, she'll confirm that about me. We now know that it is not, actually, The discovery of neuroplasticity revealed that the brain reorganizes itself throughout life, forming new connections in response to experience. If exposure to violence, fear, and neglect can carve pathways of aggression and mistrust, then exposure to safety, empathy, and responsibility can carve new neural pathways. If harmful environments shape the brain, healing environments can reshape it. Rehabilitation is not only behavioral, it has a biological basis. So the question is no longer whether people can change, but whether our institutions create the conditions in which change becomes possible. And this is where restorative justice enters. So I think our Honorable Chair brought out this alignment between the offender and the victim. Now, it's too often understood as leniency. It is not. It does not ask us to abandon accountability, but to deepen it. Where traditional justice asks what law was broken and what punishment is deserved, restorative justice asks more. Who has been harmed? What responsibility must the offender now accept? And what must be done to repair that harm where repair is possible? Now, these are not softer questions. They are the harder ones. It's far easier to serve a sentence in silence, than to sit across the person whom you have harmed and answer for it. And this is where mediation becomes a tool, not a substitute for the courtroom, but a companion to it. Mediation is not merely a legal process. It is empathy given structure. It replaces reacting with listening, judging with understanding, domination with dialogue. An offender hears in a human voice the voice of their victim, the harm they caused, often for the first time as something real rather than procedural. And a victim reclaims what the courtroom so rarely returns, a voice and a dignity of being heard as a person rather than as a case number. Now, there is something deeper still. The very capacities whose absence so often underlies an offense, the ability to pause, to regulate emotion, to imagine another's experience, are precisely the capabilities mediation asks a person to exercise. Every mediated conversation is, in a small way, a healing environment. It does not only resolve the dispute before it, it models the very skills of the offender that the offender may have never been taught. It is neuroplasticity in practice. And the evidence bears this out. Restorative programs produced modest but real reductions in reoffending, particularly among the young, while improving offender accountability. Strongest where the participation is voluntary. Like mediation itself, restoration cannot be imposed. It depends on willingness, accountability, and genuine participation. So coming back to my original question, when does a crime begin? Often long before the offense, in adverse childhood, in fractured families, in untreated trauma, in the silence of institutions that fail to intervene. If crime begins long before convention, justice cannot begin only after it. Punishment will always remain essential and accountability is non-negotiable. But if our ambition is not only to punish crime, but to reduce it, then justice must become more than retribution. It must also become prevention, restoration, and reintegration. Because the true measure of a justice system is not only how well it punishes those who offend, but how successfully it prevents the next child from becoming one. So the journey from retribution to restoration is not about choosing one over the other. It is about building a justice system mature enough to do both, to punish where necessary, restore where possible, and intervene early enough that fewer lives ever reach the point where punishment becomes necessary at all. Thank you very much. I hope I complied with the mandamus. And if I have exceeded a minute or so, I will submit a written apology, ma'am. Thank you.
Thank you very much for that. And I'm not exercising judicial powers here. I will not go down that route. Thank you very much, Mr. Jawad, for your comments. Let us now hear from our next speaker. The next speaker is Barrister Prashant Barua. He will speak to us on his personal experiences and present a case study in relation to Bangladesh. Welcome, Mr. Barua.
A very good afternoon. I promise I will be less torturous to you immediate before the lunch. Honorable Lady Justice Abha, Chair, and the distinguished members in the audience, and this my fellow galaxy of talents on and off stage. The reason why I take the liberty to share, to make myself focused on some Bangladesh recent trends that is relevantly connected with the mediation. I understand some of my figures will be bitter. You may not have even heard that. Let me just be precise what I want to share with you. For last 2 years, nearly 1,600 Supreme Court and District Court lawyers barred from coming to court. How? Not by law, not by order by court, nothing else. So why they are not coming to court? Because their names are given in numerous murder cases. Someone was murdered 500 miles away from capital, and 84 years, former bar president who was elected 6 or 7 times, I believe, Mr. Abu Said Sugar, 84 he was at that time, including him, 74 senior lawyers sent to prison and denied bail months after months. And other lawyers, they are told, don't come to appear in the court, you will be arrested, stay to your home, police will not arrest you. No investigation conducted at all. and they are told, don't come to High Court for seeking bail. You will be arrested immediately. And don't come to court to appear. Give your clients to us, particularly commercial clients. Former Attorney General, after nearly 18 months, he attempted to take the bail. He was actually, physically prevented from entering the court premise by a group of mob people. So, why I am telling that? In last election, approximately 80 million, yes, 80 million people denied free exercise of their voting right, as if ICCR Article 17 and 19 disapply in the airspace of Bangladesh. How? One of the arguably biggest political party was banned, and their supporters from last, I think, 8 or 9 general elections, nearly 40% or 45% of total voters, they are told, choose between us. So that tendency later expanded in bar elections. In all bar, district bar, including Supreme Court bar, lawyers are denied their candidacy. How? They were just said, no, you do not belong our political belief. You belong to different political belief. So you cannot participate in bar elections. I express my heartfelt gratitude to CLA and Law Asia, plus 17 other European and global think tank and rights body who correctly issued 2 consecutive statements. And there is South Africa model I discussed with Honorable Chair. There was an attempt 2 years back, if instead of collective punishment imposed, whether there can be a reconciliation attempt. The Achilles heel of mediation, sometimes is correctly said, is that victims have no say to that. Terribly imbalance of power in lawyers' community itself. So now there is a saying in court arena in Bangladesh that the defenders demand defense for themselves. Defense lawyer in Dhaka court, in one instance, were told by the prosecution, hello, you are defending 3 accused. You speak only 3 minutes, 1 minute each. If you speak more than that, the audience will be displeased and you will be thrown out from the court in open court. One High Court judge, anticipating, he was issuing a bail order to some detainees aged 70 to 80, 85 years old. He was thrown X in open court. And he was threatened, your child will be adopted, you will be beaten in the street, in the High Court. So I understand, I am sharing some bitter experience, but I assure you, as a brother lawyer, fellow lawyer, the facts are 100% correct. And there is no sign to a slightest attempt to end this continuing trend that engulfed terribly the legal arena for almost 2 years. So now, the liberty I have actually taken from the chair, and from you, of course, to share it, that the voices, international, regional voices, should be raised, should be given. The lawyers are the defenders, the frontline soldiers, fighters, to defend the rights of the members of public. They are the voice for the helpless. Now they are helpless. 7 Dhaka University senior professors are suspended from their job. One by writing and one line suspension order. And what is the reason? A vague reason. Your behavior was not like a teacher. And 238 others are facing probe. What is their problem? You didn't support our movement 2 years ago. Or at least you didn't protest. You should have protested with us. And that is the root cause of their possible suspension from the job. Doctors as well. So what I am, distinguished member of the audience, I will not make you bored more by giving some bitter information, but it will be actually unforgivable if I don't share with you. My friends, fellow brothers, sisters will not forgive me. They are suffering. So while we are discussing on the international mediation concept, and also what I now feel, this is the so-called Achilles heel, that the victim themselves cannot raise any voice. So initiative is not coming from the people who are responsible to make them victim. Rather, victims are crying to avoid a collective punishment. Even they are ready to accept, okay, if some individual is responsible for whatever offense you are accusing, punish them, but don't give us impose a collective punishment. So, sorry. So I believe my note was actually completely on different. I have written many things. I am not sharing that, time is not allowing us, but one thing I am telling, AI is giving a new existential challenge to the mediation. I believe all we are aware about the New Zealand case. It doesn't come from the apology letter. Actually, it was revealed that apology letter was drafted by AI. So, by law, for minor offenses, it should come from the accused, him or herself, from his or her heart. So, it might be a legal challenge later. So, I am not going there. But I want to tell one thing. Are we risking actually our insight in the name of knowledge, or knowledge in the name of information? Or are we risking actually losing our life in the name of living? 1934, T.S. Eliot. So I believe we can connect it, and we can actually try to minimize the risk to sacrifice the human contribution and interaction in mediation process. Thank you very much.
Thank you very much, Barrister Prashant, for your presentation. I'm sure we'll come back to you in plenary and get a chance to speak to you about this. It is now my pleasure to introduce the next speaker, who is my closest geographical sister from Zimbabwe. That's Permanent Secretary Vimbai Niemba. Our jurisdictions have a lot in common, and we also share the Victoria Falls. I will, of course, insist that it is better and more wholesome from the Zambian side, though you will all have to come and judge for yourself. Please, let's welcome Vimbai Niemba.
Thank you very much, Honorable Chairperson. Talking about the Victoria Falls, my president normally jokes with it. He says, when you look at the Victoria Falls from Zambia, you are looking at it from behind, from the back. And when you are looking at it from the Zimbabwean side, you are looking at it from the front. So if you were looking at a beautiful lady, what would you appreciate, the back or the front? Thank you very much for this opportunity. Afternoon, distinguished ladies and gentlemen. I bring warm greetings from the government and the people of the Republic of Zimbabwe, And I express my sincere appreciation to the organizers for convening this important conversation on the culture of criminal justice. The theme before us has been said. I want us to reflect on this question that was never asked before. How do we ensure that criminal justice does not only punish wrongdoing, but also repairs harm, restores dignity, and rebuilds relationships? I think where I come from, traditionally, before there was criminal justice, traditionally we had our traditional leaders who would sit and decide on cases. And I want to believe that was very restorative, because they would look at who has done it and who has been wronged. How can we compensate the wronged person? So the emphasis was on compensating the wronged person and on getting parties together, sit them together, get them to have peace with each other. So it was quite restorative. It was restoring the dignity and also building relationships. But when colonialism came, we then had criminal justice, which emphasized on who has done what and what is the punishment that is supposed to be meted on them. Zimbabwe has got a constitution, and like many other former colonial jurisdictions, Zimbabwe inherited a criminal justice system built largely around an adversarial model. Crime was traditionally understood primarily as an offense against the state, with the victim often appearing as a witness rather than as a central participant in the justice system. After a criminal has been tried, you would not then look back and say, how is the victim going to be compensated? It was how this criminal was supposed to be sentenced, or what was the punishment. It's still the case prevailing. What is the punishment that is supposed to be given to the criminal? But I think we are now moving from that. We are now moving towards restorative justice, where in a number of instances, we have introduced the pre-trials. I will talk about child justice in my country. We now have pre-trial diversion as a program, which is actually now in a bill, our child justice bill, which is going to be law very soon. When a child from the age of 12, around the age of 12, 14, commits a crime, they are not sent to prison. They are simply taken by the police, and the police will phone the pre-trial diversion officer to come and take the child. When the child is taken, he goes to the officers of the pre-trial conference, pre-trial diversion program, where relatives, other stakeholders like the Judicial Services Commission, the prosecutors, the parents of the person are going to be there. Interviews are going to be made. If the child is willing to go through the pre-trial diversion, then everyone is going to be involved to find out what has caused the crime, who has been harmed. The parents of the harmed person and the parents of the perpetrator will be set in one room to discuss as to how they would help the young accused person, so to speak. Instead of taking them in a formal prison or in a formal cell of arrest, the idea is in the constitution of our country, Section 81, which says, which takes into account the best interests of the child. So in that process, we are saying the best interests of the child are not to make him a co-criminal or to make a co-criminal. We want to make sure that the child is rehabilitated and restored. So the diversion will then go through processes, meeting with the person, meeting with the victims. And at the end of the day, the National Prosecuting Authority will look at the report from the divergence officers to see whether this child is supposed to go to a full trial or to go into custody or to be released to their parents. At the time they are released to their parents, they also go through a lot of rehabilitation programs. I also want to talk about Zimbabwe, when we abolished the death penalty, our Death Penalty Act came into being, and those who were sentenced to death and were awaiting, they were awaiting their day, they were all resentenced. And in the resentencing process, all the parties were called. Most of the matters were murder cases. So the victims' families were called, the perpetrators' families were called, and before the resentencing, everyone was put together in the same room to find out whether people can still hug amidst all the problems. So that process was really restorative, and it's working in our country. We have done very well in our civil cases. That I think that this was what was being spoken about by the previous panel discussion. But we have also done well in Zimbabwe. Most of our civil cases are finalized at the pre-trial conference stage in the courts. Before you go to pre-trial conference, the judges also insist that you must have a round-table conference between the parties and their lawyers, with their lawyers, so that most of the cases then go back to court by consent. The orders are then granted by the court. It's not the court that will impose a judgment, but the parties themselves will say, this is what we want, and matters will proceed by way of consent. When someone is arrested in my country, they are convicted, they are in prison. Our prisons have changed their character. They are no longer taking the punitive approach that they used to take. It's the Zimbabwe Prisons and Correctional Services. So we rehabilitate, we correct. When they are in prison, they have time to be visited by their families. There's a family day in the prisons. There is also, what can I call it? There are trainings that they go through, different trainings. There is also a school in prison to make sure that they are also restored. They could have been in the wrong side of the law, but they must be restored. They also, during the time, or almost at the time of completion of their sentences, they are taken back to their communities to meet with the victims and to apologize. They are taken together with an officer in the Prison Services Commission, and a whole department will go with them. They will apologize, and it's quite amicable. It's different from them having to leave prison and still go back into the same community that they wronged. So we prepare them for that. We also prepare those that have to receive them so that they become a part of their communities. We also have got what we call community service. Community service is you commit a crime, you are convicted. Instead of you being in custody, you serve your sentence from home. So this makes you, it does not make you a better criminal. It makes you a better person because you are still living amongst your community. They still have you as part of them. There will not be any fear of you coming back from prison. A lot of communities are afraid of their own relatives, of their own families, when they leave prison and they have to come back home. But community service caters for that. You serve your sentence and you come back home. For us, this is really most welcome, and we source funds to make sure that it becomes a success. It also helps us because our prisons sometimes are overloaded with people. So when you have them serving from outside, that model really works for us. We also have the open prison where you stay in prison, where you are a prisoner, convicted with a custodial sentence, but you still have to go to your family and you come back to prison, you remain a prisoner. If you commit another offense, you are taken back into prison. So that's restorative justice. Finally, I will say that restorative justice also connects with our values in Zimbabwe. Like I have said, I think I have said that before. And in closing, I would say to you, distinguished delegates, the future of criminal justice requires balance. A justice system that only punishes may fail to heal. A justice system that only reconciles may fail to protect. The challenge is achieving both. A good example that we have is in my country, we are endowed with minerals and we've got a lot of illegal miners who are mining, and a lot of disputes arise there. But I'm happy to say that there is always a way of dealing with those disputes before they go to court. The communities around those areas have got their way of looking at it because they've realized that sometimes court does not ensure that justice is done. It can ensure justice is done, but it will leave a fragmentation of relations. So Zimbabwe's experience demonstrates that restorative justice can operate within the rule of law, protect victims, respect due process, and protect rehabilitation. We actually say, nyika inovakwa nevayo, ilizwe lakiwa navanikazi valo. Nyika inovakwa nevayo means a country is built or a nation is built by its own people. So in trying to make sure that we build our country, we want to introduce, or we are very keen to move fast in making sure that our justice system is restorative, it's correctional, and it also protects society from unwanted criminals. The journey from retribution to restoration is not a departure from justice. It is justice continuing to evolve. I thank you.
Thank you, PS Vimbai Niemba, for your presentation. It's been interesting for us to hear the Zimbabwean experience. Allow me now to call our next speaker, who has already been introduced to you. This is Senior Advocate Mr. Jitendra Sharma, who has promised to intrigue us not only with real-life experience, but he will do that while speaking to the criminal justice system in India. Welcome, Mr. Sharma. The floor is yours.
I think that will save, because my height would save me. On a podium, I'll be a little taller one. As a tail ender in a T20 match, I have a tough job. I would not go into the nuances and straightway come to the about the criminal jurisprudence. Those who are practicing in that, most of them are lawyers. There are two types of offenses. One are compoundable, and one are non-compoundable. For a compoundable offenses, there is a possibility of settlement, and courts have accepted that. And Mediation Act also permits that there must be, effort should be made to have a settlement. Now there is an area which is the non-compoundable offenses. The non-compoundable offenses are those which are serious, which are heinous, which are against the society, and they should not be compounded. There should not be any settlement, because the reason behind it was that these offenses being serious, they are against the society, and the state being the protector of the society's rights. So therefore, the individual should not be allowed to have a settlement, and moreover, there is a possibility that the accused can always take care of the victim, and he would go for a settlement. So, till the end of this century, the law was, please, there is no settlement on those such offenses. Now, as the society evolves, the values also change. In 80s and 90s, a new type of offenses came. That was an offense in homes, the matrimonial offenses. In matrimonial offenses, normally the victim would exaggerate the offenses, and one of the offenses was against the dowry and having a cruelty for a dowry. That was a non-compoundable offense. There were other offenses also. Then it is at that time the Supreme Court in B.S. Joshi in 2003 for the first time came out with a concept that if there is a settlement amongst the parties and there is no point in continuing the offense, in continuing the trial for an offense, there is no sense to take the judicial time in that, and that would amount to an abuse of process. And therefore, they took out the jurisdiction of 482, which is an inherent jurisdiction, under which was not a compoundable, but it was a quashing of proceedings, because it was held to be that it would be an abuse of process of law. And this thought process, because in a matrimonial offense, this was further found in Manoj Sharma, State, CBI, and this concept gradually evolved. And thereafter, the three-judge bench in Gyan Singh came out very clearly, that in which cases a compounding or a settlement can be. Let me be very clear. Compounding is one aspect in which a settlement is a possibility. There is another aspect where no case is being made out, maybe because of settlement. The parties have resolved and they are settled. Then the courts have held that this is a case for quashing because it's an abuse of process of law. And of course, I would not go into detail. I would go into, because of paucity time, what exactly I want to share with you is a real life experience, a case which happened in Supreme Court and where a matter was settled. Since now it has been settled more than 5 years, so I can share with you. It was a case of two brothers. Both of them were doctors. Rather, their parents were one of the topmost doctors of that city. After the father's expiry, the two brothers, they were also doctors. Somehow, there was a difference of opinion between the two brothers, and an offense, and an elder brother hit the younger brother on head, and there was a serious injury. And a case of 307. 307 is an attempt to murder. A case was registered. It's an absolutely, injuries were grievous. There is no doubt about it. On the head, on a plain and simple reading, this would have been a case of 307, and it falls under the category where even the Supreme Court has said that heinous offenses should not be settled. Anticipatory bail was moved by the accused. It was rejected by High Court. It came to Supreme Court. I was for the victim. And for the respondent, Mr. Sibal appeared. While he was arguing for anticipatory bail, a suggestion came from the court asking me, because I was the counsel for the victim. He said, isn't it a dispute between two brothers? And both of them are well educated. Is there a possibility of settlement or a mediation? I said, Lordship, I put it with the one caveat. A, on merits, the case is being made out for 307. So reserving that position, I would not mind that let a mediation be tried. When this suggestion came from a victim's advocate, the court appointed a senior mediator, who is Ms. Leila Olapalli. She was appointed. I put one more caveat. I said, before things could go further, I said, we were together in a course. So tomorrow when settlement is taking place positively, this should not be in harness, because I must disclose all affiliations or alien with the mediator. Court accepted it. It appointed. Mr. Sibal rightly accepted. He said, we have got no reservations. Fortunately, mediator worked really hard between two brothers. Incidentally, the mother was with the elder brother. Worked out, she really worked hard. And ultimately, the settlement arrived at. And the settlement was that the 307 proceedings would be quashed because there is a settlement. Then there was the property disputes, which was also added. There was some distribution of properties. When the matter came up before another bench, then the bench said, how is it possible? The senior judge asked me, how is it possible 307 could be settled? The judge, who was the second judge, he said, puny judge said, we referred this matter to the mediation and it is settled and it was resolved. For Rajasthan, it would be for coming to know that the name of the judge who referred is Justice Ajay Rastogi, who initiated the process of mediation, who ventured. What I want to bring to all of you is that in a case of attempted murder, which was clearly as a case as far as the injuries are concerned, in a pure, straight parameters of legal sense, possibly no one would have ventured. But he thought that there is an element of settlement, and the settlement was arrived at because of his initiative. The mediator was Ms. Leila Olapalli, one of the finest mediators in the country. There is no two opinion about it, and she really worked hard. So, today's topic, why I bring this incident and this live incident to you, it has got two reasons. Today's topic is from retribution to restoration. The family which was entangled in disputes, the family which was living amongst each other, and which the tension which came up to have a criminal offense, which my opening batsman Jawad has very rightly said, that the crime is not just an innocuous one all of a sudden. It has got germane something which is deep into it. Those things were resolved. And now I came to know, all brothers are living happily. What exactly, another thing which I take a cue from yesterday's book my friend has released. The title said, if had there been a close watch within the legal framework, nobody would have ventured. Mediation is taking a new steps, thinking out of box. So, but at the same time, there are cautions. It is not just like it that I am taking it without caution, going into it. Because Supreme Court has also cautioned it. All disputes which are germane to the civil disputes, the criminal offenses come. Offenses which are against female, against child, POXO, against public, Prevention of Corruption Act, they should not be treated. But recently I just shared this thought process that one of my mediator friends told me that even a 376, which is a rape, in a matrimonial case against a father-in-law, he resolved it and the matter is possibly resolved it. So I say that matrimonial offenses, that exception could be taken off. With this, I just thank you to the chair and thank you to the organizers. Thank you very much for listening me to me patiently. Thank you so much.
Thank you very much, Mr. Sharma. Let me exercise judicial discretion a little bit. I know that's a concept that is not a very favorite concept with a lot of lawyers. Instead of having a moderated discussion between the panel, let me open this out straight to the audience that has so patiently sat and listened to the panelists speak. If there are any burning questions, observations, and comments, please, we will take them now. And maybe I can bring my panelists back to offer their closing thoughts or closing remarks. And that way, let's try and bring you back towards the lunch table as we move. I see a hand there. Does somebody have a floating mic? Please, could you assist us with that? Pragya? Thank you. And please, as you speak, introduce yourself and direct your question at a particular panelist, or if it's a general one, then that's fine as well. Thank you.
Good afternoon again. I'm Sonia Nigam. My question is to Mr. Jitendra Sharma, sir. Sir, you have told us about the restorative position and that how the crime should also be taken care of before we go to the retribution. And also the intent is to mediate between parties. Especially you have given examples of 376 and 307. My question to you as a lawyer and as a mediator, from the point of view of a litigant or a party is, mediation, should you not think that it should not keep aside the human rights of the parties involved? Just so that we want mediation, settlement, it should not set aside or keep aside the human rights, which in a court, the party would have got justice. After mediation, we say it's a win-win situation. But later on in life, the litigant should not feel that justice is not done. Thank you, sir.
Thank you so much. Are you able?
Yes.
Mediation concept. The mediation concept starts with this, that the parties are independent. They are taking their call. Mediator has nobody to force, or we are not a counselor. We are not counseling. Mediator is not counseling or suggesting anything. He is a facilitator. The parties are taking a call. Now, ultimately, if parties are taking a call, they are conscious of their rights. Conscious of their rights, and despite knowing those facts, as a mediator, you must make things aware. That's your responsibility. But after that, it is parties who have to take a call. And didn't you heard I take at the end of it, what was the yesterday's book which was said? If you go straightway within the parameters of a law, possibly the justice won't be able to there. Both are together, and at the same time, at times they have got a separate way to move on. Law and justice, they are together. There's one school of thought. But at the same time, it has to grow. It has to evolve. So now the justice, you have to find a way out, how to get things done, how to get parties resolved.
Right. Thank you, sir.
Thank you, Mr. Sharma. Perhaps just to add on, we could reflect on the fact that retributive and restorative justice, and I think this will answer your question as well, are not mutually exclusive. The challenge is perhaps the architecture, not the ideology. Where in the criminal justice pipeline dialogue-based mechanisms can be inserted without eroding the deterrence or victims' rights is perhaps the issue. We've said already, punishment answers, what does the offender deserve? Restoration and mediation ask, what is the harm that is required to be repaired? And of course, from our experience now, we are saying, and perhaps seeing in society, that systems that only ask the first question leave the second permanently unaddressed. And I thought I would just share that because it's tying in with what Mr. Sharma said and with the question you asked. Thank you for that question. Please, anybody else, just raise your hands. There is a mic going around.
Thank you, Chair.
Good afternoon. I already have a mic. My name is Lungile Makakula. I'm from Eswatini, and I have a general question. And thank you, Honorable Judge, for the clarification. Mine is on a specific criminal issue, murder, and I want to know how restorative justice would work under those circumstances, because someone has died, someone has been convicted, and families have been robbed of that family member. How would that restorative and restorative justice work under those circumstances? Thank you.
Thank you very much for that question. And again, as we said at the beginning, if you place yourself in the shoes of victims, you place yourself in the shoes of the family or the accused, these are the real dynamics that play out. In the question that you've posed, I'm going to ask Mr. Jawad if he'd like to attempt to speak to that issue. Thank you for the question.
I'll just answer that question by giving you an example that I came across a few years back. It was in the case of a Canadian court that ordered a mediation between the mothers of the victim and the offender. So it was a hate crime that was committed by this teenager against another. And the court said that let there be a mediation between the two mothers. And then they were asked to give their consent. The mediation went on. And the outcome of the mediation was that the victim's mother decided to forgive the boy after she came to understand the circumstances and the environment in which he was brought up. And both of them decided to get together to give the boy a good upbringing so that this repetition does not happen. So the question here is, as the Honorable Judge rightly asked, and I also mentioned, it's not just the question of what is the harm. It's also about what are the circumstances that led to that and who is affected by that and what is the kind of closure that we can give to the victim's family even in cases of murder. Is it just hanging the criminal or the offender for the crime or sentencing the criminal to imprisonment, or does that give a closure to the victim's family, or should there be something more than that? So that is the question I think we need to ask. And as the Honorable Chair rightly said, it's not in every case that may work out. In appropriate cases where the circumstances can be ascertained as to why this crime was committed, what were the circumstances in which this has happened. So I think that is the question that we need to be addressing. I hope that answers.
Thank you, Mr. Jawad, for answering that question. Can we take perhaps 2 more questions? Yeah. I see lots of hands. But I will also direct that this conversation will continue during lunch. There's no such thing as a free lunch, so of course conversations must continue. The dialogue must continue. But please, can we take a question from the lady at the back?
Yeah, my name is Shweta. I am a researcher. Values and emotions are the most important component of any justice system. And when anyone files a case, it's the values and the emotions that derives the filing of the case. In the mediation system, we have got mediators and we have got psychologists and the counselors. In the society, we have got spiritual gurus and the life coaches. If we want to reform the justice system, we have to reform the values and emotions of each and every participant in the justice system. So what are the institutions, formal and informal, in our current justice system that are there or should be there, not just for the mediation, but to reform the entire justice system? Thank you.
Thank you. Do I take that more as an observation rather than a specific question? Because you're talking about institutional capacity and what the state players should be doing in relation to achieving a balance here. So I'll thank you for your observation. Any other questions? There was...
Excuse me. We have Justice Nawaz from Judge of Supreme Court of Sri Lanka. He propagated the Truth Commission on a tool of restorative justice in Sri Lanka. He just wanted to say a few words.
Thank you. Please, we would be delighted to hear from the judge.
Yeah. Well, I chaired a commission. If you look back on the history of Sri Lanka, you would learn that there was a long-standing conflict between the two communities that inhabit our beautiful island. That raged for about 30 years. I won't expatiate on that. There were so many, lots of lives were lost. Whether we should penalize the offenders came from the army, the offenders came from forces which were alleged to have perpetrated these offenses on a minority community. The question arose that some people advocated that all these offenders must be dealt with in a criminal way. Criminal law must be launched. The full force of it must be used against them. I was given this task of chairing a commission. My commission is called the Master Commission of all commissions, and I had to do a survey, and I propounded a truth commission for Sri Lanka to resolve this crisis between the two communities, so that, like it happened in South Africa, victims and the accused can face each other and then resolve this. So my commission dealt with this concept of restorative justice. Instead of dealing with them in a criminal court, let there be restorative justice. So we have moved towards that concept, and it is quite appropriate that today we have this greatest concept being articulated. And I must say that I benefited a great deal by listening to the speakers on this. Thank you very much.
Thank you very much, Judge. Those were invaluable comments, and we appreciate you taking the time to share that with us. Is there any other hand? Are there any more questions? I can see there's one hand there. Maybe let's take the last question, and then I'll ask the panelists to offer their closing views. Thank you.
So my name is Sunita Ojha, and thank you for this wonderful discussion. My question was to Mr. Prashant Barua, and he spoke about what is the Achilles heel for mediator, and that's the lack of power imbalance, the victim's total absolute lack of power, and how does a mediator even bring about an environment where a victim feels that, yes, I can speak. And hearing Honorable Mr. Justice Nawaz talking about truth conciliation actually gave me some clue into that, but I would love to hear what Mr. Barua has to say. How does mediator work towards making victim feel empowered to speak in a situation where political imbalance or the power imbalance is so acute? Thank you.
Thank you very much for that. Prashant, do you want to answer that? No, just do it.
Thank you very much, actually. I just forgot to tell you about one thing, the mediation between former prison guards and former prisoners from Robben Island, South Africa, that did work well. And during Rohingya influx from Myanmar to Bangladesh in 2017, as I was one of the first responders for 9 days, I was showering myself under the rain. And there was also attempt for cross-border mediation between then Bangladesh government and the government of Myanmar. That failed, of course that failed. So in Bangladesh case, the case study I just presented, we expect the state will be encouraged to take the initiative. But problem is, in this part, in this scenario, state itself in the other part of the spectrum. So that's why a regional or international bodies like CLA, Law Asia, and UN, particularly the special rapporteurs, the UN, they are now actively encouraged to intervene positively. Thank you.
Thank you very much for the question and, of course, for the answer. I'm being directed that really we shouldn't exercise your patience any more than we have already. But like I said, the conversation will continue, the dialogue will continue. We're here to explore mediation and how it is used across environmental issues, family projects, criminal justice system. So can I simply thank my very distinguished panel? I think they've all been truly fantastic. Can I thank you all for your attention? You've been a fantastic audience at a very difficult time of the afternoon. And let's just perhaps proceed and declare this session formally closed, and we look forward to further engagement from you all. Thank you all very much.
Thank you very much, the dais and dignitaries and the chair, Honorable Chair. May we now proceed towards the presentation of souvenirs to the respected dais over here. First of all, I would like to call Shri Balkrishna Mishra, the Director, State Judicial Academy, to please come on stage and felicitate Honorable Ms. Justice Abha Patel, Judge, Supreme Court, Zambia. Thank you, Honorable. Thank you very much, sir. May I now request Shri Rahul Chaudhary, DLSA Udaipur, to please come and felicitate Mr. A. J. Jawad, Registrar, IAMC. I'll tell you, sir, I'll tell my wife that my brain is just still evolving, as you said so. I'll tell my wife. I'll also request Mr. Sundarlal Kharol, DLSA Pratapgarh, to please come nearby the stage and felicitate Mr. Prashant Barua. Thank you, gentlemen. Thank you very much. May I request Mr. Nukesh Bhagora, DLSA Balotra, to please come and felicitate Ms. Wimbai Nyamba, legal practitioner from Zimbabwe. Thank you very much, madam. Thank you very much, gentlemen. And last, I request Mr. Vikash Echra, DLSA Deedwana, to please come and felicitate Mr. Jitendra Sharma. You are amazing, sir, today. Thank you, gentlemen. Thank you very much. With this, we end our session now formally and we proceed towards lunch. I'll request honorable judges to please proceed towards dome, which is the left-hand side, and all other participants to please towards first floor, Balochi and Quorum 1 and Quorum 2, and have your lunch. We'll assemble after 1 hour. So it's exactly 3:15 by my watch. So let's assemble at 16:15 hours after this. Thank you very much. Have a great lunch. Thank you. In a while. Okay. Can you start? Yes, no. Yes, no. We have just 5 minutes. Before we start the session, I want to make a small announcement. We found one spectacles on the front sofas. If it is of anybody, I'll request you to please collect it or just let us inform. We will hand it over to you. On the front. Is, beyond disputes to settlements, mediation as the engine of trust in modern commerce. The session chair, I most humbly request Honorable Mr. Justice Arun Monga, Judge Rajasthan High Court, to please grace the dais, sir. On the chair is Mr. Jaideep Gupta, Senior Advocate. I request you also, sir. And our speakers for the session is Mr. Amir Ali from Hong Kong. May I request you, sir? Mr. Patrick Filmami from USA. May I request you, sir? And Mr. Rajiv Datta, Senior Advocate. May I also request you, sir, to please come on the dais. And the coordinator for this session will be Mr. You have to allow us to, first of all, to felicitate our dignitaries on the dais, and then you can take over from us. So we begin with the felicitation. May I request Member Secretary, RSLSA, Mr. Hariom Atri, to please come and felicitate Honorable Mr. Justice Arun Monga, Judge Rajasthan High Court. May we have you, sir, on the stage? Thank you very much, sir. Maybe a round of applause for our... I request Shri Hemant Bhagela, Judge, District Ajmer, to please come and felicitate Mr. Jaideep Gupta, Senior Advocate, the Chair. Thank you very much, sir. Once again, thank you very much. May I request Mr. Vijender Jainji, District Judge, Session Judge Jaipur, to please come on stage and felicitate Mr. Amir Ali. Thank you very much, sir. Thank you very much. Now I request Shri Abhay Jain, District Judge Bhilwara, to please come on the stage and felicitate Mr. Patrick Filami. Thank you very much. And last, I request Shri Baljit Singh Ji, DJ, District Judge Bharatpur, to please come on stage and felicitate our esteemed speaker, Mr. Rajiv Datta, Senior Advocate. May I request Mr. Baljit Singh? Thank you very much, sir. Thank you. With this, now we begin the session, and it's over to you. Thank you.
Thank you, sir. And a very good afternoon to everyone. And on behalf of the Commonwealth Peace and Mediation Conference 2026, it is my privilege to welcome all our distinguished judges, lawyers, delegates from India and outside India, and the members of the bar, the participants of the conference, and participant in the theme of this session, which is Beyond Disputes to Settlement. My name is Siddharth Sejoria, and I'm an advocate and the immediate past chair of the Young Commonwealth Lawyer Association. Today's session focuses on one of the most dynamic and evolving areas of legal practice, commercial dispute resolution. As commerce continues to transcend border, the need for effective mechanism of mediation, arbitration, negotiated settlement has never been greater. This session brings together some of the most accomplished practitioners, judges, and thought leaders from across the Commonwealth and beyond to share their perspective on building efficient, innovative, and sustainable dispute resolution system. It is now my privilege to introduce our panel for today. Today, as a session chair, we have Honorable Justice Arun Monga, sir, a sitting judge of the Rajasthan High Court. His lordships have made significant contribution in the civil commercial jurisprudence. Our chair for today is Mr. Jaideep Gupta, Senior Advocate. Mr. Gupta is also a distinguished Senior Advocate of the Supreme Court, and he is also the Council Member of the Commonwealth Lawyers Association, representing India in the Commonwealth Lawyer Association. Our speakers today include, the first speaker is Mr. Amir Ali B. Nasir from Hong Kong. Mr. Nasir is the Vice President of the Law Society of Hong Kong and founder of the Nasir's Solicitors. He also serves on the Rules Committee of the Hong Kong Court of Final Appeal and holds leadership roles in several international legal organizations, including the Commonwealth Lawyer Association and International Bar Associations. Our second speaker for today is William Patrick McPhillamy, who's from the United States. Mr. Patrick is a lawyer, mediator, and chartered arbitrator based in Los Angeles. He is Harvard-trained mediator with an LLM from University of Cambridge. He is internationally recognized for his expertise in the alternative dispute resolution and has served as a judge and expert assessor for numerous mediation, arbitration, negotiation, and national trial competitions in the United States and internationally. Our final speaker for today is Mr. Rajiv Datta, Senior Advocate of the Supreme Court. He is the country representative for India at the International Bar Association's Mediations Committee. He has also served as the Vice President of both Supreme Court Bar Association and the Bar Association of India. He is also one of the co-founders of the Nivaran body of mediators in the Supreme Court. Now, I would hand over to the chair, Mr. Jaideep Gupta, to please begin the session, sir.
Good afternoon, everybody. With the kind permission of the session's chair, Justice Arun Monga, I'll set the ball rolling. And Justice Monga has very kindly agreed to give his views at the end of the presentations by the three speakers. We all know what mediation is it? Do we? In India, we have two concepts which are constantly mixed up, but are not the same. One is mediation, and the other is conciliation. We have two different statutory frameworks for the two. The mediation is now controlled by the Mediation Act, and a mediated settlement, which is a settlement between the parties, signed settlement between the parties, is enforceable as a decree under that act. On the other hand, conciliation has a longer history, statutory history in India, because it came as an adjunct to the Arbitration and Conciliation Act, and there it is enforced as an award. The role of the mediator and the conciliator are also a little different, as most of you would be aware. The mediator is neutral. He generally doesn't come out with solutions, and he allows solutions to evolve. A conciliator is far more active and suggests solutions, and one of them may be appropriate. So, we are today talking about mediation. Since conciliation is a very similar process, we can talk about it, but provided we keep in mind that there is a little distinction. We are talking about mediation in commerce. It is perhaps the most appropriate dispute resolution mechanism outside the courts for commercial activities, because both parties are expected to be pragmatic and both parties are expected not to have any emotional baggage when they come to the table to resolve a dispute. But we find in this country at least, and maybe elsewhere, that both parties must have something to lose before you can get them to successfully resolve a dispute through mediation. It may appear to some of the parties, particularly a debtor, that there is no reason why he should mediate, he or she should mediate and come to a settlement early. But let me assure you that's not true, because there is a cost of delay, and that cost of delay in today's terms can be extreme. We have had situations where the refusal to settle a matter or the refusal to settle a dispute has led to an enormous liability on the debtor ultimately, and conventional theories of how one can use the legal process to delay resolution are all defeated when they finally find that they have been handed a bill at the end of the day. So there is always something to lose. Or if you are aware of that, then mediation will succeed, because both parties will be equally interested in finding a solution. We also need to understand that while the legal background of a dispute is relevant, the solution in mediation is not necessarily a legal solution. One can find a solution outside the legality of the matter, which is one of the reasons why it is so useful, because a court cannot usually find a solution outside the legal framework. We also know that there are two aspects which make mediation attractive. First of all, the unpredictability and uncertainty which is surrounding legal resolution by courts, and the time that resolution takes in a judicial proceedings. Today, I only wish to point out one thing which I am hoping that the speakers will address you on. In our country, a significant part of commerce is carried on between a private party and a public party. Public party means companies which are either owned or controlled by governmental entities. We find a remarkable intransigence in public corporations or public entities from finding a mediated settlement, because that involves putting a signature on a document. They feel that anybody who puts a signature on a document is liable to be questioned for his decisions, and nobody therefore sticks his neck out. This means that apart from tackling the mediation process, we have to tackle the mindset of public commercial entities. Without this, almost every mediation between public and private corporations fail. I will ask the speakers now to take over, and we want to know from them particularly how a mediation can be brought to a successful conclusion. Because today, every civil proceedings has to start with mediation. You can imagine the huge amount of work that is there in the mediation sector in India today. But it must not be a mere time-wasting tactic. it must be resulting in something concrete. So therefore, we are particularly interested on how you can bring parties to a settlement on the table. With those words, I would like Mr. Amir Ali to start off today's discussions.
Good afternoon, everyone. I'm going to give you, I've got slides, but I'm going to give you two examples of mediations in Hong Kong. And I believe mediation is a function of the mediator, the parties to the mediation, and of course the lawyers. So I've got two stories. The first one, I'm a litigator and of course a mediator as well. I started off life as a litigator. So when lawyers look at clients, those clients that are fighters, we call good clients because they don't back off, and it's good for business. And those who say, yes, I want it, and then halfway say, I want to give up, and they're not very good clients. So I have this good client who is a litigator, and he loves four things. First, he loves business. Second, he loves litigating. Third, because he always goes around town saying, I want this case, I want this case. He just has a fascination. Some people like horse riding, he likes horse racing, he likes litigation. The third one he likes is cars, and the fourth one is not the topic of today's conversation. He copied, following, I don't want to mention the product because of confidentiality, but if I may take what Chief Justice Surikanta talked about, an orange. So he copied this orange in Hong Kong and started producing these oranges. Maybe you can call them an AI orange. So of course, he displayed it in one of the international venues, and the original owner of the orange bought one of my client's oranges and then issued a cease and desist letter in Hong Kong. My client's view was, his orange is different from my orange, proceed with litigation. There comes my duty. My duty is to my client to represent in litigation, his position. If I do not protect his position, then I am negligent in Hong Kong. So I have to protect his position. But I also have to protect his value system as well. So what I suggested to him was, let's mediate. He said the mediation is a fluffy thing, doesn't really understand, no one cares, it's for soft people, not really for serious litigation. I don't want to take a mediation at all. I don't want to consider it. Okay, it's the trust that I developed with my client. I explained to him, look, I have your views, I have your interests in heart, but I would suggest you proceed to mediation. It would be to your benefit. The issue of trust is there. He trusts me. And he said, okay, proceed to mediation. The other party was not interested either, but eventually I agreed to allow them to proceed to mediation. So now we have the client, myself, and we have the mediator. The mediator was skilled, chosen by both parties for his skill. It was an intellectual property dispute. He started off with positions. One party said, this is my orange. Here's the intellectual property rights I have. My client said, these are intellectual property rights I have of this orange. And so the dispute was as to the intellectual property rights. So the mediator then explained the situation, listened to their stories. Initially, each party sent their executive and me as a lawyer, and they discussed those. And the mediator said, I think it's better if the owners of the company appear before me. So eventually they said, yes, come along. And the mediator focused on their business. And he focused on why they wanted this particular product. And they focused on why they dispute the differences between the orange. As the Chief Justice said, he didn't try to slice the orange in half. He looked at the orange as a whole. And what he discovered over a period of 2-3 days was that the original owner had his orange, but he had not been able to resolve a particular issue in the development of the orange. Whereas my client, being an engineer but a businessman, worked out that his orange cured the defect and improved the product. The other party A, this owner, actually was an international company. And the mediator, so the dispute in litigation would have been the IP rights, who has the rights, who has the damages, etc., cease and desist letters. That would have taken a long time. My client did not mind paying $20, $30 million in costs. He said, that's fine, I don't really care. But the mediator said, well, if you, my client, produce this product for the owner, would you be able to consider jointly producing the product and selling it in Asia and the rest of the world? And so he set them off, and they came back, and it was like, I think, over $150 million a year. Compared to $20 million in litigation fees, it worked out $120 million a year on this particular orange. So the mediator found value between the different parties. My client was very happy. He said, but this is quite amazing. You know, he was quite proud that he got it, because his first value was interest. Business. Business is his first value. Litigation was second. His value was always business. And the mediator actually discovered the differences, discovered what their values are, and built on that. And so, although they were not parties, they were able to build value which litigation would not have provided. For my client, who'd be happy, but he felt that the satisfaction of mediation was far more than the litigation buzz that he got. So now he's always asking, is it mediation? Is it possible to mediate? I want a mediator that's innovative. I don't want some boring mediator who just says, what do you think? What do you think? He's looking for somebody who, what's he doing? He's looking at his first value. His first value is, where can I get, business? How can I earn money? That's his first. Second value is litigation. But he's always looking for an issue where there's a dispute. And the first thing he thinks about is mediation. It's very interesting. So that's the first example. The second example is another client of mine. First value business, second value horses, horse racing. That's what he likes. Mediation, I don't want to know about it. So he's a landowner. He had a dispute in relation to land. I said to him, do you want to issue proceedings? Yes, just issue proceedings against them. There were complexities in land law, and I said, let's try mediation first. He said, no, it's too soft. It's for soft people. It's not really for me, And we said, look, okay, to satisfy him, I said, let's issue the proceedings and stay it, and then go straight to mediation. It's okay, I trust you, go ahead, I don't mind. Ultimately, I'll get litigation anyway. So we went ahead to mediation. There was several negotiations, took a couple of days, probably just under 1 week. And eventually, during the negotiation, the mediator said, please bring the owners of the company, which we did. And in the negotiations, the mediator discovered again the value of, this is a land dispute, the value for him to get his land back, and why the tenant was not moving out, and what interests he had. And he was able to resolve that. And then we took the mediation agreement and made it into an order of the court. So it satisfied my client as well and the other parties. And in that one, that was a contractual issue, ownership of land, landlord and tenant of different pieces of land. So you can see how it's very important for a lawyer to participate in the mediation process, in advising the client, not just say, oh, you have your rights. Look at the position of your client and how best mediation can serve the client. The mediator has to really consider the parties' interests and values and work at that level and be innovative to create solutions which are not there within the litigation package. And that's what people are looking for in the world. And for the parties, I think they're satisfied at the end of the day if they get value. And what is the value that they receive is very much depend on multiple factors. And it's the mediator's job to try and find out what those values are. So I'm just trying to see. I'm not going to go into my slides because my slides really highlight, but I'll just go through them quickly. Can you put, yeah, so here I talked about trust building and the cases. Next slide. I've followed on setting the stage by following Jaipur and how they set the stage for the city. Next slide. And of course, the city is set on that stage, or mediation is that process. Next slide. And then how you set up the mediation process should be resplendent for the parties and the mediators because it gives value to them. Next slide. And these are some of the human factors that we have to bear in mind. I'll put arbitrator's perspective if it goes to arbitration. Next slide. And of course, types of thinking that you have to adopt because I spoke to the mediator afterwards and he's focusing very much on the systems that people follow. Next slide. And of course, look at different principles, morals, of course, of the lawyer, the ethical values of the lawyer, ethical values of the mediator, and of course, those of the client. Next slide. And next slide. And so in our profession, we are bound by Rule 2, the solicitor practice rules, and you can see we have these principles. So when a lawyer is acting on behalf of a client, although it's mediation, he should bear in mind his responsibilities on the Guide to Professional Conduct, which is extremely important. Next slide. Next. Yeah, we in Hong Kong have the preponderance of probability for breach of conduct rules. It's not a criminal standard, civil standard. We have a preponderance of probability. Next slide. This is our Court of Final Appeal. Mr. Justice Ma sitting in there. I thought you might be interested to see what our court looks like. Next slide. And next slide, we have mediation by the Law Society. Next slide. Roles of mediation for the different parts. I've already given you that in my talk. Next slide. And of course, trust. Within the system, lawyers, parties, and mediators, important, communicating at the right level. And of course, patience is the key element, as some of the earlier speakers have highlighted. Next slide. The essence of arbitration and mediation would really be looking at the trust of money, time, and motivation, and then looking at cultural diversity. In my example, the first example I gave you was an Indian client in Hong Kong, and the second was a Chinese client in Hong Kong. The parties were Indian and UK in the first one. The second one was Singapore and Singapore Chinese, Hong Kong Chinese, okay, but different languages. So the cultural diversity, although it's Chinese and Chinese, Singapore Chinese is slightly different. The cultural diversities, you still have to take that into account. And of course, human experience and interaction are important parts of mediator. I think I'll stop here because I'll get other speakers time to speak. Thank you very much.
Can I request Patrick to speak?
Good afternoon. When we look at global commerce today, we see an ecosystem of unmatched velocity, defined by cross-border supply chains and instant e-commerce. Yet, when friction occurs, whether it's a factory shutdown, an API failure, or a shipping disruption, our legal fallback tends to be litigation. we rush to litigate, freezing capital rather than deploying it through more productive means in our businesses. In the hyper-intensive era of dependence, trust is not an abstract principle, but is really the currency of commerce. It dictates that transaction speeds, it helps with onboarding costs, and efficient deployment of capital. Today I want to talk to you a little bit about shifting mindset from winning to embracing the concept of engineering settlements. By embedding commercial mediation into contracts, I think we set the stage for an opportunity to resolve disputes at a more efficient pace, consistent with the speed of today's commerce, both supply chains and e-commerce. It gives today we have the Singapore Convention, which also provides a mechanism by which mediation is no longer a soft, fluffy concept or title, but it is really a more efficient, modern mechanism for resolving disputes. Mediation acts as a vital catalyst towards modern commerce by using a structured, neutral third party, a mediator, someone who doesn't have skin in the game, so to speak, to help facilitate resolutions between the parties. It does so, as I said, at a modern pace. It can be initiated at a very early stage of any conflict. It enables the parties to get out in front of a dispute before it gains legs and finds its way into the litigation system, where the litigated case can go 2, 5 years, or even longer. Once within the litigation system, the case really takes on a life of its own, and the parties often quickly lose control. They lose control of the case, they jeopardize important commercial relationships. It can end up costing them more than really what the dispute's worth, and at the end of the day, it could turn out to be really a lose-lose rather than a win-win, which can be afforded by mediation. So mediation really is an opportunity rather than a challenge. It's a chance to, I think, move away from the old way of doing things. Litigation really is, I think, a legacy concept of the past. Obviously, it's something that's used worldwide for disputes, but in a jurisdiction such as India, where you have millions and millions of cases that are backlogged, it really makes sense to at least explore the opportunity of mediation at an early stage. By prioritizing mutual interests over winning at all costs, you really have an opportunity to find out what can work, what can make a situation better, what can preserve a relationship for future commercial transactions and value. So the legal framework of the past century is becoming really less compatible with modern commerce. I think traditional courtroom litigation presents serious bottlenecks, whereas mediation can be convened worldwide at a very, very rapid pace, especially with technology. Online dispute resolution can narrow the playing field considerably. Mediation bypasses legal posturing. It gives the parties an opportunity to go deeper into discussion, an opportunity to communicate with one another, which parties, once in a litigation, often don't realize that they can do. So mediation gives you a chance to actually sit down and talk with the other side, to explore what your mutual interests are, how you can find a shared, I guess, a ZOPA, in other words, a value proposition. So to move forward, to preserve the relationship, and to try to advance your interests while preserving value. I think mediation is an opportunity to transform conflict into a strategic opportunity. I think with a paradigm shift of looking at it not as weakness, but really as strength, as a strategy, as a tactic to see how to come together, how to preserve the relationship, how to prevent the dispute from spiraling out of control and just end up costing time, money, angst, and many, many other things. It really is a driver, I think, of sustainable commerce on a macroeconomic level. It gives the parties a chance to efficiently meet and resolve conflicts. Ways that it can be deployed practically or in contracts. More frequently now, you're seeing tier dispute resolution clauses where the parties have to actually sit down and talk before they commence litigation. There has to be negotiation. If that fails, it can follow up with a mediation, and then perhaps an arbitration. And then if there's a settlement at any of those stages, the mediation agreement can be converted into an award. And you have enforceability, as I said, under the Singapore Convention and under the New York Convention as well. So in conclusion, I think the global trade and digital transactions continue at a very, very rapid pace. And mediation is really the modern tool that can meet that pace. It's consistent with our modern way of thinking, our modern way of doing things. And so by making a collaborative effort, we really have an opportunity to continue to preserve the relationship rather than to destroy it in a litigation. So in effect, mediation is really, I think, the practice that enables us to preserve our most important asset, and that's trust. And as I said at the outset, trust is really the currency of modern commerce. So mediation ensures that all those things are viable, and it's highly preferred, I think, in today's e-commerce and super fast modern commercial environment. So thank you very much.
Thank you, Patrick. May I request Rajiv now?
Good evening, everybody. I am thankful for the organizers to have given me this opportunity to be here and also share a few of my thoughts on the topic beyond disputes to settlement. Mediation as the engine of trust in modern commerce. I will be very simply not delving too much on what is mediation, because I expect that my audience here is fully aware of it and are also some of the leading mediators in this country and abroad. So what I have done is, I'll just divide my speech into, firstly, why mediate and not litigate in commercial world or commercial disputes now in India. The second part will be Now, because of legislation, you must. The option of choosing is now reduced if you have a commercial dispute. We all know that, so I'll come to that. So basically, in an era of defined by global trade, digital transactions, and economic interdependence, trust has become the most valuable commercial asset. As you heard the previous speakers also, why mediation is also important is that it is what has brought about between the parties a sense of trust. This session explores how mediation is reshaping the business landscape by transforming conflicts into opportunity and preserving relationships that drive economic growth. Since yesterday, you must have heard a number of speakers telling you that mediation has not only arrived, but now it has become a necessity. So once upon a time, when commercial disputes which arise from contracts and agreement always carried these clauses, they were riddled in fact with clauses of arbitration and the manner in which the parties could proceed to interpret those clauses in the agreements. I'll at the outset give you a few figures which will drive home the point that how successful commercial mediation has been in India. And in the world we are living today, the concept of disputes resolution is getting reshaped, and instead of the courtroom theatrics, parties are getting more and more inclined towards mediation to solve their disputes. To give everyone a recent example, last year, a little bit of a data here, that last year the Delhi High Court Mediation Center, which is Samadhan, conducted its inaugural mediation drive for 90 days. Within a short span of about 3 months of this special drive, 28,141 matters were referred for mediation in the Delhi High Court and the Delhi District Courts, out of which 4,316 matters were settled and 13,938 matters are still pending for settlement. Out of these 28,000 plus matters, a huge number of matters were commercial in nature, displaying a huge potential for future commercial disputes. So that data itself reveals that commercial disputes which are referred to mediation are taking a lead over other matters for the simple reason that I will now show you that, and when I said in the beginning that mediation is not only a necessity, but it has become a must in India. By introduction of Section 12 capital A in the Commercial Courts Act as pre-institution mediation and settlement, which has brought about a sea change, as the amendment itself said that it is being done to increase the trust which people should have in India and in the Indian legal system. So the simple thing that has been brought about is nothing but time span, and also when you litigate, before that you have to go for a mediation session to solve your dispute. If it is, and time frames are given, if you have an interim relief to be sought, then that can be referred to court first, but then the matter will go back. And all that has been now settled, as Supreme Court has also upheld the validity. So what was the thought behind such an amendment? The amendment was brought in only to bring in trust in the existing commercial world. I think now I'll shift my gear into why is it that mediation also is now arrived at a stage where people are preferring it. For example, if you look at it, mediation, when you go for a mediation or before mediators, both the parties, they get a reality check of what is the problem that they are having, because of which the dispute has arisen. Now that reality check they may not have, even if they have examined their matter in detail. And also, apart from the trust factor, the major part that is being played by mediation in commercial disputes is the confidentiality. Because most of the businesses do not want that if the facts which have arisen, because of which the dispute has arisen, may lead to a public knowledge of where they are not correctly holding a project or they are not proceeding. So confidentiality is another thing, apart from trust, which has come in and made mediation, even if it is necessary, they are very, very happy to do it. Please envisage a situation today if a manager of a company is called to a board meeting where he is asked as to whether in this dispute which has arisen between the company and another company, should we litigate or should we go for mediation? So therefore, what is it that the manager will have to reveal to the board? The basic things which will come up are cost, timeline, confidentiality, nature of dispute. Here, what will work better for the company than litigation or mediation? And of course, since we are specifically talking about India, we all know how the litigation process and how the system works, the litigation in this country. But at the same time, I have to tell you that in evaluation that is being done here, there is a little bit of a setback which has to be looked into. Because you know all businesses and companies and business companies trading or doing business in India, they are all bounded by a lot of law. There are regulatory laws, there is tax laws, and there are other laws. So therefore, if two parties just sit down together and settle a matter, then that settlement will have to go to the regulators. And when it goes to the regulators, they may not accept it. And there comes the pinch. Because if you are to go for a litigation and there is a court order, or if there is a decree that is passed, of course the settlement may later on become a decree, but that has to be followed by the regulator. Then the regulator cannot raise all these disputes. One facet which has really worked in India in businesses is the family business of businesses which are being run in India. There is a very big example of a coffee company in India where the person who was leading the company was brought it to a great, he really developed it very well, and then suddenly, because of his passing away, the whole family came into a disarray. Now this company was almost shut when they went in for mediation, and the mediation and the mediators worked on how that can be revived, and that company is absolutely flourishing today in India. So I think one of the very important thing that has happened because of mediation is protection and saving the business, the family business in India, apart from other businesses. So the other thing which is helping mediation between commercial companies is that it lacks what has been already spoken to, is the emotional aspect. And that's why when, and it's my personal experience, when we go into mediation in matters which relate to personal disputes, the commercial matters lack the emotional aspect. And that emotional aspect many times is a hindrance in solving or settling the dispute. Now let me come to the final thing which I want to bring to your notice, is that, which is another thing that can come out of settlements in commercial disputes, is better synergy with each other, along with better understanding of each other's dynamics, paving way for more business amongst each other, making the whole exercise a commercially viable settlement, entailing more opportunities for growth. It is also noteworthy, now this is something which has come about and we all in India have to take a note of it. Government of India recently has come out with a geo that up to a certain value, the companies, especially the government companies, will not go for arbitration. They will now first try to mediate their disputes. And that is something which we thought was in the mind of everybody, but now it is being imposed as the government itself is removing the arbitration clause from these agreements, which is a very, very major step taken by the government itself. So therefore, it is time now that the business community in India is now, I would say, more than ready to first explore the possibility of mediating and then going in for litigation. As also it has been I think Mr. Gupta very fairly said that without any emotional baggage, both parties are interested in finding a solution. That also is helping a lot. See, there is, and he also touched upon the aspect that the settlement may always not be legal. So therefore, that part of it has to be taken care of. And that I already told you, that there are regulations and regulatory mechanisms in India which you have to sit down and resolve first. Both Mr. Mehta, the Solicitor General, and the Chief Justice pointed out that there will have to be an SOP by the government, because it will have to follow and come out with an SOP where they must now establish as to government, how the government officers are going to take the responsibility, and there should be a public trust developed when they take a decision as to how the matter is to be settled. Now this is another very important aspect. So apart from the fact that mediation has not only arrived, mediation is become a necessity, and now that it is also legislated in, of course, the Mediation Act is there, which I am not going into in detail because you are all aware of it, and the Commercial Courts Act, which has now come out with the final statutory requirement of going in for the settlement by mediation before the matter is decided by the courts. Thank you very much.
Thank you, Rajiv. May I now request the session chairman to give his remarks on this issue. Justice Arun Monga, currently Judge of the Rajasthan High Court.
Well, all my fellow judges from India, from abroad, all the learned lawyers, the delegates, the mediators trained and aspiring to be trained, and all my co-panelists, good afternoon. Well, rather it's evening now. We're running late by 3 hours, it seems. Good evening. And thank you, Rajiv sir, for running us through the legal niceties of mediation. And for you, Jaideep sir, why did I agree to speak in the last? Was I thought one who speaks last will speak the least, with the way it was running late. And there's another reason also, frankly, which the organizers know. I was made to play some musical chairs. I was supposed to do the morning session. Then I was suddenly told, no, you're doing the 2 p.m. So I didn't prepare any speech. But picking up the threads from all that has been said since morning, you see, when it comes to mediation, India perhaps stands tallest on the global scale. Our independence struggle is the best example of that. That was a war, but that was a war which was fought not on the basis of armies fighting each other, through dialogue, through mediation. Our leader, our father of our nation, Mahatma Gandhi. So what did he do? He refused. He says, no, only dialogue, only mediation. He coerced the other side into mediation, into dialogue, and results are there for all of us to see. In fact, it was in this perspective in the morning, Dr. Bhati also gave the examples of how mediation can help us even win wars today. Globally, so many countries are on different parts of the world fighting different wars. And there's a background to why, in fact, Mahatma Gandhi adopted this mediation. When, in fact, translated in Hindi, mediation means madhyastha. In easier Hindi, it's beech bachav. For the delegates who come from foreign, beech bachav is nothing but a dialogue through mediation. So, coming back to why did Mahatma Gandhi indulge from the very beginning into dialogue? He had had about 20 years of practice before he moved to India. And if you read him, he confesses that all 20 years, what he did was nothing but mediation. He settled the disputes. He did not chase the fee. He united the people. And it was this mindset of his which translated into his stubbornness of dialogue. In fact, speaking of united peoples, it not only unites people, it unites your hearts. In the courtroom, you might just win a case. It's very intoxicating for a lawyer to win the case. But those parties one loses never talks to the one who wins. You may win the case, but you lose your relationship. Now, it is in that spirit we must indulge in mediation rather than litigation. Now, mediation also in those countries which are very prosperous, the lawyers are the most paid professionals. It's almost prohibitive to indulge in litigation there. Our friend Patrick from America will tell us. It is in this context that mediation has almost become a must even for the prosperous countries, that before you go for litigation, you must try mediation. In almost every litigation, there's a pre-litigation mediation with the opposite counsels, and then finally, it's almost they threaten to each other. All right, if you don't mediate, we'll go for litigation. And speaking of non-prosperous, well, perhaps we are one example, India. There also mediation helps. And through what mode? Panchayat is one of the best examples. Panchayat is nothing but a mediation. We have it at the grassroots level. Though, of course, for lawyers, it's somewhat strange that they should be treading the path of mediation. That is almost like going to a good restaurant, Michelin star restaurant, the chef saying you rather eat at home. So it's a conflict of interest for a lawyer, of course. We are all in the profession to earn and not to do perhaps social service. Social mediation, though, sounds like, in that sense, a bit of a social service. Sorry, I have to just... So the lawyers for you, next time when you're getting up for a legal fight, whether in a boardroom, in a courtroom, so ask yourself this Gandhi question: are you trying to win or are you trying to unite? You will find the answer. Of course, winning will make you feel terribly clever and also more intelligent than others. But if you unite the hearts, unites the people, that actually makes you have a better sleep in the night. You earn dignity, peace of mind. And it is with this spirit that Gandhi must have lost hundreds of excellent cases in the courtroom. But yet he says that I lost nothing. So may all you lawyers be so spectacularly successful in losing, but yet winning the hearts. With this note, thank you all.
Thank you, Justice Ponga. We do have a little time to discuss matters. Any questions? Yes, Ajit? Who has the microphone? Microphone.
Please hand over the mic to the people
Is
who
there
want
a
to
hand
ask.
microphone somewhere?
Yes.
Ajit? Would you please introduce yourself?
Yes. Good evening. I'm Ajit Sharma. I'm an advocate and record in the Supreme Court. I have two one observation for Mr. Amir Ali and one question for Patrick. Mr. Ali mentioned about this very interesting take on mediation, where two parties have come together and actually ended up gaining from the process of mediation rather than seeking an adjudication of their dispute, which somebody will go to the court and seek X amount of dollars and get X plus interest. But in your case, the two of them worked together and ended up a business which is a lot more than X. So that's a fantastic example, and I think it's something new that I learned. So thank you so it's more of an observation. Thank you. And I think something like that could have come out of a city like Hong Kong, which is where business and commercial interests are so deeply ingrained, and resolving a dispute, keeping business interests in mind. So that's wonderful to note, I thought, and I must mention that. The other question is for Patrick, where you mentioned that where you mentioned issue of trust between the parties during mediation. Now, look, as I understand from whatever little we know, is that often parties will go to the lawyers once there is a trust deficit already that's there between them, and then the attorneys would suggest them, all right, let's institute proceedings in courts of law. Now, what is the practice in US? The moment somebody comes to you seeking legal advice to you not as an automatic response, but you say that before there is more trust deficit, you exchange notices, you send and they reply, and things get much worse. Do you suggest mediation at that very stage before you exchange any kind of out-of-court pleadings, or do you exchange pleadings? Because I think by the time notices are exchanged, there's already a trust deficit. The other party wouldn't want to see the other party's often face or maybe sit across the table with them and let the judge take a call. So what's the normal practice there in US that you've seen? Thank you.
Every case has an opportunity for dispute resolution. It could be arbitration, non-binding, and then if the arbitration fails, the case continues, and then the court would appoint a mediator, or the parties could select a private mediator and then meet with the mediator, retain him, and then proceed accordingly. So your observation is very astute that generally there is a breakdown in the relationship, and there is often a breakdown in trust, and it's undermined by perhaps duplicitous interactions, or just negligence, or just fortuitous circumstances. So I think as a litigator, you have a strategic opportunity to use mediation as a mechanism to try to move from dispute to resolution. Lawyers, I think, explore it at all stages. Sometimes pre-litigation. Generally, the courts require it at least the parties submit to mediation, not necessarily that they have to settle the case, and at least participate in good faith. In my practice over the last decade as an ADR professional, parties, clients will come to me, and generally there is a trust deficit. As a mediator, it's really incumbent, I think, on dispute resolution professionals to try to establish rapport with the parties and to help them to have dialogue and to facilitate a resolution. It's really up to the parties, and if they're represented through counsel, to try to sit down and work something out. So the parties will frequently not have any idea about mediation, and lawyers will often eschew it or even look at it as something lesser, a stepchild of litigation. But I think parties are becoming more and more savvy, especially with conferences such as this and many other ways to educate the public. So the public is becoming more and more aware that mediation is really an opportunity. It's a strategy. It's a way to get from A to Z without the loss of time, consumption of resources, the heavy stress that's occasioned by litigation, and as one of the panelists said, risk. So it's really risk versus certainty. So in a mediation, the parties have the chance through self-determination, through the facilitation of a mediator, to chart the outcome. And as I said, you can win the war and then, or win the battle and lose the war. So I know I mentioned preservation of the relationship many times, but if you have an ongoing business relationship, it's really paramount, and it's in your best interest to try to explore the opportunity to amicably resolve the situation. It could be a restructuring, it could be even a party injecting capital and then changing terms and doing things that a court could never do. So that's kind of my take as a litigator for decades and as an ADR professional.
Thank you, Patrick. Yes?
Good afternoon. I have a question. I'm Advocate Sakshi Srivastav. Firstly, thank you. I would like to thank all the panelists for a very enriching session. So my question is regarding foreign mediated settlement, actually. So we have the Singapore Convention, but a lot of major jurisdictions like India, US, and China have not ratified the Singapore Convention. So what do we do about the enforcement of foreign mediated settlements, right? Because if mediation has to inevitably rely on arbitration, ultimately consent-based arbitration, is there an interim, cheaper strategy that we can advise our clients if we are talking about commercial mediation specifically? How do we go about that? Thank you.
Mr. Amir Ali?
I think the Singapore mediation is very important, but where you find that there is no ratification by a country, mediators generally try to work towards med-up, and therefore you move from mediation to arbitration. And just in the example I gave you where my client didn't want to start, but I issued the proceedings, that proceedings allowed my client to obtain an order in the court proceedings, although the mediation was there, because it's land. You were talking about how do you regulators. So in land, because in Hong Kong, there are tax issues in relation to land. So that's why I issued the proceedings. So I think it very much depends on the parties, the circumstances, and yes, of course, it's not like the New York Convention. If it was there, it would be much more useful. But if it isn't, it's up to the innovative approach of the lawyers, the parties, and the mediator. And that's why I think mediation is so important, because it really requires you to focus on the values of all those three parties, not just the mediator alone. Yeah.
Thank you.
I was only saying that all this process eventually has to be done through the court route. You have to get it declared as a decree, and then you can go for execution. It's not straight away enforceable.
Thank you. Would you like to?
Yes.
Yes.
Good evening, sir. I'm Sonia Nigam. I'm from litigation law firm Karanjawala and Company. My question initially was for Mr. Patrick, but he has already answered. I will request any of the panelists to answer this question. The question is basically, all the panelists have basically said that in mediation, especially in commercial disputes, what is important is trust preservation. And business has to continue, because business has to continue between parties forever, even after the war or the dispute is over. Now, herein where the other side is the state or the government, who is not just the biggest litigant, but also the most difficult litigant, how do you think that this bridge can be, this gap can be bridged when the commercial disputes are, and the business also, the trust is also to be preserved, the business also has to continue. So what is your take? Any of the panelists may answer. Thank you.
Rajiv, would you like to?
I think your question is that in case the one of the parties is state, then how do you enforce mediation?
Yes.
Is that you're saying? I think in that case, well, it's very difficult. As in the morning, we heard Justice Vijay Bishnoi from Supreme Court, you can take the unwilling horse to the pond, but you cannot make it drink. So eventually, I guess, well, the gain is that you try your luck, at least he'll be a little closer to pond, even if it doesn't really agree to drink water. State cannot be forced, obviously. There's no state policy as yet. We'll have to perhaps frame a statute which is in the annual. If it happens, when it gets mandatory, they will also have to do.
So the second question could be to that, just in addition to that. We also discussed, we also heard from the panelist speakers earlier, that the people who are from the state government coming, they are not instructed well to come for mediation. So can there be some mechanism or some suggestions to make it more motivated from the state side with the instructions to at least try mediation? Can that help, sir?
Again, there's some, can you hear? I couldn't hear clearly.
Excuse me, sir. I'll
it's
request
in
you.
continuation of what you said or something.
Yes, yes.
The other party is in the United States. So therefore, have they consent for a mediation? Where will the settlement be enforced?
No.
No.
No, that is his.
Sir, one of the party is government.
So I think Mr. Datta did talk about the SOP. For those here who are from outside India, perhaps SOP is not such a familiar concept. SOP is probably statement of purpose or something like that, which means that you lay down steps by which you will go about doing something. Now, if I had raised this point also in the beginning, the attitude or the mindset of the government sector has to change. This can only be brought about by the government itself, instructing its CEOs that you will not get into trouble if you mediate. Of course, there may be situations where mediation is not bona fide. That's a difficult area. But if it is bona fide, and if people are told by their superiors that you will not get into trouble, and if this is consistently practiced, yes, then over a period of time, if there is an SOP like that which the Chief Justice had spoken of, or Mr. Mehta had spoken of, if such an SOP does come about, then we would expect that the attitude would change. Once the attitude changes, then people will be minded to go for mediation. Of course, we now have the rule that the court can impose a mediation on parties. It cannot impose the solution, but it can say that you must mediate. And that is true even if there is a litigation which has been started between government and another party.
Right. Thank you. Thank you.
Yes, Justice Patel? Can somebody give her a microphone?
Thank you. Thank you very much. This is perhaps not a question, it's an observation, and I think it's to kind of talk to what's happening across jurisdictions, and this is problems that we are all facing. The question raised by the lady at the back, it's something we face at home as well. And I don't know if the answer to this is who are the players in the mediation framework? Who are the stakeholders? Who do we need engagement with? And I think it's conferences like this where we have state actors who are present that take a message back. So for example, many years ago, we had the same problem in Zambia that you could not bring the Attorney General's chamber to a mediation table. And of course, it's party autonomy. So as Judge has said, you can't force a party that doesn't turn up. But the more agitation that is made, the more stakeholders that are engaged, the more awareness that is happening across governments to say, look, we need to be engaged in this process. Because like you said, you can take a horse to water, you can't force it to drink. The thing that I find is lacking, and I know I speak from my jurisdiction, is there isn't a distinct policy. And I think this is where stakeholders need to be engaged. Does judiciary have a policy on ADR? Does the government have a policy on ADR? Do the lawyers have a policy on ADR? Are the mediators trained? Because it's all, you know, what comes first, the chicken or the egg? Do we first capacitate the mediators and then they wait for referrals? Or do we have referrals and then have no mediators? So I think it's a system that needs to speak to each other. And I live in the hope that conferences like this and other engagements will lead to such changes coming, because we can't just live in despair. Why did mediation lag behind? It did become the impoverished twin sister. It shouldn't have. In fact, in my opinion, it should have run leaps and bounds ahead of arbitration, but it didn't. And maybe the New York Convention is one of the causes. And now we must look at the Singapore Convention. And that's again another agitation we should do. How many countries have ratified it? And if not, why not? So perhaps we need to move mediation to an international platform as well, so that it doesn't just get lost in a local dialogue at home. Thank you.
Thank you very much.
Thank you. It is these, conferences, etc., where we bring out these things. And I think in this conference, we had the Solicitor General of India and the Chief Justice of India, both were at tandem. Both of them expressed this. And I'm sure all the mediators know, whenever we sit down for mediation, the first thing we ask the person is, do you have the power to enter into the settlement? No, that is where, and there has to be a watertight compartment. It cannot be that we have mediation, but these things are lacking. So they have to be taken care of, and I think these conferences, as you said very well, are responsible for bringing in these changes.
Thank you very much. I would like to bring the session to a close for the simple reason that the entire process has been delayed, and so therefore we should not take any more time than we are allotted for this session. Thank you very much for the participation, and it's been most instructive. And I thank my panelists and Justice Monga for having given, all of them having given their valuable time for this.
Thank you. Thank you very much, sir. We'll request you to remain seated till the time we complete our souvenir presentation to all of you, sir. So may I request you to please just bear us for another 2-3 minutes. Okay, now I'll call out the names of few people who will come up on the stage. Mr. Ashwini Vij, District Judge Bikaner, to please come on the stage and felicitate Honorable Mr. Justice Arun Monga. Shri Ashwini Vij. I'll also request Shri Anant Bhandari, District Judge Alwar, to be ready. Thank you, Honorable. Thank you, gentlemen. Shri Anant Bhandari to please come on stage and felicitate the chair, Mr. Jaideep Gupta, who brilliantly, answered all the questions and handled this. I'll call. Thank you very much. I'll call Shri Keshav Kaushik, District Judge Dausa. Mr. Keshav to please come on stage and felicitate Mr. Amir Ali. I'll request Shri Rajendra Kumar, District Judge Pali, to please come on stage and felicitate Mr. Patrick Filami. Thank you very much.
I think I saw it last year.
And also I'll request Shri Rajendra Kumar, District Judge Pali, to be ready. Yeah, please. Okay. Shri Mansingh Chundavat, I'll request you to also please come. Thank you very much. Shri Mansingh Chundavat to please come and felicitate Mr. Rajiv Datta, Senior Advocate. Thank you very much, gentlemen. Thank you very much indeed. So with this, we come to an end of session 3 of the day 2. Now we break for tea. It will be a 15 minutes. It's a short break, yes, 15 minutes break. I'll request all the participants and all the member in the hall to please come in time. After 15 minutes, as per my watch, it is 5:35, 17:35 hours. So can we meet at 17:50 hours? Thank you very much. Good evening. through mediation, resolving employment and services conflicts with dignity. For the session chair is Honorable Dr. Justice Shri Pushpen Singh Bhati, Judge Rajasthan High Court. May I request the Honorable to please come on the dais and grace it. Along with it, the speakers for the session are Mr. Jonathan Rodriguez, Advocate. May I request you, please. Ms. Pooja Anand, Advocate. And Mr. Neelmani Gandhi, Ms. Neelmani Gandhi, Advocate, to please come on the dais. Thank you, Honorable, and thank you, the delegates. Thank you very much for coming.
Either ways.
Amit sir, can I have the list of felicitation from you? Amit sir, can I have the list of felicitation from you?
Thank you so much.
Before we begin the felicitation of our esteemed session chair and the guest dignitaries, I will also inform you that for the session, the coordinator is Ms. Sakshi Banga. She is an advocate, she is a mediator. So after I finish with the felicitation, I'll hand over the entire stage and proceedings to Ms. Sakshi Banga.
Hello.
So may I request Member Secretary Shri Hariom Atri to please come on the stage and felicitate our Honorable Dr. Justice Pushpen Singh Bhati, Judge Rajasthan High Court. Thank you, Honorable. Thank you very much, sir. May I request Shri Rameshwar Sharma to please come on stage and felicitate our speaker, Mr. Jonathan Rodriguez. Rameshwar, sorry, Shri Ravi Sharma. I'm so sorry, Shri Ravi Sharma. I'll also request Shri Rameshwar Chaudhary, DJ, District Judge Salambur, to please come near to the dais. Thank you, sir. Thank you, gentlemen. I request Shri Rameshwar Chaudhary, District Judge Salambur. And I also request Sri Shalendra Vyas, District Judge Khairthal, to please come near to the dais and felicitate Ms. Neelmani Gandhi. Thank you very much. I hand over this entire proceedings to Ms. Sakshi Banga. Wish you all the best.
Thank you. Good evening and a very warm welcome to session 5 of the Commonwealth Peace Mediation Conference. I hope you're all feeling refreshed after the coffee break and are ready to get into what promises to be a very engaging session with an august panel. I am Sakshi Banga, the coordinator for this session. I'm an advocate and a mediator at the Supreme Court of India, and a member of Nivaran, Mediators of the Supreme Court of India, an organizer of this event. I'm also a specialist mediator with the Singapore International Mediation Center. Our topic for discussion in this session is workplace harmony through mediation, and we will look into resolving in employment and service conflicts with dignity. Here, to begin with, and to just speak about workplace harmony in the legal profession specifically, as most of us present here today are stakeholders in and custodians of justice. I would just like to refer to what Mr. Harish Salve, Senior Advocate and former Solicitor General of India, said in his keynote address at the unveiling of the portrait of late Sri A.K. Sen, Senior Advocate, last Wednesday at the Supreme Court of India. He said, and I quote, "In this profession, we need to revive collegiality, which was always present at the bar, but which I regretfully see is now dwindling. We lawyers, we live life as gladiators. We thrive in disputes, but we call each other learned friends. As they say, with respect to my learned friend, why do we say that? Never have 3 lies been packed in 6 words. You neither respect nor consider him learned or consider him your friend. Then why do we use that phrase? Because that gives a necessary pause. That is the civility. And that civility is not just a virtue, it's a survival strategy. Because the way we work, cases would end, but our careers continue. Justice can only be served when lawyers are willing to argue fiercely, but then shake hands afterwards. To disagree sharply, but without being disagreeable. The profession could not manage this and would not produce zealous advocacy, but scorched earth, and courts would grind to a halt under the weight of personal animosity if we forget these basic courtesies and these basic virtues." And I unquote. Modern workplaces bring together diverse ambitions, expectations, and pressures. Conflicting goals and priorities, poor communication, personality clashes, role ambiguities, scarce resources, divergent work styles, lack of trust, inequitable workloads, competition, unclear objectives, cultural differences, leadership issues, past conflicts, and external factors can lead to conflicts at the workplace and impact workplace harmony. When conflict arises, can institutions move beyond confrontation toward constructive engagement? This session explores how mediation can foster healthier workplaces, protect dignity, and strengthen organizational culture in an increasingly complex professional world. With that, may I introduce our esteemed panelists for this session. Our chair is Honorable Dr. Justice Pushpender Singh Bhati, Judge, High Court of Rajasthan. We have all heard Lordship's excellent keynote address this morning. Enrolled as an advocate in 1992, Justice Bhati developed an extensive practice before the High Court of Rajasthan in constitutional, service, revenue, mining, education, election, criminal and public interest litigation matters. Elevated as a judge of the Honorable High Court about 10 years ago, on 16th November 2016, Justice Bhati has authored several significant judgments that have enriched constitutional, environmental, service, criminal, and public law jurisprudence. His judicial pronouncements have consistently reflected a commitment to constitutional values, human dignity, and the transformative role of law in society. Presently serving as chairman, Rajasthan State Judicial Academy, Justice Bhati is actively engaged in shaping the future of judicial education and leadership in India. Under the stewardship of Justice Bhati, the Academy has strengthened initiatives relating to continuing judicial education, mediation, emerging technologies, cyber law, gender justice, and capacity building for judges across all levels of the judiciary. Guided by a profound belief that the strength of institutions lies in the continuous nurturing of future generations, Justice Bhati has consistently advocated for a judiciary that is technologically adept, socially responsive, and firmly rooted in constitutional principles. Through institutional leadership and judicial discourse, emphasis has been placed on paperless courts, digital transformation, artificial intelligence, mentorship, and lifelong learning as essential components of a future-ready justice delivery system. A defining feature of the judicial philosophy of Justice Bhati has been the steadfast advocacy of mediation as a means of fostering enduring peace and strengthening the rule of law. A trained mediator, Justice Bhati has consistently championed mediation through judicial pronouncements, institutional leadership, and academic engagement. emphasizing that mediation is not merely an alternative to adjudication, but a civilizational tool capable of transforming conflict into dialogue, restoring relationships, and building resilient communities. Justice Bhati continues to inspire judicial officers, lawyers, and young legal minds while fostering a culture of excellence, mediation, and institutional resilience in furtherance of justice, constitutionalism, and the rule of law across India. Beyond his legal achievements, Justice Bhati is an accomplished horse rider, swimmer, shooter, solo glider pilot, and a parasailer. We welcome you as chair of this session, sir. Our second panelist is advocate mediator Nilmani Gandhi. Ms. Gandhi is a senior lawyer, an internationally accredited online commercial mediator, arbitrator, and the founder of Susamvad Dispute Resolution, a mediation center established in 2018 as Maharashtra's dedicated private pre-litigation online dispute resolution platform. A pioneer in the field of mediation, she is Maharashtra's first woman-trained mediator, advocate-trained mediator by the Mediation and Conciliation Project Committee of the Supreme Court of India, trained in January 2009. Following this, with the support of the district judges there, she played a pioneering role in establishing one of the state's earliest court-annexed mediation centers, which began its journey in a modest tin shed within the district court premises. At a time when court-referred mediation was still in its infancy and referrals were difficult to secure, she proactively leveraged her professional network and engaged with stakeholders to encourage the registration and referral of suitable cases to the mediation center, thereby contributing significantly to the growth and acceptance of court-annexed mediation. From 2010 to 2018, she got an opportunity to be a resource person for the Bombay High Court, conducting mediation awareness programs and training for referral judges across Maharashtra. In 2020, she became an internationally accredited online commercial mediator and arbitrator, expanding her expertise to cross-border and online dispute resolution by CIMI, IMI, ADR, ODR, International London, and IIAM. With around 4 decades in the legal profession and more than 17 years in mediation, she has successfully resolved over 1,200 organizational disputes, helping preserve corporate relationships and avoid lengthy litigation. She has helped Bajaj Finance achieve faster loan recoveries by facilitating the resolution of over 3,000 matters through mediation and the mediation awareness initiatives over 5 years. Her mediation journey revealed that most business disputes stem from weak legal foundations rather than genuine commercial differences. This insight inspired her to expand Susamvad's mission from dispute resolution to dispute prevention. Ms. Gandhi is known to conduct dispute resolution proceedings in 4 languages: English, Hindi, Marathi, and Gujarati. Beyond her legal practice, she is a program leader and mentor for the Women's Leadership Program at Iron Lady Bangalore, where she nurtures and inspires emerging women leaders to lead with confidence and purpose. Her guiding philosophy is, strong legal foundations prevent disputes. Clear contracts build confidence. Meaningful dialogue strengthens relationships. Together, they create sustainable business success and a culture of peace. Our third panelist is advocate and mediator, Ms. Pooja Anand. With more than 3 decades of experience as an advocate in India, she has built a comprehensive career in litigation across several key practice areas, including matrimonial law, criminal law, and arbitration. She's one of the few women lawyers in her cohort to actively practice criminal litigation in her early career. Over the past 17 years, her focus has expanded to mediation and dispute resolution, and she has conducted numerous workshops, webinars, the online series Agree to Disagree, for awareness of mediation. Her work has predominantly centered on advocating for justice in the face of social inequality, wherein dialogue takes it forward. Ms. Anand has extensive hands-on experience working across India and partially in Canada. As a strong advocate for alternative dispute resolution, she has trained advocates nationwide in crucial skills such as legal advocacy, negotiation, and soft skills. Her role as a dispute resolution trainer has seen her conduct extensive training programs, particularly in the realm of mediation, equipping legal professionals with the tools to handle complex disputes with compassion, fairness, and efficiency. In the arena of online dispute resolution, she has acted as a mediator and conciliator in numerous cases, facilitating amicable resolutions that save time, reduce costs, and offer parties a more holistic approach to conflict resolution. Her certification and accreditation from Pepperdine University, Dulles University, USA, Besides, as a negotiation expert from ADR ODR UK, civil and commercial mediator, CMC IMI, semi-accredited mediation advocacy expert, ADR ODR UK has further enhanced ability to navigate these complex issues effectively, helping parties come to a mutually beneficial agreement without the need for prolonged litigation. Ms. Anand's work continues to focus on creating lasting change and ensuring that the legal system is accessible and just for all individuals, regardless of their socio-economic background. She actively advocates for vernacular mediation and community mediation centers to help democratize access to justice for marginalized populations. Her journey of almost 17 years has been from ADR, being alternative dispute resolution, to appropriate dispute resolution. To maintain personal balance outside the courtroom, Ms. Anand engages in gardening, painting, listening to music, and going on long drives. Our final panelist is Jonathan Rodriguez. Jonathan is an international mediation professional with a background in psychology, journalism, and law. He is the founder of PACT, a mediation institute and service provider. He serves as the regional assistant editor, South Asia, for Clue Mediation blog, and hosts the much-acclaimed Mission Mediation podcast, streaming on LinkedIn and YouTube. He consults with the TCM Group, London, on workplace mediation and people and culture. Jonathan has a TEDx talk on the multi-door dispute resolution system, highlighting the immense responsibility of the lawyer in mediation practice. Jonathan is an adjunct faculty at Mediator Academy, Ireland, and ICFML, Portugal, Brazil. He is certified as a civil, workplace, and commercial mediator by NALSA, IICA, IIAM, IAM, PSMA, and TCM Academy. He's the author and editor of Mediation Simplified, India's first interactive workbook on mediation, published by Oakbridge Publishing in June 2023. Jonathan completed his LLM studies in mediation and conflict resolution, graduating with a distinction from University of Strathclyde, UK. He's also published as a contributing author in Conciliation and Mediation in India, published by Walters Kluwer in 2022. He is a contributing author to Mediation Moves, published by Wolfgang Metzner-Verlag. He has also been published by the Asian Journal on Mediation, which is Singapore-based, the New York Dispute Resolution Lawyer, and Scottish Mediation UK. Jonathan has trained over 17,000 professionals and law students across India in mediation advocacy and dispute resolution practices. He has advocated for the term resolutionary lawyers to highlight lawyers excelling in collaborative dispute resolution and helped launch national initiatives like Mediation Championship India, which is an annual event. This concludes our panel's introductions, and with that, I now hand over the proceedings to our Honorable Chair, Dr. Justice Pushpinder Singh Bhati.
Thank you, Sakshi ma'am, for such a wonderful introduction of me, Pooja ji, Jonathan ji, and madam. All the respected colleagues from Rajasthan High Court, various jurisdictions of the world, and also the respected colleagues from the district judiciary, panelists, delegates, and all the participants. It is a wonderful evening. And the topic is very interesting because all of us who are of, say, my generation in law would have grown with the employer-employees disputes, which range from employment, pension, appointments, and various other aspects which employer-employees often deal with. It is often a story of harmony. Continuing with madam's question, sorry ma'am, Karinjwala ma'am, from that firm, I mean, I forgot your name. Okay, ma'am, thank you. It was so well answered that National Litigation Policy and SOP were the answers to your question, but I and Praveer Bhatnagar sahab witnessed a very interesting thing. We both were in a division bench, my esteemed colleague Praveer Bhatnagar sahab. This was a case where the Container Corporation of India and the customs, they were both fighting since 2009. And the reasons to fight was that the custom, wherever custom goes to the inland ports or some of the ports, they establish their facility on a particular cost. And the cost is recovered if their volume of trade is below some level. So the whole case was that in 1 year, 2009, the Container Corporation of India, which is a Indian Railways owned, again, same Union of India, it was having a liability that volume for cost recovery was not meeting in 2009. And rest of the years it was meeting. But since 2009, there was a problem, the exemption was not being given. So here, one side was custom, the state, other side was Union of India. So me and my respected colleague, we told the lawyers, for 1 year you have an admitted position, 2009 you are entitled for the exemption from the recovery charges. Rest of the years it is not there. So you give exemption for the rest and you pay for the rest. So they said, we'll take instructions. They went back. Both were government authorities. They both entered into a mediation of 24 hours. Next day they came, okay sir, you get 2009 whole amount to be deposited, and the other one said, okay, we are prepared to deposit this and go do away with the rest of the liability. So it is not that mediation cannot happen. Mediation can happen in the state. State is a very responsible word. Section 80 CPC, where we all began reading our law, was meant for that, so that every resolution comes when an advance notice goes, when an advance proposition is there. That's how it started. Now, the scope of discussion today, there was a slight tweak in the today's topic because it was the modern workplaces. So we have tried to work on it, and I'll take you, to as fast as I can. So building respectful workplaces, inclusive workplaces is important, preserving professional relationships, mediation for organizational resilience, best practices in workplace mediation. These are the problems. Modern workplaces bring together diverse ambitions. Today, the youngsters, more matured people, less matured, different subjects, this, that. Expectations, pressures, conflict arises. Institutions move beyond confrontation towards constructive engagement. So this is basically our session to explore how to protect the dignity, strengthen the organizational culture, and increase the complex professional world, the efficiency of this. Now, what is required? See, the whole topic is employer-employee. So what does the employer need? Productivity. What does the employee need? His harmony with the service. So the end result is that if they are able to harmonize, there will be, it doesn't mean that there will be no disagreements, no grievances, no dissent, no accountability. No, it will be there. But we'll disagree without dehumanizing. Challenges will be met without destroying relationships because of mediation, and resolve without unnecessarily escalating, and continue with dignity and institutional confidence. This is the modern times where we have to work, because we are coming up with generations which are more fast to adapt, quick in their energies, and they are very quick to understand the system of peaceful understanding, peaceful negotiation. So conflicts are inevitable, not that because there are ambitions, different personalities are there, the question of livelihood, competition is there, change is required, authorities are different from person to person, ambitions are there, so it is there. But dialogue, understanding, and resolution are the ways by which we can find out ways and means to reduce the conflicts. So the workplace and conflicts it could be divided in 6 types of conflicts. It could be an industrial dispute, the employment relationship and industrial relationship. It could be service-related disputes, individual employment grievances. It could be misconduct and discipline, discrimination and sexual harassment, interpersonal conflict. These could be broadly divided into these heads. Now, how do we do it? When conflict escalates, the difference has to be raised to grievance, grievance has to be raised to dispute, and dispute goes to litigation. But this is the process which we all need to avoid. This I found very interesting, that because employer-employee relationship is not mediating, because they are not resolving in time, at stake, in the morning also I said, it is 1.37% of global GDP lost annually. It is a huge figure. It amounts to 10 trillion lost productivity due to these are Gallup figures which have been given for workplace 2026. And the amount of, see, this is not only harmony, productivity. Please imagine that 10 trillion is a big amount, and if we are able to save it through only mediation, workplace harmony, it is always worth it, even if we could attain some part of it. So those are the things which we have to look into. I studied a few examples where they have different mechanisms. So I'll take you to some of them, like for example, Google. So they have some of the key examples in the world to quickly take you through the world scenario. They have managers, they talk, they have human resource people who raise, they have ethics and business integrity reports, they have alphabet helpline if it escalates. And they have access to all these, care for all, act in accordance with law, and investigate if required. This is what Google follows. Now, I also saw after Google, Microsoft is doing something where they listen, then respect, protect confidentiality, and report. I also saw Meta, they were doing it speak up, formal grievance, review, remedy, and that's all. So this is how they were dealing with their disputes, some of the international chains. IBM, they were doing it talk, open door, concerns and appeals, confidential speak up, so on and so. So these are some glimpses of how our employer-employee have been working around the world. I have done some India also. Accenture speak up was also, they were able to do 100% of the concerns reported to HR, legal and ethics helpline were investigated. So 7,79,000 people were involved in this. So this is what they did by fair investigation and escalation of it required. Apple also did it in a manner which was interesting. Talk, resolve, investigate, speak up, learn, act. So these were some key features. Unilever was doing it, resolve, speak up, remedy. Then I saw some Indian, Siemens was also there, dialogue, speak up, respond. We did some Indian companies also. Infosys was doing resolve locally, if unresolved, review and resolve. Then we had Tata Steel, which was doing talk, represent and escalate. We did TCS. TCS was raise, root, redress and close. And they are able to do it. On the right side of each, you will find the success rate also. These are practical examples which I have taken just to understand, so that the house understands that how a different mechanism, but near to each other. Reliance was doing raise, protect, raise multiple channels. And 100% employees were covered by human rights training. So this was a kind of thing which they have adopted. Then after raise, if there was an oversight, they could review and investigate as well. Then HCL was doing raise, track, escalate, appeal. Then Mahindra and Mahindra was doing grievance, conflict, ethics, misconduct investigation, and different types of harassments. Statutory committees are there, independent review was there, dialogue and resolution was there. Wipro was doing workplace concern, ombudsman, review and redress. So each of these companies, as you will all see, they were doing various aspects of employer-employee relationship. All of you remember that when initially Industrial Dispute Act, all of us who were doing Industrial Dispute Act, the first stop was conciliation officer, conciliation proceedings. If it fails, then it is referred. Once the government makes the reference, these respective labor court or industrial courts would decide those disputes, and we would bring an end to by virtue of award. Now the things have changed with the new labor laws in place, but the basic things remains the same. Voluntary arbitration becomes an important component, and judicial scrutiny also remains. So the industrial dispute, we all remember the Trade Union Act, the Industrial Employment Act, the Industries Dispute Act. We have all worked on these sections, particularly those who are cross 50. We would have worked for them all our lives on these laws, on these pedestals, where the mediation, conciliation and all, we did it. But now we have this code, which is on the similar pattern, but a better mode, a more faster mode, a more technique efficient mode. And once we have now the philosophy which continues from the older ones also is to resolve internally, negotiate, conciliate, arbitrate, adjudicate. So we have given it a more progressive structure to harmonize the relationships between the employer-employee. The resolve begins like this. The grievance redressal committees are there. The voluntary arbitration has become a major mode. The adjudicatory journey, it is interesting because industrial dispute, we all see, then reference, then pleadings, then evidence, then cross-examination, and finally the award. So the overall things that looked like was to clarify, enforce, protect, establish and decide the adjudication regarding these employer-employee relationship issues. But adjudication was to be avoided. Industrial dispute crisis became bigger because the pendency was very high, and if a person, a labor or a workman or a person concerned would get the relief after a number of years, it became slightly painful for us, for the society. So that's where we needed to step in, and we could, but by the new laws, we hope that we have, this is an example of the old dockets for reliable companies like Air India, PNB, Bank of India, etc. The nature of disputes has changed. We have to avoid the corporate paralysis. We have to keep the resolution gap and the speed very high. The fairness, recognition, security, respect, identity, and trust are the figures, are the components which we need to take care of while going towards resolution. We also need to understand that what mediation is giving in employer-employee relationship. Because on various aspects, if we hear, clarify, explore, and decide, in mediation, it does not give us the stress and anxiety which normally an employer-employee relationship always carry. So mediation for nation now today are seeing different kinds of drives at High Court, at Supreme Court level, at High Court level, and at various other levels. Since morning we have been talking about Samadhan Samaro, so I will not revisit it. And in service matters also it works. The answer is typically little difficult, but suppose for example there are 500 transfer matters and the government says that we will revisit them. All 500 can go and there can be a revisitation. Similarly, suppose there are 500 suspension matters. There can be a mediation, all 500 suspension go, a revisitation in critical cases. So things like this can carry on, and we can continue to engage in mediation through the law, the authority, the volunteers, the people affected, and the purpose which we need to achieve. So ultimately, the mediation is giving that harmony, that precious harmony which is required for the purpose of achieving that level of satisfaction for employee. So this could be a future with mediation. The grievance, miscommunication, service dispute, harassment, pay, termination, and promotion can end into resolution, restored relationship, continuity, and closure of the issues. So the whole thing is that we need to consistently engage in mediation and also ensure that we try to do it by picturizing the whole topic. We divided it amongst ourselves. So this was the point which had come to my share. But what I could understand, I was basically a service lawyer when I was practicing in writs. And what I could understand is that mediation is, like in the previous session we were speaking, that mediation can be imposed by the court. So even if national litigation policy and SOP is not working in certain spectrum, even if some dimensions, some paradigm, there is something missing which we need to link, then there is always a judicial link-up. That is why our judges are not AI-oriented and AI-generated. Our judges are human beings. They can see where the mediation lies and where the two ends can meet. I'll come back to you again. I hand you over to the next speaker. Thank you.
It was such a crisp one. It was very short and crisp.
I wanted to speak last actually, but Sakshi, who's been coordinating our session so well, said that Justice Bhatti has already secured the lineup and you are going second. So now I have to just follow suit. But what a privilege to be part of this panel. All of us mediators in this room, our patience has been tested, right? It's been a long day, but hey, patience is our biggest virtue as mediators. So let's keep it up. We've got one more session to go. This has been an exciting day so far, a very inspiring day, and I hope you're taking back that inspiration. That, by the way, was a fantastic presentation by our learned judge. So that is like a 40-hour mediator training in workplace mediation, concised in 9 minutes. But yeah, that presentation is gold, by the way. We'll try and get a hang of that. But yeah, that was an excellent presentation. It serves the three of us following speakers. We don't have to go into the theory now. We can tell some stories. And I'll start with one. I was working with a UK-based mediation firm. Some of us in this room might we're familiar with the TCM group run by David Liddell. It's London-based. I spent around 3 years there after doing my master's in mediation in Glasgow. And when I came back, I was very high on workplace mediation. I was like, I'm going to bring workplace mediation back to India, and we're going to do a lot of good stuff. And I was very excited. And I went to meet this general counsel, GC of a very big company in Gurgaon. And I was sitting with him. I gave him my book. And then he said very nice things to me. And in the end, I started talking to him about workplace mediation. And he said to me, it's not going to work. I said, sir, I didn't even start. Like, let me pitch. He said, no, it's not going to work. So I said, how do you, okay, fair enough. I said, how do you handle normally when conflicts come up or there are disputes occurring in the workplace? How do you handle situations right now? And he said, we don't handle them. So I obviously was picking up signs of arrogance, clearly. So I resorted to what every mediator does, ask open-ended questions. So what followed was a 1 hour-long conversation where I tried to understand how he dealt with conflict. And all he kept saying to me is, if at all there is a workplace dispute that escalates, we will make sure that we ruin the person's life. Financially, I am not making this up. I am traumatized by this. I had to take it to my therapist every time I talk about triggers. But he said, we will ruin them financially, socially, legally, psychologically, mentally, emotionally. And for a second, I was wondering, who am I speaking to? Like, right? I left that conversation quite destroyed, to be honest. But there's a happy ending to this, and so I'll summarize. He called me up around 3 weeks ago, not for a mediation. He wanted me to speak to his team about the benefits of workplace mediation. And in this situation, he said he'll bring in the HR as well. So it's been around 2.5 years since I spoke to him last. I was quite upset when I left his room, and therefore I didn't speak to him after that. But he called me up around 3 weeks ago, and he said he would like to speak about workplace mediation again, which means I think the transformation has happened. Right? Some kind of awareness has taken place, some kind of, I would say, enlightenment has come to him where he can now understand the value of workplace mediation. So, see, workplace mediation is no rocket science. We spend most of our time at work besides home, and therefore it is something that we really need to prioritize as a mediation profession here in India. It is a bit unfortunate that our panel doesn't have someone from the HR industry. There's no point talking about workplace mediation without HR, but hopefully when we do this the next time, we'll have a couple of HR professionals with us who will be able to bring in that aspect of what it means and what value it brings to them as people always at the forefront of dealing workplace conflict. So I want to share a very, very quick story about a workplace mediation that I was a part of. It was between a hiree who had just returned from Europe. She had spent most of her education in Europe. She had studied in Netherlands, she had studied in Germany, she had worked in Berlin, and she had come in and joined a big NMC in Delhi NCR. This was around 5-6 years ago. After around 2.5 months of working, there was suddenly a complaint that was filed with the HR, and the easiest thing to do is go and file a complaint under the POSH Act. So there was a complaint that was filed. Luckily, the HR was aware of what mediation meant because this company also had an office in the UK. And the UK is big on workplace mediation. I think it is the only jurisdiction that has got it together. Of course, the US and Australia and Canada and some of the slides that the judge showed us shows the kind of progress it has made in these jurisdictions, but the UK is the flag bearer in terms of workplace mediation, I would say. So this HR was aware of what the value of workplace mediation was. She suggested that both sides, the person who had a conflict and the person who was accused of harassment, try mediation. Okay. After a few rounds of mediation, it came to be that it was a simple incident that took place one evening where the line manager or the manager of this new employee asked this new employee for drinks after work. It was a normal Friday evening, and all he said was, hey, whenever there's a new person who comes and joins the team, we go out for drinks. Would like to join us for drinks? He did that once. She refused. She said she was busy. So he did it again the next weekend, because obviously they didn't do it that weekend. And so he did it again, and then he did it the third time. So when he did it the third time, what happened is there were some other junior employees around who started making comments like, I think you should say yes to him. I don't think even his own wife has rejected him so much. So that was one comment. The second comment was, you have turned him down so much, I think he deserves a date. Two comments. He, by the way, said nothing. He had never said anything. It was the others around who said it. And so that triggered the situation, which went to HR and which caused the conflict. This was obviously shared during the mediation. And she confessed that she actually had nothing against him, but she thought that he was using the others to kind of, approach her, because she had heard rumors about him from other colleagues. So you can understand how deep this is going now. So obviously this case was settled in like 4 hours of mediation, by the way. It was settled, it was sorted out, they shook hands, it was done. Commercial workplace mediation. But what we did after that was more important. We had to fix the workplace culture. We had to fix this water cooler conversations that were taking place, the toxicity in the workplace, the gossip in the workplace. We had to fix their organizational culture so these kind of things don't come up again. So when you're talking about workplace mediation, it just doesn't stop with the situation. It just doesn't stop with a particular incident, but it goes much, much more deeper. I want to end with this because a lot of us think that mediation is a social service. It's not. I charged for this 4 hours of mediation, and I also charged for the next 15 hours of work I did with the team. I work for a UK-based workplace mediation firm. I'm not sure whether I'm allowed to share this, but my company, not my company, my boss's company rather, makes anywhere between 1.5 to 2 million pounds just on workplace mediations every 2 quarters. So there is value in this. It's very structured, it's very clear, it's very defined in terms of what the role of mediation is. The mediators are paid handsomely. The lawyers are paid handsomely if the external lawyers are involved. They also know how to bill. They know how to showcase their services and skills. And finally, it's a win-win for the organization because the HR does not have to spend more money on hiring new people, on training new people, and fixing this kind of conflicts. One last point. I just want to share it with you. I'll wrap up in 30 seconds. All of us are here. Yeah, I will. I'll wrap up in 30 seconds. But now you took away my 5 seconds. All of us are here. We understand the value of mediation. All of us have probably teams of juniors working with us. I see a lot of seniors in the room, so you all have teams. It might be one person, it might be 5 people, it might be 15 people, it might be 20 people, it might be more. You all have contracts with them. You all have some kind of a contract. You have some kind of an employment arrangement. How many of those arrangements have mediation clauses? How many of your contracts or arrangements or MOUs have mediation clauses? If you don't have them, do it today. That is the biggest takeaway you can take from this session. Thank you.
Good evening, everyone. And first and foremost, a big thanks to CLA, to SCBA, and to Nivaran for this wonderful, wonderful international conference. It's been a very, very effective one where we are taking a lot of, there's been so much of takeaway. And I won't take much time because thankfully, Sir and Jonathan have done my bit. So it's going to be a very, very wrapped up kind of thing from my side. And Jonathan and I just had an open mediation where I was the second speaker, but he had a little work, so he said, can I go? So this was live example of mediation. I said, you go second, how does it matter? The very fact that we are having this international conference by itself speaks volumes of how far mediation has traveled from just being an alternative dispute resolution mechanism to a strategic leadership tool. When I say that, conflict is inevitable, whether it's at home, in relations, workplaces, school, everywhere. So coming to the topic of the day, workplace, how many of us sometime or somewhere in our lives have worked with somebody, maybe a grumpy boss who's difficult, maybe a colleague who takes away your credit for the work done, or an employee who just refuses to communicate. Over a time period, those small little things keep churning, till they become voluminous and end up in litigation. I feel somewhere, these are my views, and I'm no, encyclopedia on mediation, just that I have a little more experience than the youngsters who have started now. And like we have the POSH committee, isn't it time that workplaces should have a mediation committee inbuilt to look into disputes at workplaces? POSH is simply agenda-based. But mediation committees can be gender neutral. I mean, where is it written that workplace harassment or conflict is only pertaining to females? They can be to anybody. When we come to this, so I would say that workplace, if the atmosphere, there's an unresolved tension, it just takes away your growth, the organization suffers, and eventually, it's an alarming drop in revenue, which we also call ADR for that particular organization. Now, how do we look into this in the present scenario? The role of the lawyers comes into place. The lawyers of today have to not only look into the legal aspects of a corporation or a company, but also into emotional intelligence, cultural intelligence, and conflict intelligence. Till there is not an amalgamation of all three, the workplace harmony will not be in place, because just by burying it, it just is going to grow like a tumor. We need to take it out of the system so that it just takes away from the conflict. I would just take you to like one or two examples, and I was just noting what Sir had written about, he was speaking, and as Jonathan also said, that was a wonderful treatise on workplace disputes and how to resolve them, and I'm going to borrow it from you, sir. So I'll just give you one or two examples when we talk of workplace. Usually what comes into our mind when we're talking of workplaces, corporations, offices, it happens even on our turf. So when I give that example, first let me give the example of two managers looking for a post of senior manager. And one of them is promoted without the other getting into the same position which was supposed to be his. A problem began, a conflict began, and how he went to HR, said, how can I not be promoted, and how the other person is promoted. So conflict came into place. When the committee was formed to look into it, what simply happened is that I got to know about this promotion from the LinkedIn post. Why was I not informed? Lack of communication. Maybe this thing could have been resolved if he was informed that this particular post is not suitable, so in a week or 10 days or 1 month or 2 months, you're going to get your promotion. This litigation which came into place was avoidable. Coming to our turf, our home ground, lawyers, advocates, our fraternity. Maybe there is a young advocate who's designated a senior. Matters go to him, and suddenly people observe a change in his attitude. He's returning briefs, he's not appearing in the court, he returns the fees, and few of the people who suffered make a complaint. They make a complaint that he is arrogant, he is disruptive, he is changed, he was hardworking when he was not designated, now his ego is becoming bigger than his own self. And they all ganged up together and they said, we need to complain to the Bar Council. Meanwhile, Bar Association came into place and a committee was formed, and he was just asked one question: what changed in you? That question brought him to tears. He said, the day I got my designation, my wife was reported with a terminal illness and she only has few months left. So when I'm returning the briefs, I'm rushing her to the hospital. She needs all the treatment. I have to be with her. So it was not his arrogance. He was grieving. He was in pain. Nobody understood. Why? Nobody asked. There comes the role of a mediator. Our courts take evidence. Parties take positions. The courts are not designated to facilitate conversation. I personally feel, what is the power of mediation? Not just merely confidentiality or it's a volunteer process. The strength of mediation is it allows people to tell the story behind the story. One story is of the perception of people. One story is of the person who's suffering. So when they went out, so many times you have observed that councils will come and they'll say, ma'am, this matter will not be resolved. Party is not interested. The other side is very difficult. But because we go through a structured process, we follow what we have learned from our peers, our seniors, my own trainer, my master trainer, Veena ma'am is sitting here. We have learned and Jawad sir, he has taught me also. So we have learned from them what actually to do in our sessions. And with that patience, we are able to facilitate. Today, workplaces are going to change. AI has come into place. So the need for employees will definitely be less than where they are today. How do we change this place into more harmonious is by having a committee in place, by letting people grow and branch out, by giving them the freedom to communicate wherever they feel that there is a conflict. I think I have not taken more time than I was supposed to. Okay, because Neelmani ji had already told me, Pooja, once you start speaking, you don't stop. So please restrain yourself to less than 7 minutes. So on that note, I hope that a time comes when mediation is given the respect, and I will just end my take on this the way Jonathan said. What started as a very small step towards dispute resolution has today grown. So it is time that we give the respect to ourselves. Please take it as a profession. Please understand the value of mediation. It is saving the companies, the litigants, lots and lots of money. So why should mediators continue with a paltry sum and just say, oh, it is a service to the society? Mediators too have homes, they too need the money, and if I want a lawyer to be a full-fledged mediator, he has to be taken care of financially so that he can run his family. Thank you very much.
Finished in time. Thank you, sir.
Good evening, everybody. Pooja's voice was so energetic, so I have to retain that energy in my speech. And Justice Pukhrajji Bhati, he had Pushpendra Singh Bhati, he had started, the well beginning is the half done. So the job is already done. It is only that whatever is left, we call it as a sheput, that I have to finish. After both of them, my young colleagues who have done their job and who have set a stage, let me finish it, let me move ahead. I will invite and welcome all of you or wish all of you as a peacemaker, peace builder, and all the mediators who are here, who are already learned. And it's not that I'm sharing something extra with you all. You all are aware about this. Just the thing which I have experienced while dealing with the 1200 cases during my journey in 17 years, being a program leader of Iron Lady, being the mediator with the organizations, and organizations have faced some cases, some partnership matters were there, some manufacturing units they are facing, and during their partnership, during their financial adjustments, some criminal cases also erupted. And in that case, no, I had given them a strategic advice. Through the strategic advice, through auditing of the organization, I use this word specifically, auditing of the organization created such a legal foundation through which I have created for these organizations as a conflict-free environment for their business growth. This is done by me. That's why I have a pure authority and authenticity to say that we can create a really peaceful and good environment using the mediation tool. Mediation tool, why I'm saying? Because the anatomy of a business is very different. And in India, we experience it differently. It's not like global platform. In India, we have the family businesses where their seniority and the hierarchy are working. Senior people are leading the business, and when young generation with the AI tools and with the modernization, when they enter into the business, there are the frictions, and because of the frictions, some conflicts may arise, some disputes may arise. This is what we all are experiencing. There are multinational industries, multinational organizations are there, where their working style is different, HR system is there. But some of them, they are the startups, and startups do not have HR, startups do not have any policy, and they do rely, they have the stakeholder management or the agreements with them with the oral conversation, just with the trust. And because of that, even disputes may arise. So let me start with why I'm speaking about this. Because conflict at work is not an aberration. That's what we have spoken, we have heard, and even Pooja also had taken care of that. But it is in the nutshell that frictions are natural. And what is important for us, that how to deal with the frictions, how to deal with the disputes, and how to move ahead. HR know how to do, HRs are trained, human resources are trained into conflict management, but they are not trained into the conflict resolution. And there, our mediator's job comes, and mediators have to take a role to coach them, guide them, or train them. And this is what is my future role, that I am training, I'm coaching the organization to have the conflict-free environments through training the HR, CEOs, CFOs, and decision makers. So if we mediators take these steps, we can move ahead. So let me state, in Indian workplace, because that's the role given by Honorable Justice, that in Indian workplace, we have learned that how to escalate the matters, but we are very slow in resolving that. So understanding the landscape, we need to see why courtroom is not the first stop, but the last. And the mediation should be the first stop. Mediation should be the first accessible tool, it should be in our country. So when we start with the topic, let me open with the sentence that it is not the failure when we are not able to resolve the dispute. Because of the culture or our factory or some factors on the floor which we are not able to understand. I have realized while working with these 1200 organizations that when the notice arrives, dispute does not start. Dispute starts a year long before that. So when it starts long before that, why not we take care of that? We as a mediator, why can't we step in and see that that dispute which is seen in the future can be stopped earlier, can be prevented earlier? And thus I'm working on that before the notice arrives, how we can move ahead. So the question is rather how to hold it, how to deal with this, and how to finish it. I work on this. I love to see that every mediator takes proactive action. Instead of people coming to you, you just start yourself projecting yourself, showcasing that you are available, because people don't know whether mediator are available, mediation system is available or not. And there where I have observed that mediation is not moving faster. We are depending on the court referrals, but start working with the pre-litigation matters proactively, reach out to the people, resolve their needs, resolve their problems, and then see that you are available in the market. People will reach out to you, and you will be able to provide more services than what we are expecting today. So when we see the anatomy of the business in India, in the Indian landscapes, the disputes do not arise the way we have seen in the courtroom. In workplace disputes, we have seen the interpersonal frictions between the personality clashes. People may have overpowering authority or maybe bullying tactics dominating behavior, and because of that, employees may fail a lot, may face a lot, and then frictions arise, and then there are the consequences which we have seen later. Hierarchical conflicts also are there between the managers and the subordinates. Structural conflicts will have, and this one is the under which we have, it is not recognized, but the manager or the HR, if they are trained, if they are coached well, and if they are equipped with the mediation tool, they will recognize that how to deal with this. And if unclear things are there, with the training, with the coaching to the HR's decision maker, that can happen. Right-based disputes will arise. That's what we have never seen in the court, but during mediation we have seen. In workplace, it's also the similar example. Violation of a dignity where POSH committee comes. But the battle is every time battling or dealing with the battle, filing a case or a complaint in a POSH is not going to give the relief. So if mediation steps in, then I think POSH committee, instead of POSH committee, there should be a mediation committee. So ethics and belongings also differ. Everybody comes in a different way. When I speak about the ethics and belongings, I remember just now recently we have seen that Infosys has gone through some litigations in France. Infosys is fined for not having a right kind of a calculating, working hours calculating system. In India, it keeps on going. We say that, yeah, it's okay, chalta hai. And in India, we work more than 7 hours, more than 8 hours. Nobody takes consideration that it is a extra hour work. But in France, it's not so. In France, 45 to 48 hours are fixed. If you go beyond, if any employee works beyond that, then he has to be paid for that extra. But in India, it's not so. I have seen my daughters, they are working and they work since morning 8 and they come home after 8. So 12 hours they are working. Nobody takes the account of that. And this, if it is considered under workplace conflict, then I think tomorrow there will be a peaceful and a harmonious relationship in the working environment. That also has to be taken care. So if these matters, if these kind of anatomy or these frictions or the issues of the disputes taken care well, then there is a benefit, not just like the cost effect and a very faster resolution, but it will save the employees' energy. I have seen that employees are working in a very good, healthy environment when there is a mediation system set well. Because addressing the disputes, if the system is not there, if the mechanism is not there, then employee will feel that I am unheard. If that unheardness is removed, and if they are heard well at a right time, at a proper time, then I think their disputes will be taken care well by the HRs, by the right authority, and by right kind of a system. So considering all this, what it helps or how it works ahead, that outcome of having a workplace mediation or a workplace dignified system which will resolve the conflicts will create a winner atmosphere. Businesses will focus on the business growth instead of focusing on the employees management or conflict management, and it will allow the businesses to continue the business, move ahead faster with speed, because India stands third in the startups ecosystem. And when India is starting third, the startups are so moving fast and they are adopting AI, they are adopting modern technology. In a modern technology, we are facing many challenges. It's not just the workplace harmony or workplace dignity or workplace conflict-free environment. It relates to the hybrid model also. If it is online conflicts are totally different. And if that is not been taken care well by the HR, by the authority, and if they are not trained, then the results, the outcome will be negative. But we are working here to create a very positive outcome, and we are here to see that these people, they are, the organizations or the startups or any businesses, they work in the right directions without having these frictions. It will help them to move faster. I just would like to quote one sentence over here. जहाँ संवाद है, वहाँ समाधान है. Jahan samadhan hai, wahan sukoon hai. And that's why that samvad has given me some instinct when I heard this. Communication really helps a lot. So when we communicate well, even if egos, if we remove our ego and if we have a communication, there will be a very nice pool of mediators. And we mediators together, we can take step, we can find some activity, or we can define some activity through which we will define steps for the organizations and how they can move faster. Organization do not just come out of that. There should be a roadmap. And that roadmap, I would like to focus not only on what are the challenges, how the frictions happen, and what are the causes of the disputes, but there should be some strict, strong roadmap. We are having flaws in our country, though we are waiting for the notifications of our Mediation Act, or some policies are not there on place, and then how to move ahead. And that's why mediation has not taken that pace which was expected. So even in such challenging scenario, if we think of 5 steps bringing on place, that is first, train the managers, train the HRs. It may not be the mediation training, it may be a training wherein they are equipped that what is the mediation, how to deal with the conflict. That coaching, that training has to be there, that can be provided by we mediators. This is the first step. Second step, that institutionalized care intervention. And that intervention has to be done through the trained, equipped manager and the CEOs. But we have to show them that this is the trusted roadmap and you can work on this. So that focus, that step also has been involved, implemented in every organization. Third is the mediation clause has to be, as rightly said by Jonathan and Pooja, this care I take every time. Whenever I draft an agreement, I make sure that along with the arbitration clause, there is a mediation clause. And that mediation, in first step, mediation should come, then arbitration, and then if it is not resolved, then the last resort is the courtroom. So that's why first and foremost step, that's what I said, that is mediation clause has to be there in every agreement. It's not just the employment agreement, it's the role and responsibility of whatever kind of a performance you are fixing the performance there also, you have to fix this mediation clause in everywhere. Create a genuine psychological mindset. We have to create that environment, and we are the pioneer, we are the forefront, and we are the torchbearer where we can ourselves project and propagate that this is the safe environment, and changing their mindset takes place when the awareness grows. So working on that for grievance redressal, then also wherever we find such an opportunity, please take that step and move ahead by creating awareness. I had gone to HDFC Bank to get empaneled as a mediator. But then HDFC Bank did not give me that chance because already one of my colleagues is working over there. So I just told him that, can I get a chance to send a notice or send an invitation through which I can create awareness? And just by taking such a small step, 300 matters are resolved. So we can take such proactive steps without anybody asking you or without having any empanelment. You can do so. You are the change maker. Just believe in yourself and start creating that. The last one is that normalizing mediation as the normal system, like how in USA we have that system that before going to a court, USA makes sure that mediation happens. So can we do that? Can we start propagating like this, that mediation system is available first, avail it, and then move ahead? So with this, I would say that Susamvad se, not only Samvad, Susamvad, and uske saath, can we create a harmonious workplace? Thank you for giving me this opportunity.
Thank you very much, Honorable Chair and esteemed panelists, for a most enriching session. We'll take a couple of quick questions, please, from the audience. We're running short of time, so just a couple of questions. Yes, ma'am, over there, please.
Yes, madam. Somebody could give her a mic, please.
Thank you very much, sir. I'm very happy to see that the topic of POSH has been mentioned over here in the discussions. I'm from Hyderabad, district local committee member in POSH committee. I'm Dr. T. Subhashini, practicing advocate as a High Court. Here my question is, we get a lot of complaints from the employees. There is a clause under Section 10, before the inquiry of under Section 11, we can go for the conciliation. But here I can see that mediation can also be taken off. So whether we can do it as a committee members or we have to refer to the third party as a mediator, we can take it into consideration.
Am I audible? Am I audible?
Yes, yes.
All right. A mediator is always neutral third party, cannot be interested party, cannot be an employee of the same company, has to be a neutral third party. Otherwise, there'll be a bias, there can be a prejudice. Even if it is not there, it'll be seemingly so.
Yes.
So mediator always has to be, and so is the conciliator, but there's a slight difference. A conciliator can suggest, a mediator cannot even suggest.
As a conciliator, the district local committee is taking care of for conciliation also. But as a mediator, because they are the trained persons, so district local committee can refer to the third person who's a neutral, or whether we can take up directly, because we are also trained, because we are committee members. So
as long as you are neutral, you can take it.
Okay,
No
that's
issue
fine,
about
sir.
that. Next question,
Thank you.
please.
With permission from the chair, may I just add to this?
Yes, yes,
this
please,
one?
definitely,
Since
madam.
I am a member of the POSH Committee of the Supreme Court of India, the GSICC, I'd just like to add that under Section 10, the conciliation provision, what we've done at times is when we constitute the ICC, usually a 3-member from the larger GSICC, there have been times when we have included a mediator as an addition to the ICC constituted to help us and aid us in the conciliation process, right? I mean, Mr. Rakesh Khanna, I think, is present here, senior advocate and mediator. We have engaged his services as well at times. So we can also do that. We add a mediator to the ICC panel, sometimes 2 if needed, so that if it's an odd number, we always have a majority, you know, even though this doesn't require a decision, but we prefer it to be an odd number committee. In conciliation, that's not necessary, so it can also be a 4-member panel, and we usually get them on board and have a mediator assist us in the conciliation process. Thank you.
It also adds to one more point, which I noted last week only, that the international community which had gathered on UNCITRAL 60th this thing, they were quite discussing the intersectionality between conciliation, mediation, and arbitration as well. So intersectionality is there, so that has to operate. We'll go to the next question.
Yes, ma'am over there. Sonia? Yes.
Yes, ma'am.
Go ahead.
Pooja ma'am, this is for you.
Yes, please.
We had done a mediation under you at Karanjawala. I'm Sonia Nigam, Associate Partner Karanjawala, also junior of Nanni Gore ma'am. So there was a matter, there was a very big real estate corporate house in a PSU, a 10-year long decade issue was going on, and very beautifully and effortlessly you had helped us resolve. Our clients were very happy. Now the question to you ma'am is now taking from it from here is that, now since we are lawyers and we need to have this confidence and comfort to tell our clients that if we tell them that you can go to mediation, this is for my understanding, ma'am. Is there a way out to know that there are subject-specific, field-specific, or issue-specific expert mediators, especially now when we have these contract labor laws, also when there are amendments in the labor codes, that they have this trust that, yes, it won't go to a mediator who's only doing family dispute, matrimonial disputes. So this is for my understanding.
Sure, thank you so much. And I was getting worried when you talked about a matter which I did. I thought maybe I was not able to help and mediate effectively. So thank you for putting my fears to rest. See, litigation is not the first step of conflict. It's like an autopsy of a conflict which rose much before the legal notice came into place. So the relationships have already gone for a toss. And that's when litigation, that's not the first step. That's like, you know, as I said, we're already dissecting the body. The autopsy is being done of various small little disputes which have become a conflict. Now coming to your question, We are reaching there. That's why I said, and Jonathan also said, we need to understand that mediation is a profession. We need to understand it's not service anymore. There only we'll have a construction expert, a matrimonial expert, a banking expert mediator, an insurance sector. If I do not know the laws only, I don't even know if there is a Hudson book of construction which I need to refer to for understanding what's gone wrong where. So we need to know that whether the mediator has the knowledge. Today, I personally, if a tax matter will come to me, I'll recuse myself. I hate to do anything with numbers. I will not be comfortable doing it. But how many of us are doing is a question. Yes. Why mediations do not go ahead? Because we need to have domain knowledge. Yes. Domain knowledge is very important for a good, like sometimes a matter comes and then we say, oh, that person doesn't understand ABC. Why? Because that person does not have the requisite domain knowledge. Once we take this mediation as a profession, once we understand that there's an expertise involved, things will evolve, but we're taking baby steps, but we will reach there, don't worry.
Thank you.
So you can also now join the gang as mediator and then become an expert.
Halfway through.
All the best.
Thank you.
Yes, sir.
Last question, please.
Yeah.
Yes, yes, sir.
Hand raised.
Yes, yes.
Sure.
Hi, Anil Changrath from Singapore. Just a couple of quick things. If you remember the fundamentals of mediation, it is about getting two parties to move away from their positions to the interests. Substantially, that doesn't have anything to do with domain knowledge. All right, it has to do with trying to get the parties to try and resolve that. Right, so sometimes domain knowledge can be dangerous. I sat with a co-mediator, a judge, who does construction matters or contract matters, and he insisted the matter should be settled by way of looking at the contract. The mediation fell apart, but at the end of the mediation, the parties wanted to approach it differently, a suggestion that I had made at 10 a.m. in the morning. And they came back to mediation. So that's point number one.
Sir, may we have the question, please?
Right, sorry, no, it's just...
I'm so sorry, we're running short of time.
Okay, my apologies. So
then we'll go to ma'am, we'll take the last question. If you don't have a question...
Oh, no, the question is, so domain knowledge is very important for the mediation. And are there skills, are there people trained in those domain knowledge in mediation?
So can I just come in quickly in 10 seconds?
Sure, Jonathan.
I think if there are two employment lawyers involved in the mediation, they already know their domains very well.
Perfect.
So I agree, in that case, you would need a process expert. Yes. But say it's just the parties involved and they don't know their rights and they don't know the law, then it's good to have a domain expert mediator. So the right answer is it depends.
Depends.
And let the lawyers take that call.
Thank you.
We can have one more question.
We'll have the last one.
I'm
Yes.
Sarita Lal, and I'm practicing in Madras High Court, and I'm a next mediator there, and also a part of POSH committee in one of the companies. So just to, for the clarification, I just want to know that now that you have said that in the POSH you can also make the use of mediator. Now the POSH and conciliation both are governed by different provisions, statutory provisions, and there is no mention of mediation in section 10. So if we take a mediator or do a mediation, won't we be going beyond the scope of the statutory provisions?
See, conciliation is always, I'm sorry, I think
Please,
it's
please,
addressed
yeah,
as
anyone
me.
can answer, yes.
It's always at the insistence of the aggrieved woman under the POSH Act, right? So we're just aiding her, whether as a POSH committee, the ICC members, or with the help of a mediator. That is just an assistance that we're requiring to ensure that the process happens the way it's supposed to. That is all.
Yeah.
But otherwise, ultimately, the decision lies with the aggrieved woman, whether to accept, let's say, her expectation may be a simple apology, right, or a reprimand that she expects the ICC to sort of do towards the respondent. That is for her to accept. If she doesn't accept it, the inquiry proceeds. The ICC has to proceed with the inquiry.
Because conciliation also is only on the consent of the aggrieved woman.
Absolutely. As is mediation. Mediation is also a voluntary process.
Yeah.
But here, under POSH, the power is only with the aggrieved woman. whether to explore conciliation or not.
So it is like, you mean to say that I need to tell the aggrieved woman that there is a provision of mediation,
Yes,
conciliation, and then...
yes, if she is not aware of the provision, then the ICC does have the responsibility to educate her about it.
Yeah.
But ultimately, the decision to conciliate or not is up to her.
Thank you.
Thank you, ma'am.
So Sakshi, just to
Yes.
sum up in a short, I'll take it, madam, even though there is no provision in that, you can have a consensus with the members, ICC members, committee members, and you can ask the party who has applied for, who is a complainant. With her consensus, you can start with mediation.
Right, and with this, I declare the session closed. We shall have the formal mementos.
Thank you very much. May we quickly have this roundup of, souvenirs. May I request Shri Vikrant Gupta, District Judge, to please come near the dais and felicitate Honorable Dr. Justice Pushpendra Singh Bhati, Judge Rajasthan High Court. And also I will request Satyanarayan Taylor, District Judge, Shri Sunil Pancholi and Shri Satyanarayan Vyas, all three district judges, to please come near to the dais so that we can quickly round it up and we can proceed to the last session. So first is Shri Vikrant Gupta, District Judge, to felicitate Honorable Dr. Justice Pushpendra Singh Bhati. Thank you, Honorable. You had a fantastic presentation that you shared with us also in time. Thank you very much. Thank you, Honorable. Mr. Satyanarayan Taylor. Please, Mr. Jonathan Rodriguez. Shri Sunil Pancholi. To Ms. Pooja Anand. Thank you very much. And lastly, Sri Satyanarayan Vyas to felicitate Ms. Neelmani Gandhi. Thank you very much. With this, we come to the end of the session. Thank you, Honorable, and thank you all dignitaries of the present. Thank you very much, sir. You had a very fantastic presentation you've given to us. Now, the last session is soon to commence. I hand over to Grishma Sharma ji. Please come on stage. Judge, Supreme Court of Sri Lanka. May we have you on the stage, sir? And the... Good evening, sir, and please welcome. Thank you. May I also request Mr. Joe Tirado from UK as one of the panelists over here? Mr. Joe Tirado. and Mr. Vikas Singh, President, Supreme Court Bar Association, Mr. Rishabh Gandhi, Advocate, and Ms. Nandini Gore, General Secretary, Nivaran.
Good neighborly relationships.
The coordinator for the session will be Ms. Manjula Gupta, Advocate and Mediator. I will request Madam, just let us do the felicitation and then it's all over yours. Thank you, Honorable, thank you, gentlemen, and thanks, Madam, for coming on the dais and gracing the dais. We now begin with the felicitation, the first round of felicitation. I hand over it to Grishma Sharma. May I request all to be please seated, sir? Madam, thank you very much. Please be seated, sir.
Honorable Mr. Justice A.H.M. Dilip Nawaz, Judge, Supreme Court of Sri Lanka. Respected speakers, Mr. Joe Tirado, Mr. Vikas Singh, President, Supreme Court Bar Association, Dr. Nandini Gore, General Secretary, Nivaran, Coordinator of the session, Ms. Manjula Gupta. Honorable deliver them through collaboration, dialogue, and consensus. Before handing over the session to our coordinator, we shall first proceed with ceremonial felicitation of our esteemed dignitaries on the dais. First of all, I request Sri Arun Beniwal, District Judge, to kindly come up on the stage and felicitate Honorable Mr. Justice A.H.M. Dilip Nawaz, Judge, Supreme Court of Sri Lanka. नहीं sir, बिल्कुल नहीं sir, नहीं. Now I request Shri Sanjeev Mago, District Judge, to kindly come up on the stage and felicitate Mr. Joe Tirado.
Tirado, lovely name in my view.
Sanjeev Mago. Now I request Ms. Renuka Singh Hooda, Judge, to kindly come up on the stage and felicitate our speaker, Mr. Vikas Singh, President, Supreme Court Bar Association. वो आ रहे हैं. Now I request Ms. Shweta Sharma ji and Ms. Savitri Anand ji to kindly come up on the stage. I request
Ms. Shweta Sharma and Ms. Savitri Anand, please come near to the dais.
I request Ms. Shweta Sharma, Judge, to kindly felicitate our speaker, Mr. Rishabh Gandhi.
Okay, this slight change of name, may I call Ms. Rashmi Arya? Thank you, madam. Thank you for being in the hall.
बस एक लास्ट हाँ श्वेता शर्मा जी की जगह आ रही है नंदिनी अब नंदिनी जोड़े जी को करना I request Rashmi ji to kindly felicitate our speaker, Dr. Nandini Gore, General Secretary, Nivaran. Thank you, Manjula ji. Now you may continue.
Thank you very much, Mr. Anurag Bharadwaj.
Thank you very much, madam. Wish you all the best.
Thank you. Good evening, distinguished ladies and gentlemen. And first of all, I would like to say thanks to you, and I appreciate your patience that after such a long day, you are still here to listen to our esteemed panelists and all. And I really appreciate that. Now, I'm Manjula Gupta. I'm advocate on record in Supreme Court, and I'm practicing for last more than 3 decades as an AUR. I'm a trained mediator also, associated with Supreme Court Mediation Center. Now, it's my privilege and honor to welcome you all to this prestigious session of CPMC and on my behalf also. I extend my warm welcome and heartfelt welcome to all our esteemed panelists, distinguished delegates, and learned members of the bar and the bench, mediation professionals, and participants from across different places. Your gracious presence has added immense value to this conference, and we are truly honored to have you with us. I feel honored to introduce my panelists, and I'll first introduce Justice A.H.M. Dilip Nawaz, who is the session chair of this session. Justice Nawaz is known for his specialization in commercial, transnational and criminal law, public law, and international law. A British Chevening scholar and a Fulbright Humphrey Fellow, he graduated from King's College London and Washington College of Law, American University with merit. His international legal exposure includes professional stints at top US law firms and such as Enrolled and Porter. Justice Nawaz recently chaired a commission that recommended a Truth and Reconciliation Commission for Sri Lanka and is often invited as a distinguished speaker and adjunct lecturer of law at several South Asian jurisdictions. In 2011, he was recognized as the top South Asian academic in international humanitarian law at an international competition held at the National Law School of India, University, Bangalore. Before being elevated as a judge of the Court of Appeal, Justice Nawaz had been functioning as a Deputy Solicitor General in the Attorney General's Department and represented the Republic of Sri Lanka in several domestic and international cases and arbitration in several constructions contracts. Justice Nawaz represented Sri Lanka as a council such as the Southern Expressway arbitration, which was between Japan and Sri Lanka, and the water supply infrastructure project, which was between Sri Lanka and Australia. He carries 3 masters in law and holds an LLB from the University of Colombo. Now, I welcome Mr. Joe Tirado, who is an independent international arbitrator, adjudicator, expert, determiner, conciliator, accredited commercial and investor state mediator, and ADR consultant based in London. He has over 35 years of dispute resolution experience, having held global leadership positions in leading firms from 4 major jurisdictions, UK, US, Illinois, and Texas, and Spain. He has handled hundreds of cases in more than 70 jurisdictions with a combined total in dispute of over US 10 billions. He is a solicitor advocate with full rights and audience before all civil courts in England and Wales, a CEDR accredited commercial and investor state mediator, a civil mediation council fellow, a former ICSID conciliator appointed by the president of the World Bank Group 2018 to 2024, and a panel member of a number of leading invitation-only arbitration and mediation panels, including the European Union and the United Nations. I welcome Mr. Vikas Singh also. Mr. Vikas Singh is an eminent senior advocate practicing in the Honorable Supreme Court of India with standing of over 35 years at the bar. He is the president of the Supreme Court Bar Association, the post he is holding for the 4th time. I welcome you, sir, here. He has been the Additional Solicitor General of India from 2005 to 2008. Notably, Mr. Singh was appointed as a special prosecutor by the government of NCT of Delhi in the high-profile Abu Salim trial. He is perhaps the only lawyer associated with 3 significant temple cases in India: the Ayodhya Ram Mandir, the Guru Ravidas Temple in Tughlakabad, and the Bal Yogi Sri Sadanand Maharaj Ashram in Maharashtra, winning all 3. His contribution to the field of law and public life was significant. Mr. Singh has also been a visiting faculty member at the Indian Parliament, delivering lectures to foreign delegates on topics including legislative drafting and legal education. Beyond his legal career, Mr. Singh is dedicated to social causes also. As the chief patron of the Delhi Foundation of Deaf Women, he is committed to supporting children with disabilities. He actively promotes the education of girls, emphasizing that educating a girl means educating a family. He is also the patron of Tamanna, an NGO founded by Padma Bhushan awardee Dr. Shama Chona, which has been doing exemplary work with special needs spastic children in Delhi for nearly 4 decades. Additionally, he serves on the board of trustees of the Sai Temple in Greater Noida and is devoted follower of Lord Tirupati, whom he visits annually since 1989. In recognition of all his outstanding contributions to the field of law, Amity University conferred upon him the Doctor of Laws LLD honoris causa on 12th of November 2022. An avid tennis player, Mr. Singh represented the International Lawn Tennis Club of India in a tournament at Wimbledon in 1999, hosted by the International Lawn Tennis Club of Great Britain on their 75th anniversary. Apart from all this, Mr. Singh is also very kind to the legal fraternity persons. Whosoever is in need of that, Mr. Vikas Singh is always the first person to come and offer his help to them. And I really appreciate that. He has a multifaceted personality, I'll say. I welcome, sir. Now I welcome Mr. Rishabh Gandhi. Mr. Rishabh Gandhi is an advocate, arbitrator, mediator, and former trial court judge. He is the founder of Rishabh Gandhi and Advocates, a dispute resolution and commercial law firm with a presence in Pune, Mumbai, and Bengaluru. His practice focuses on arbitration, commercial litigation, with a particular emphasis on construction and infrastructure disputes, real estate matters, and complex contractual claims. He regularly advises business developers, institutions, and other stakeholders on dispute avoidance, negotiation, mediation, and effective dispute resolution mechanisms for large commercial and infrastructure projects. He also serves as an arbitrator and mediator in institutional and ad hoc proceedings. Now, Ms. Nandini Gore, she is an advocate on record at the Honorable Supreme Court of India with practice spanning over 3 decades. She is a senior partner at Karanjawala and Company, one of India's premier litigation firm. Ms. Gore holds LLB and LLM from Campus Law Center, Delhi University. She has also been conferred with an honorary doctorate degree in law and mediation. Her expertise covers the full spectrum: litigation, arbitration, corporate law, and mediation. Her work has earned her consistent recognition. She is ranked by Chambers and Partners Asia, listed in Lawyers World Premier 500, and is a recipient of so many awards like Prominent Women in Law Award, Leaders in Law for Commercial Litigation and Mediation, and 100 Inspiring Women by Fox Story. Law Asia has also named her an elite legal practitioner in corporate law. What truly sets Ms. Gore apart is her leadership in mediation. She is an accredited mediator with the Supreme Court Mediation Committee and serves on its panel also. She holds an advanced certification in commercial mediation from the Ministry of Corporate Affairs and is accredited by international mediation bodies. She is also a senior trainer with MCPC. Apart from that, Dr. Gore has authored 2 seminal works, Handbook on Mediation and a commentary on the Mediation Act 2023. She is a global voice on ADR, having spoken at conferences all across. Beyond practice, she has served as Secretary of Supreme Court Advocate on Record Association and is currently Vice President of Mediators India and General Secretary of Nivaran. She is a distinguished Fellow of International Academy. She has other qualifications also, which if I'll start reading and I keep reading, it will take so much time. So in one word, I'll say that she is the best combination of beauty, brain, and smartness. I welcome you, Dr. Nandini Gore. Now, everybody knows that today's topic is building nations through consensus. I just asked Justice Nawaz, what is your opinion about this, sir? Please enlighten us on this. Yes, building nations through consensus, sir. Please, sir, come.
Good evening, ladies and gentlemen. It has been always a stationary sitting, so I love to stand before you and expect some to file motions for a passover. But anyway, this is the word that I heard recently in the Supreme Court when I was there. As we are about to ring the curtain on today's Peace Mediation Conference, I will shed my thoughts on this topical topic that is engaging our attention. I'm going to give you 2 examples which help me shape my enthusiasm and my thoughts for mediation as the best tool of adjudication. And of course, when I was invited by Mr. Santanakrishnan and heard this topic of mediation, my thoughts went back to the famous king, Ravana, from whose kingdom I come. A profound, I don't need to repeat it, there was a profound wrong that was committed by him, and there were diplomatic efforts by people like Angada to have Sita return and resolve the conflict. And that did not take place, and the inevitability of the war followed. This historical nexus between Sri Lanka and India, it shows how in ancient times, we had this concept well ingrained in our history, shared history. So therefore, it's not surprising this has existed in ancient wisdom, and we should adopt it as a full measure for our education. That's a thought that came into my practice when I was appearing for Sri Lanka as a counsel in a famous arbitration, an ICC arbitration that took almost more than 2 years, that concerned a beautiful expressway. I don't know whether Mr. Santana Krishnan, who makes frequent visits to Sri Lanka, has ever done that on that southern expressway which goes from Colombo to all the way to the southern tip of the island. That expressway we contracted with some Japanese contractors, the state of Sri Lanka, the Republic, and initially Sri Lanka proposed a two-way carriageway, but then we wanted to have it converted into 4 lanes. So the contract was entered into. As a result of that contract, they were dragging their feet on the contract, on the completion of the contract, and by the time they handed over the road, fully completed, almost 4 years had elapsed since the date of completion that was stipulated in the contract. As a result, in this infrastructure project, suffered delays, transportation became difficult, and they themselves, the Japanese themselves, took us to arbitration because there was this arbitration clause. Arbitration was like virtually an English court. The chairman was a QC from England, and we had a Sri Lankan arbitrator, and the Japanese had an arbitrator again from the UK, and I had to virtually sleep at the hotel. I was given a room, and it was such an arduous task doing that massive arbitration where we were being sued at that arbitration for delayed handing over of the project. We were also being sued for designs which we later on changed from 2 lanes to 4 lanes. And thereafter, we also had this extension that had to be given to them. All this came out in the arbitration. So when I looked at it, I found in the arbitration clause we had formulated a dispute resolution mechanism prior to arbitration. That was under the famous contractual arrangement, the FIDIC. You go before a dispute adjudication board. If you go before the dispute adjudication board, that board had rendered a decision which was not enforceable by them, but they were dissatisfied, and then they issued the notice of intention to go for arbitration. So under FIDIC, as you know, the decision of the first tier dispute adjudication board becomes final unless the contractor gives a notice of intention to proceed to arbitration. So all these were rephrased. Arbitral tribunal in such a situation doesn't sit as an appellate body. It sits virtually as an original dispute resolution mechanism to go into the dispute. At that time, I thought to myself how well mediation could have saved this delay, could have saved a lot of money, and we could have definitely resolve all these issues prior to arbitration. As you are probably aware, or as most of you know, most of these contracts involve multiple parties. The contractor will have another subcontractor, that subcontractor will have architects, and then it goes down, there is a chain that you will have right round. Because of this, delay occurs. So finally, because we didn't have a mediation clause in the arbitration clause, we had to pay heavy cost. And in fact, the arbitral tribunal held against us. And that was despite the robust defense that we put forward. Come to Singapore today, 40% of their construction contracts are in the domain of mediation. They hardly go for arbitration. So this shows the utility value of mediation, and that defeatist feeling, if I may put it that way, that disappointment that I had about the non-consensual negotiation we failed to have with the Japanese, that led me later on to innovate in my judgments mediation procedures and mechanisms. So I virtually carried this experience into the judgment. Recently, when I decided a construction contract dispute, I found the contractor, the builder, had not signed written contracts with the apartment owners. When the apartment owners went into the building, now as you know, Colombo now is dotted by condominiums all over. And when they found that the contract, what was promised in the brochures, had not been met by the builder, they sued them. And it came up in appeal. Then I ordered mediation between them, between the builder and the apartment owners. Instead of, I appointed even a committee to go into this and report. So even when a case is pending, a judge has to be activist in ordering mediation, and that will pave the way for peaceful settlement. So these are two thoughts that I thought of sharing. One acquired when I was a counsel, and the other which I used by way of my experience that I had in that case into a recent judgment. That judgment is today rated with pardonable humility, I must say, a landmark judgment, where I brought in the escrow arrangement and I also mandated that all builders have to have written contracts. And there is also another aspect to it. Some of these apartment owners, when they go into the apartments, or rather before they are handed over their apartments, the time has passed and some of them want to get out of this contract. They want to recoup their money, which was invested on a project which did not materialize. In such a situation, there was no arbitration clause, so I innovated that there has to be a mediation between the parties. So mediation has come to stay, and today it has assumed greater proportions in the landscape of disputes, and my panelists are going to shed their experience and wisdom into this discussion. And I would first invite that great friend of mine, Mr. Vikas Singh, whom I met in Delhi some time ago to be the next speaker, then I will have you share some of your thoughts on this. Thank you.
Good evening, friends. Today's topic, or rather this whole conference which is planned in Jaipur, I think it's a very, very important subject which governs the litigation sphere, so to say, and this success of mediation in this country can be a game changer as far as tackling the pendency of cases in the country is concerned. Because in a court system, as we all know, there are only hierarchies. You may win at the lower court, then there is an appeal, then there is a review, then there is a further appeal, right till you go to the Supreme Court. And recent examples of even matters being decided by the Supreme Court have not attained finality. We've seen review petitions being filed, a curative petition being filed, and curative being allowed. So really speaking, it's an endless process which keeps the litigation engaged, which keeps the parties engaged, and parties have to sometimes wait for their lifetime or maybe the lifetime of their children as well to get the fruits of their victories, so to say. Now, litigation, the mediation in infrastructure is a very interesting. I chose this topic when Mr. Santhanam said that if you'd like to speak on any of these subjects, I chose this topic because I think this is a very important subject as far as nation building is concerned. When a very sick man goes to a hospital, a wealthy and sick man goes to a corporate hospital, what is the feeling of a management of the hospital? That we'll have to have more people attending him. We will have to cure him, but he's having multiple problems, so we'll have to have more number of tests, more number of stay, and huge billing for the corporate hospital. Similarly, when a large infrastructure project gets entangled in litigation or gets entangled in a dispute, and when two law firms are engaged on both sides, the feeling, apart from the genuine feeling of wanting to get this issue resolved, is also that this will be a lot of business for the law firm. Now, if you are looking at a dispute purely from the angle of a law firm or even an individual lawyer or even a senior lawyer, that this particular dispute can fetch me huge amount of revenue in the years to come. Just imagine a matter going in for arbitration, Section 9, Section 11, then the arbitrator is appointed, then interrogatories, and then endless cross-examination, and the hearings go on, and it's an endless process. By the time the arbitration ends, a dispute of a high magnitude, or 3,000-4,000 crore dispute, ends up paying something like 200-300 crore as litigation fee. I am reminded today of this very interesting dispute between Amazon and the Future Group, the Reliance, where they got an award for 1 billion Indian rupees. And while executing the award, there was so much difficulty that after filing for the execution, ultimately it was settled for 100 crores, 1/10 the amount which was awarded in the. The power of mediation is that it can heal relationships immediately, put a quietus to litigation, and the project goes on. Whereas the downside of not going into mediation is that the project gets delayed, lives of so many people who are supposed to be working on that project gets completely disrupted, and it becomes a gold mine for the law firms and the lawyers. Unfortunately, in the world today, there is no way by which you can give a success fee or a percentage of the claim to a law firm because or to a person who's supposed to mediate a dispute. Because the moment you agree for a success fee, you actually are in a way impairing the neutrality of the mediator. The mediator becomes an interested party in the dispute. Now, how to resolve this issue? Because unless we are able to find a way to resolve this issue, in my view, mediation will not be very successful. There are so many stakeholders with their own diverse interests involved in the dispute. If I have a problem, I am the owner of the infrastructure project and I depend upon a particular law firm who has been doing my work for a long period of time, I will go by their advice. If the other side has a similar law firm, they'll go by the advice of their own law firm. And if the two law firms are not ready to sit together and find a middle path, there'll never be a middle path. But the best way to ensure that there is an attempt to find a middle path is to incentivize mediation. Let us admit it today, and we can't, although we say the legal profession is a noble profession, and in fact, the small bag that you have in your gown is supposed to be the fee that your client is supposed to pay to you without your knowing what he's paying to you. That's how originally this fee of a lawyer had started, but unfortunately that's not true anymore. Legal fees have gone up very, very high, whether it be a law firm, whether it be individual lawyers. And invariably, the people who are handling the cases are, because they are the best in the business, and that is why they are handling that particular case. So they definitely have the wherewithal to find a solution if they genuinely want to. Now, interestingly, very interestingly, although there is no success fee for a mediator, which I'm not a regular mediator in the normal sense. I do mediation without being a trained mediator, but it's more of an informal kind of a mediation where people have come to me and have tried to solve their problem. But mediators should be paid a success fee. And very interestingly, Supreme Court in the recent schedule that they have announced for mediators, they have included a success fee. A normal mediation you get, supposing if you get 10,000 rupees, if you have a successful mediation, you get 20,000 rupees. It's not a question about numbers, but it's a question of paying a higher amount for finding a solution. It is for incentivizing mediation. Now, I was just thinking aloud while sitting there, and my friend, Honorable Justice, talking was from Sri Lanka. How do you incentivize mediation without losing the objectivity of a mediator? Because the whole purpose of not giving a fee relatable to the value of the dispute is to retain his objectivity. One method could be what the Supreme Court has done. If you are supposing before the dispute starts, if the parties can agree that this dispute will result in instead of per appearance fee is fixed and it will have 20 appearances. And if the dispute gets settled immediately, then at least the person can be paid those 20 appearances, which could be a predetermined fee. This is just loud thinking. I don't know how this can be made, because there are Bar Council of India rules which talk of not taking any share out of the profit, but then the moment you structure it as a share out of the profit, you are in trouble. But if you structure it as a fee for what you have done, by virtue of the fact that what could have been otherwise achieved in 20 sessions or 30 sessions has been achieved in 2 sessions, then why not pay him that 20 session or 30 session, which has saved time, which has saved cost, which has ensured that the project goes on in time, which has also ensured that people are not thrown out of their jobs by virtue of the project getting delayed. Just imagine a highway project. There are thousands of workers engaged, and in a situation like India, you will find workers coming all over from, I'm from Bihar, mostly Bihar workers you will find working all over the country. Even on a highway in Jammu and Kashmir, you will see thousands of workers from Bihar coming and living in those small hutments. And suddenly tomorrow they are told that this project is not running anymore. Just imagine the plight of those workmen who have come thousands of kilometers away from their homes to find a living for themselves and being told from tomorrow there is no work. We have labor laws to take care of all that, but to appreciate that whether a small laborer will be able to go to a labor court and get justice in the manner in which he should get is also a very daunting task. For him to engage a lawyer to get the protection of whatever is his entitlement from the large corporate house who is running this project is also not an easy task for him. So you are, by virtue of a mediated settlement, able to ensure that this disruption does not happen. The cost overrun does not happen. A project which starts at 1,000 crore because of a dispute which may last for another 3 or 4 years ends up 3,000 crores. 2,000 crore is the additional cost only because of the cost overrun. We have to find ways and means to ensure that a genuine, proper mediation is so well properly incentivized that both the law firms who have been seeing a particular case as a money spinner for the next couple of years for them are able to take out that money by a settlement at the start of the dispute itself, rather than wait for billing for years to come. Actually, these are conferences where we must, rack our brains and look at solutions, because these are the solutions which in the long run will ensure that mediation picks up in this country. If my lawyer is not advising me that there is a middle course possible and the other side's lawyer is also not advising him that there is a middle course possible, there is no middle course possible. The matter will go to litigation. I was sitting with Justice Bansal here from the Jaipur High Court a little while ago. One way to ensure mediation is if the judge who is handling the matter forces a mediation. That's the most effective mediation, because he has the power of the pen to decide one way or the other. If he can make the two parties understand that, look here, this is how I may decide this side or I may decide that side, the parties will immediately think of finding a middle way out. But judges, by their normal work, are so overburdened to get into a dispute with so much of attention leave their normal work to try and get into this dispute in this manner and to get it done is almost impossible. We see on a daily basis that there are matters where, in family matters especially, because there are human lives involved and miseries involved, judges do take out time to meet the parties in the chamber and try and find out a solution, and many a times they are able to find a solution as well. But that kind of attention is not possible to be given in all the matters which come before them. We have several amendments in the, so for instance, in the Specific Relief Act now, an injunction cannot be granted in an ongoing project by virtue of that amendment to the SRA. The legislative intent is very clear that we should try and see that there is least disruption of an ongoing project. But in spite of the legislature making it very clear that there should be least disruption, still we all know that projects get held up. We all know that projects, if they go into litigation, take a huge toll on the project itself, apart from the toll that it takes on the lives of the people whom that project ultimately was going to benefit, whether it be a power plant, it was going to supply power, if it was a road project, it was ensure connectivity, if it was. So that is one aspect of mediation which I think is very important as far as getting a mediated settlement in infrastructure is concerned. The second important part of mediation in infrastructure will be on environmental clearances. Environmental clearance invariably have a public hearing where public is called and their objections are taken. But most of the time the effort is to find out whether their objection should be sustained or whether the project should be allowed to go on. The effort at the time of a public hearing should be to understand the core objection of the people and see whether the project can be suitably altered to ensure that these people who are worried for a particular reason, that worry can be taken care of. And if that approach is that approach at the time of public hearing or at the time of understanding what is the locals' problem, why they don't want this project to come up, what is their real reason that this, unless of course many a times we know that there is some hidden reason where some competitor of yours is pumping up these locals to, which is of course also happening, but most of the time it is actually the public who have a problem. So those are also cases where if you are alive to the problem of the local people who are the real affected people in the project, and if a mediation happens, a pre-mediation happens at the time of approving the project itself to take care of the problems of the local people, I think that also will be a huge step in ensuring that projects, infrastructure projects, go on smoothly and there is no disruption in the project. I had actually prepared a long note, but seeing the way that the whole session has been delayed, I think I'd rather leave it at that, and I would be happy to do a question answer at the end. But the theme that I want to bring out is this, that there has to be incentivizing of mediation. There has to be more pre-mediation deliberation as far as infrastructure is concerned. And it is only if that happens that as far as infrastructure project is concerned, mediation will play a very meaningful role in national development. Thank you.
Thank you,
Mr. Vikas Singh, the President of the Supreme Court Bar Association. So having listened to our discussion so far, I think it quite appropriate that we will have some international perspectives. Mr. Joe Tirado, may I now invite you to share your thoughts on how mediation is reshaping as itself as the best method of dispute resolution.
Namaste. I was expecting to say good afternoon, but obviously we're way past that time. Good evening to you all. It's wonderful to see so many of you still here, awake, listening. I think you should all deserve a special certificate for the most engaged and hardcore audience, and it's good to see you being so enthusiastic. Well, obviously, many thanks to the organizers for the invitation, especially my good friend Santhan for the invitation to be here. It's wonderful to be back in Jaipur. I was last here 25 years ago, so it's been long overdue. Great to be here in this splendid venue. It's been a tremendous occasion, and I think if nothing else, if there was any doubt, what we've learned today is just what a broad church mediation is, the different subjects that we've covered. And it's not all of them by any means. And in fact, what I was going to do is slightly add an additional one, if I may, using the topic that we've been asked to talk about, which is building nations. And I wanted to talk about nations and the role of states and state entities in mediation, which people forget is a very important part, and there's no reason at all why state and state entities should not be using mediation. And we need to remember that, of course, both engage in commercial activities, and particularly in infrastructure disputes, and you will see that the biggest docket obvious in most institutions of arbitration-related work is infrastructure of one form or another, where the government itself or a government entity is involved. Clearly, when you're dealing with a state, it's probably more under a treaty that you may be looking to bring a claim against them, but nonetheless, it is quite feasible to bring mediation. And what a lot of people forget that, of course, when we're looking at investor-state arbitration, the origins of ICSID in the Washington Convention was conciliation, which it's a term of art. It is slightly different from mediation, but the whole aspect of dealing with disputes with states involving investments was to be resolved through conciliation. Not arbitration. We saw this huge explosion in the beginning and the end of the 90s and then early 2000s, and then arbitration seems to be the default method. And there have been a handful. I think my last count when I looked at the ICSID statistics, I think there's something like 17 cases in its 60-year history that it's had conciliations. Astounding when you think that that was the basis that it was introduced, that the idea, when you think of the cost involved, we all complain about the cost, clients often complain about the cost. If there's a universal factor of the delay and cost associated with commercial arbitration, well, you're talking at least double, 3, maybe 5 times the amount of money when you're dealing with investor-state matters. So there has to be a better way of dealing with it, and there has been initiatives for the last 10 years or so focusing on doing exactly that to try and, I think, shake us all into trying doing things a bit differently. And I'm going to put a little caveat here because maybe it's a sign of me getting older, but I'm getting a little grumpier as I get older, and it's probably going a bit off piece because it's going a bit off the harmonious theme of our topic. But I get extremely frustrated, and if there's one thing here I think if we could probably all agree on, there is an element of frustration in the room that, as Jonathan, I think, said, this is not rocket science. It really isn't, and yet it's such a difficult sell for mediation around the world. It's not an India problem, it's a global problem. There has been, I say this recognizing the huge progress that there has been in the last 25 years or so that I've been involved in mediation, particularly in my home jurisdiction in the UK, but all around the world, we are beginning to see things move. COVID, bizarrely, was a major game changer in terms of encouraging us to do things differently, and I think in seeing a bit of a renaissance in mediation around the world, including here in India, of course. And all of that is a good thing, but I am frustrated that it is such a hard sell, and I think we need to do more. I'm sure most of us, if not all of us here, are taxpayers, and I think we should and expect more from our state entities to do more when they represent us. So instead of engaging in these long, protracted, expensive arbitrations, they should be looking, they should be obliged to be looking, and there needs to be far greater transparency. Part of the problem is there isn't the level of transparency that's required. Because at the end of the day, it's our money that's getting paid, that has to pay for all of this, whether through external lawyers and the opposing party in circumstances that just make no sense. And when you're talking about infrastructure projects, of course, what you're looking for is they are perfect examples where mediation is appropriate, because you have ongoing relationships, you have other contracts in play. It's the perfect type of case for mediation. Certainly you might argue, well, it's more complicated, isn't it, when you involve state entities? The answer is yes, it is, but that's probably an even bigger argument for using mediation, because inevitably when you're involved in an arbitration or a litigation, you're talking about a bilateral kind of scenario where it's you win or you lose. There is no middle ground, and often there's, even if you get the proverbial splitting the baby, it's far from ideal. Whereas I think in a negotiated settlement, having done this for over 35 years, I genuinely think it's the best outcome. And the closest, I mean, we all have our own sense of a definition of what justice is, but ultimately I think it's what the parties define it to be. And if they're happy with it, and presumably they are, it's the closest they come to being happy in inverted commas, when it's a negotiated solution that they themselves have created with the able assistance of a all importantly, of a skilled mediator, then I think that is definitely worth looking at. I mean, there are complications, there are issues about structure, but you can make culture needs to come in, corruption issues need to be dealt with in terms of transparency, but I certainly think we should be looking far more, and there was a little momentum after COVID. ICSID introduced new mediation rules. It's kind of gone a little bit off track again. There's an initiative to try and push it back again. I'll be speaking later this month in Singapore and Singapore Convention Week, where there's another attempt to try and push the investor-state mediation. And I implore everybody to kind of not ignore that aspect. And as I say, it's a bit esoteric when you're talking about the treaty stuff potentially, although very common these days. And certainly on the commercial side, one sees it a lot. So that's what I was going to introduce, if I may, by focusing on the building nation side, as I say, not forgetting that aspect, which is yet another aspect of the advantages of mediations. In many ways, I don't think I need to repeat the advantages. We've heard that said many, many times, but I think, as I say, that's the basis of my frustration, because it shouldn't be such a hard sell, and inevitably it is. And I implore, particularly here in India, there is real momentum pushing forward to keep that momentum going, because I think that when it starts slacking, people will start getting even more frustrated and thinking it's not going anywhere. I think all I would just say is be patient. It takes time. It's a cultural shift we're looking at, and when you're talking about cultural shifts and mindsets, these things don't happen overnight. You can impose it, and one of the interesting things we've seen is the introduction of mandatory mediation across the world, including in my home jurisdiction, which I initially had a real issue with, and our Honourable Chair just whispered in my ear about something about having judge-imposed mediation. And for me, that seems like it's a contradiction in terms. You know, there's a clear tension there when you're imposing something that's supposed to be consensual on parties. But I think we have to be realistic as well, that while a purist might think, well, it should be that way, and we've been focusing on trying to, the right way, cajole people, persuade people to accept mediation, there is a benefit to the public purse of having mandated mediation, because even though the success rates are lower, they're still pretty impressive. Something like 50% of cases that go to mandated mediation, and these are kind of global, general statistics, admittedly, but it's a universal constant, will settle. Well, if you can get rid of half of your caseload, in most cases, there's a real benefit there
So I've become more persuaded, and often I think it's more of a gentle introduction. You just have to show you've tried once, and I think this is where the judiciary can help people introduce the concept of mediation. But candidly, clients tend to be a little bit schizophrenic. They say one thing, they complain about the cost and the delay, but often they're the ones that are putting the barriers in the way for you to proceed forward. And it's very difficult as counsel, certainly, when you want to suggest an alternative, not to be seen or potentially judged to be weak. They've come to you because they've heard you're a great litigator, arbitrator. They want you to win the case. And I think our focus with this whole cultural, what I've called the industrialization of disputes, has been about winning, not resolving. And I think there is a subtle difference there. Because even when you win, you often don't recover all of your costs, and you may have lost the relationship forever. Whereas I think when you resolve a dispute, it's far more creative. The ability to focus on interests, as we heard earlier on, rather than rights, opens a real box of possibilities, not only for settling the settlement that's right before your very eyes, but one that's just coming down the road, and some that may be even there you've not even anticipated are coming, can be incredibly beneficial. And I would kind of just end with this. I think it's at the end of the day, we all can agree that life is very uncertain. And so one thing, even with the strongest case, you don't know you're going to win in an arbitration or litigation. So you reduce that, you remove that uncertainty of litigation uncertainty by having a negotiated settlement. And even when you win, you've still got to enforce it, which again is a real problem. And in mediated settlement scenarios, the risk of non-compliance is significantly reduced. We've had a huge promotion of the Singapore Convention in international settlements, which is, in practical terms, perhaps not as needed to be implemented as necessary, but it's one obstacle less for people not to consider it. So I think that addition of certainty and enforceability is another added factor. So for me, I just can't, as I say, in one way I argue against myself, because of course I love the thrill of as counsel, and I sit now almost exclusively as arbitrator. The thrill of the battle and the intellectual debate, but it's not about me, it's about the parties and helping them resolve their dispute. So with that, I think I'll wind up now so that the next speaker doesn't have to start off saying good night, but thank you for your attention, and thank you for indulging this grumpy old man.
Thank you, Joe Tirado. I hope the audience would have found him quite invaluable. Now, I, of course, have to turn to Rishabh, Rishabh Gandhi, the young man who does a lot of work in arbitration and mediation, and we would have your thoughts on this.
Good evening, everyone, if I may say so. We have, throughout the day, we have had multiple sessions. We have discussed how Krishna mediated in Mahabharata. We have discussed how Angad mediated in Ramayana. We also discussed about Kautilya's Arthashastra stating Sama Dama Dhanda Bhed, and we also discussed Panchayat system. Apart from that, we discussed mediation at workplaces, in family cases, in criminal cases, in corporate cases, etc. But when it comes to infrastructure or construction disputes, it becomes a little difficult, to be very honest. Because construction disputes or infrastructure disputes are differently designed. Because, first of all, in most of such projects, there is a government involved, there is state involved. So it's a public-private partnership that is at play. That is one thing. Secondly, there are multiple parties. For example, if there is a highway construction going on and the land acquisition is to take place, then there is a contractor to whom the contract is given who has won the bid, then there is a subcontractor, and then there is government. So there are multiple parties involved. And suppose there is a dispute. The dispute may be about land acquisition. The land was not acquired on time and not given to the contractor for completing the work on time. At that time, the landowner has his own grievances. the contractor has its own grievances, and the government wants to finish it off within time. There are multiple claims. There are EOT claims, there are variations, then there are prolongation costs, etc. involved. In such circumstances, I have observed it becomes very difficult to mediate between the parties. And why I say so, we have heard a lot of success stories today and yesterday. We did not ponder much over that. Let's talk about a few failures also. I'm going to share 2 failure stories from which we'll understand, as far as this particular topic is concerned, infrastructure and construction disputes, it's not a straight road for mediation. One is an example. I was representing a client, a Spanish company who was into manufacturing of cranes, traversers, and train coaches. And it was a long-drawn contract. And in Spain, COVID was declared a little early in comparison with India. And therefore, the cranes and traversers were imported late in India, and thereby the contract was terminated, etc., which is normal course of action, how it happens. Now, in this particular case, there were subcontractors, contractors, and there was a government body or a state body. Arbitration started. During the arbitration, since we have med or ABMED, so a proposal was made, let's send it to mediation. The matter was sent for mediation. Surprisingly, for the mediation, the person who used to represent one of the sides, who used to come to arbitration in each and every hearing, did not appear, did not come. He had the authority. Instead of him, he sent a junior, or he deputed somebody else to the mediation meeting. Why did he do so? It's a very important question. He thought that mediation is just a formal process. It's a formality to be completed with. There's no need I should go there. Maybe there was ego in between playing somewhere. So there we requested, ask that person who has the authority to come before the mediator, let's actually mediate the matter. Then eventually, after 2 hearings, 2 sessions, he came for the mediation. What we came across was ego, which may have been attributed by us as ego. Maybe it was a fear, because the officials, especially state officials or government officials, have got this fear in mind that if I settle this dispute, or if I settle through mediation, there's possibility eyebrows would be raised. There's possibility somebody would later say that there was something backhand done, there was corruption involved, etc. So with that reason, somehow, after some sessions, we could not reach mediation. That's the reality of construction arbitration mediations. This was one. Secondly, now this was my client and he was at fault, let me tell you. I'll not name definitely. It was a pharmaceutical company's project, a project of 18 acres to be developed, having multiple buildings just in the outskirts of Mumbai. The construction was to be completed within specific timelines. You all know developers never complete construction within timelines. Even after giving extensions, it was not completed. I was representing such construction company. The matter was being arbitrated, and again, it was referred to mediation. The mediator and a High Court retired judge, and she was very good as a mediator, let me tell you. She tried up till last moment of the session, multiple sessions rather, but it could not happen. There was only one reason: greed of my client. I said it to his face. It is your greed that has cost us this particular case. Eventually, we won the case, and you know very well how it works in arbitration. You start with section 9, section 11, 34, 37, thereafter you go in 136, and thereafter you have curative petition. So at the end, this will go on. The matter could have been settled there and there itself. Now, why I am sharing these 2 failures, it's because we should not get swayed only by success stories, but we should understand that these failures teach us a lot. They give us lessons which should not be, or from which we should learn and decide future course of action. And those lessons, those learnings, if I can spell it out, One was decision makers are not at the table. When the mediation is taking place, ensure that if it is your client, get the decision maker on table. For all the sessions, if that is not the person who is going to take the decision, the mediation is worthless. That is the one thing I have learned. Secondly, do not treat it as formality. We have to inform our clients that do not treat this as a formality. It's something which can actually yield results. Thirdly, public authorities, the fear that they have in their mind, that I may be perceived as corrupt, I may be perceived that I have done some backhand dealing while the mediated settlement agreement is being placed. That needs to be taken care of, for which we need a lot of training for public officials who are involved in arbitrations and litigations. Apart from that, sometimes we are too late to attempt mediation. In time, mediation is a very good pill. But if you do it late, when the evidence is seen, when the cross-examinations have taken place, and one of the parties feels or understands that I have an upper hand, then it is either advocates or the clients who are smart themselves may take a call intentionally that I do not want to settle this matter. Sometimes expert guidance is not provided. This is the fourth point, I feel. Sometimes it is important. I think somebody said from the audience short while ago that expert guidances or experts are not important, but according to me, I have seen it firsthand. Experts would help you a lot if they have domain knowledge, if they are domain experts. If I do not understand the designs, I do not understand the 3D structure of the building, and the question at hand is about a particular part of that building, how would I be able to mediate that case? So somewhere we need to involve domain experts. One more thing, for advocates, we all are advocates and judges, let's not treat mediation as a stepchild, because we had this feeling that mediation is a fluffy, it's a very soft thing to be done only by the cowards or something of that sort. It's been making rounds. But let's not treat it as a stepchild. We should give it a priority. And last and most important, and which is very important for us also, one example I'll give. Bombay High Court retired judge, I was in that mediation. He quoted a fee. He quoted certain fee because he had habit of quoting fee for arbitrations also. And he quoted a certain fee. So that fee was a little higher than what my client or their client, the opposite side's clients, would have expected. Now, it has been considered, the opposite party in fact argued that you are not supposed to take fee as a mediator. So for a while I thought that have we lost our minds? Mediation, treat it as a profession. Advocacy is a profession. Mediation is a profession. Take fees. If you are a mediator, quote your fees. And if somebody else is quoting, if a mediator is quoting, do not raise objections unless it is exaggerated. So these are a few challenges that we have, which we have to curb. And that is why I come to the end with the saying, we have heard a lot of success stories. Let's think about the challenges that we have and the solutions that we can bring. Thanks a lot. Yeah.
Thank you, Rishabh, for a very thoughtful and illuminating talk. It brings out a lot of issues that we perceive or rather encounter in mediation. Litigation, at the end of the road, you get crores and crores of money, if at all. Mediation, to be successful, in order to recover that amount of money, you must have a mediator who must know the law, who must know the intricacies, and that is another contributing factor why mediation is not taking off in these construction contracts. Thank you very much. Now, I must turn to the General Secretary of Nivaran, of course, a very good lawyer and she's a distinguished author on the Mediation Act of India. Whenever I encounter any problems as regards the Mediation Act of India, she's the go-to person as far as I'm concerned.
Thank you.
And over to you, Ms. Nandini Gore.
Thank you, sir. Thank you. Sorry to keep all of you waiting for so long, and we have already started the printing of the certificates for sitting so long today. Please bear with me for some time. So mediation in infrastructure, as Mr. Vikas Singh said, is a very difficult task because, like Rishabh said, that it is not two-party centric. There are multi-layers of parties which are involved, and we can call all our skills in mediation are used here because we call it shuttle diplomacy, that we have to go from one party to the other party. I'm just giving you an example. So this is a village land, a grazing land, and the villagers are there, and one party decided to start a logistic park, which is 220 acres spanning. And the government officials, they decided that this is the rate I'm going to give to all the farmers. But the farmers came to know that this particular place is near the highway, and the compensation which they are going to get will be much higher. So they revolted. They said that we don't want this project because we know that the compensation which the government has to pay to us is much higher than this. And then a revolt was there. Now what should we do? Because if 15 farmers out of 1,000 farmers for this 220 acres land decide that we don't want to give it, the project is totally halt. Because a person who is going to start with such a big project, he has taken money from the banks, he has taken money from the lenders, he has to pay the interest rate. His whole thing is over. So what he has to do? Now he cannot go to every farmer, right? So what he has to do is he has to decide to go for a mediator. That mediator need not to be some very hi-fi person because you have to speak with the farmers. So he will decide to take some mediator who will sit and who will decide, okay, for your particular village from where I am going to take this land, I will try and do something for your benefit. So what we will do, I'm just giving you options. I don't want to give the cases which we handle because they are all confidential matters and they are mega projects, but I am trying to explain to you that it is not easy. So what they will do is they will talk to these farmers, they'll ask them that how much money you want. Now they can give any exorbitant figure, but they have to work out. Plus they will give them some alternatives like we will build a hospital for you, or we will build a community center for you, or we will open a school for your children, and you can take advantage of that, plus we will increase the rate. So this is how they can come to a settlement and a term. So I will show you the second slide also. So this is how we do it. Now, mediation to resolve possession delay dispute with home buyers. These are the cases which come to Supreme Court also. There are many companies who are building houses, right? And they are big complexes of 900 flats. On the first floor, you will get 3 bedroom. On the top floor, you will get something like 8 bedrooms, and the prices will be different. People will pay their asking money, and like for example you have to deposit this much amount of money in the first installment, second installment. Now this is the case. I have changed the name of the parties because I cannot disclose. So 900 unit township stalled because the financial partner withdrew after the cost overruns. Now what to do? 400 families, they were started paying their EMIs. And now they are saying this is totally disastrous. The construction is unfinished. What is to be done in those type of cases? Now, rather than litigating for years, what they will do? The promoters and the buyers collectively agreed to structural mediation. A neutral mediator with real estate finance experience set up an escrow account funded by the fresh sale proceeds. tied to milestone-based construction release and gave buyers representatives a standing seat on the monthly progress report and the committee. And compensation for the delay period were folded into the final settlement rather than fighting separately in the court. So this is how this project was saved, and it was delayed, but proper compensation was paid and they came to a conclusion and it was mediated successfully. Now this is regarding co-developers. When there are co-developers, it is not easy for big projects where one party is the developer. So there are 2 co-developers or 3 co-developers. Here it was a case where I have just given S, you can say S and A group, jointly held a large redevelopment project through a special purpose vehicle. SPV, many of you must be knowing that. Each controlling a near equally stake. When the project lender declared default and moved to enforce pledged shares, S accused A of concealing cost overdues, and A accused S for blocking approvals. Now multiple suits followed and the site sat idle for 2 years. Then a retired judge, he acted as a mediator and he brought both the promoters on the table and the lender also on the table, structuring a phase buyout. A exited for a fixed amount paid over 2 years. Then against that, the shares of the build-up area within every pending case withdrawn as part of the settlement, and an amount was given as a lump sum and the matter was resolved. I'm going to give 2 more examples and I'm done. Now this is another mediation. Buyers allege a builder altered approval plan of the sale, reducing unit size and adding unauthorized floors. Usually what happened that we were told that you will be giving a flat like this, the drawing rooms area will be this, you will have a kids playroom, you will have a storage area, but when the buyers, they pay the money and then they say that it is not there. So at 8 hours, buyers discovered on possession that 2 of the 4 blocks had gained extra floors and the promised common amenities has shrunk. A resident welfare association representing roughly 600 flat owners began exploring a collective damage claim running into hundreds of crores instead of years of consumer litigation. The builder and the association, they agreed to structural mediation involving an independent structural auditor to verify the actual deviation. The process produced partial refund tied to the confirmed area shortfall on upgraded clubhouse to offset the lost amenities, and the revised maintenance agreement capping future charges increased for 5 years. So this is how this matter was settled. There was one environmental slide. Can you just show that? No, not this. Yes. So this was a project where this project was stalled after an environmental authority flags concern raised by a local advocacy group, which usually happen in Bombay. It happens very rampantly that a PIL will be filed and then the whole project is stalled. So a proposed highway bypass ran along the edge of a protected wetland, and a local environmental group petitioned the Pollution Control Board for stopping and encroachment in the approved alignment. The project authority faced idle machinery cost and mounting pressure to meet an announced deadline. While the contractor, he risked penalty cost for a delay it had not caused. A mediator converted the authority, the contractor, and the advocacy groups together rather than letting the matter drift towards a tribunal appeal that could take years. The parties agreed to a revised alignment setback by few hundred meters. So what they did, they shifted the land. They said, okay, we will shift it. It will not be near the waterland. And this is how this matter was settled. So in a nutshell, I just wanted to tell you that infrastructure project is a specialized field. It is not a field where you go to if you are ready to go to court, for example, we law firms, we always welcome, please come to us, because we know it's a 3 years plan for us that, you litigate, we will send you the bill. But there are certain matters which can be resolved. And big infrastructure companies, they don't want to go into litigation because they want to try mediation, and many of the matters in Delhi and Bombay and Gujarat also, many mega projects, road projects are settled with this. So thank you very much for listening to me. Thank you.
Thank you, Ms. Nandini Gore, for these visual representations. A lot of hard work has gone into it. Of course, it's virtual manner for some jaded audience, right, which is virtually must have grown quite weary of the whole proceeding so far. So we will straight away segue into questions and answers. Only 3 questions, I'm being told by the panelists. So you can pose 3 questions. I see a hand going up. Yes, somebody can give the mic to her.
Good evening, everyone. First of all, I want to thank Nandini ma'am to point out mediation in land acquisition disputes, because in land acquisition, it starts from Special Land Acquisition Officer and goes to Supreme Court. However, there is no provision of mediation in Land Acquisition Act, Right to Fair Compensation, or NHI Act. But if it happens, it will definitely be very helpful. But my question is from Justice of Honorable Justice, Supreme Court of Sri Lanka. I have done like lot of construction arbitrations related to FIDIC contracts and all. But if I have done like 50 arbitrations, not even in single matter, those DRB provisions gained any success. So my question is, what can be done to make these kind of mechanism effective and successful?
Well, they have still not dropped the district adjudication mechanisms out of the FIDIC, and then, well, we are stuck with that. But I was stuck with it in my arbitration, which I did for Sri Lanka. The arbitral tribunal, as I told you, which comprised 3, one from UK and the other 2 from, one was from Sri Lanka and the other, we did it at the Maxwell Chambers in Singapore. We had to go through the whole hog, and that mechanism, decisions are made by them, but unless they drop it or keep silent on it, the moment they give the notice of intention to oppose, we have to go to arbitration. The only way in which Singapore had tried to overcome all this is by having this MED arbitration, and then Malaysia has followed it with MED, ARB, then MED. So these are ways in which jurisdictions are trying to grapple with this. So your frustration, I have suffered it in my own life as a counsel for Sri Lanka. So the second question, please. Yes.
So my senior, Mr. Singh, always says that I must feel the pain of the client. For resolution of a dispute through mediation, we must feel the pain of all the parties involved. And as I think out loud, I can think that because time, money, and emotions are involved in the process. So yes, the present time is most important time, but I stand with the lessons learned in the past and the pain I carry from the past. So my question to each one of you is that when we are stepping into a mediation session, when we are at a stage of successful mediation, hopefully, and for the way forward, what is that one first principle which each and every party must have in mind, which will lead to a prosperous future?
The author, I'll give it to the author on mediation.
No, but then she has asked each one of you, sir.
Yes, yes. So we'll start from her.
So the one thing which this whole process would be the initiator would be the desire to find a middle path. If you want to find a middle path, you will find one. If you don't want to find a middle path, and most of the cases where middle path is lost completely are those cases which get entangled in ego. And if you set apart your ego, and if you honestly work towards wanting to find a middle path, I'm sure you will.
You can, please go ahead. Rishabh, you.
Yes, so if I am the mediator, first of all, I say, trust me and trust the process. You trust the mediator, you trust the mediation process. If these two things you have as parties or advocates, I think you'll reach the destination. It's very easy. But that trust is difficult and for which you have to strive. Yeah.
Yeah, you're absolutely right. There are certain core elements that a mediator must have in order to inspire confidence. As I said before, the mediator has to have expertise. Then, well, if you look at the ICC arbitrations, you will see the timing is so vital. It moves in a very orderly manner. In the same way, the mediation also must have timelines, strict timelines. It takes them to quick and expeditious disposal. And I must tell you, recently I had to refer one matter to arbitration, rather mediation. The mediation failed because the mediator was not paying attention. He was sleeping on the, he was not listening. He was quite old, right? My friend was saying that once you retire, the arbitration market opens and then the judges earn much more than they would have earned in the past. So that kind of culture must also develop in mediation, right? And then we can invest more in them, because who else is better equipped to do mediation other than experts like us? Maybe retirement is not too soon in the horizon, but then what I say is the system of mediation has to be refined, and because we are in a no man's land at the moment. It's not fully defined. Even we have also now brought in a mediation legislation, and the great author was telling me that some of the mediation provisions have still not been brought into effect in India. So I'm about to address next week Sri Lankan symposium on this. So these are issues that that will we have got to address in the future. Joe?
So the young lady, she asked us a question where she said that the mediation, see the mediation is a structural process, and we all have to go 40 hours training, plus we do capsule trainings, plus we go try to do many international trainings also, and then I think at the end a refined mediator is formed. Now, what you said up to some extent I don't agree, that you have to take the pain of the parties. If you keep on taking the pain of the parties, it's just not possible. You have to be a professional. You are a professional. It is like a lawyer, an engineer, or a doctor, or any other like MBA or whatever. So this is a profession for you. Yes, you have to hear to the parties. Listening is the most important thing in mediation. If you are not a good listener, you cannot be a mediator. If you jump on conclusions, how can you mediate? So these are the things which every day we all keep on learning, and everybody is learning, and we keep on learning. We try to read more books, and we try to see that, for example, this shuttle diplomacy, which when I learned it, and I used to think that, okay, I'll start the mediation with many years back when I was very new. that I will start the statement, I will tell to the parties about myself so that the trust building is there, that I have done so many mediations, these are my educational qualification, and this, that, no. After that you take introduction of the party. You know, parties fight on this thing also. There's whose introduction you have taken first. Because if I call Mrs. A first, please give your introduction, and not Mr. B. Why did you call her? You have a prejudice for a female. So there are so many things. Every day we start learning with this. And to become a good mediator, I think it takes a lot of tapasya from everyone, and then you can become a good and a refined mediator. And you cannot give guarantee of any matter that this matter will be resolved. One can never be 100%, unless and until that mediation agreement is signed. Sometime it is signed and it is with the mediation center, and we get a call in the night, Madam, we want to meet you again. Why? What happened? No, I thought about something, and no, madam, one more session is required. And it will not go for the, to the judges next day in the court. Again, they will start. So, unless and until it is signed, it goes before the judges, it becomes decree of the court, you cannot give guarantee that it will be a successful mediation. So, there is no success 100% that day one matter is coming and you are 100% sure about it. So that is about it. Thank you very much.
Thank you.
You have
Thank
asked,
you. Sir, we are sorry, sir. I think the time is already...
you have asked too many, about 4 questions in
no,
one question.
Gracious lady, please, sorry. The time is already passed. We have 3 hours late. I'm so sorry.
Please ask one more question.
My name is Ejaz Maqbool. I'm a lawyer in Supreme Court only for past 41 years. Let me end this evening with a couplet. सुबह सुलह की राह पे चलना ही बुजुर्गी है दोस्तों, जंग तो नादान भी हर बात पर कर लेते हैं. Walking the path of reconciliation is true wisdom, my friends. Even the foolish can quarrel over every matter. My Lord Justice Nawaz is here. Let me just tell you I have a small query. The query is here. Mr. Vikas Singh and Nandini will be the best persons to answer this. In our country, most of the big arbitrations which we have handled is with the government. And the government authorities, when they know that in a particular mediation or in arbitration proceedings, the party must get that much of award, but they will never agree to it because they are afraid that ED will come. If they agree for any payment to be made by the government, they will never agree. So here we had an interaction with the government. The Chief Justice was here. The state of Rajasthan was here. The central government was represented by the Attorney General and Mr. Tushar Mehta, Solicitor General. We should also tell them that if there is something where the government can also agree, they should also do that. But that's what my query is, and that should be answered. Thank you.
So this was discussed in our last meeting with the Honorable CJI. Samadhan jo hum log hone wala hai coming this month in Supreme Court. This exact issue came up, that nobody from the government side will ever agree for a settlement, because nobody wants to take a call ki I have agreed that we will agree for this amount to be paid. So the one solution that we have thought of, and we are going to implement it, I mean Supreme Court is going to implement it, is that from the government side, apart from somebody from the law officer being there, a committee of 3 will be there, so that it is not an individual decision with regard to accepting a particular settlement. And every matter will be vetted by the committee, so in that sense that nobody can raise fingers on any one person that you have gone out of the way to favor somebody by giving a particular amount. I think that's one solution that comes as a handy solution to start with. But over a period of time, I think the way forward will be the credibility of the mediators. The more credible the mediator, the better will be for the government or anybody to understand that this settlement should go through.
So the upshot of all this is that how best we can make this system effective to ensure enforceability. Thoughts have been shared, and I hope today's session catered to the issues that confront arbitration, or rather mediation in infrastructure and construction contracts. Thank you very much for patiently listening to us. And until we meet tomorrow, we wish you a very good night today, and have a great night, and then conviviality, fellowship, and mixed feelings of wisdom and joy.
Thank you very much, sir. With this, we come to an end of our session over here. And now, but then small, just 3 more minutes, may we request for the souvenir presentation, may I request Sri Alok Surolia to please come on the dais immediately and felicitate our session chair, Honorable Mr. Justice A.H.M. Dilip Nawaz, Judge, Supreme Court of Sri Lanka. May we have you, sir, please. And also same sequence, I'll request Ms. Seema Agrawal, District Judge, Ms. Yogita Parikh, Savitri Anand, and Ms. Suman Saharan. To all please come near to the dais so that we can wrap this up in a flash. Mr. Alok Surolia to felicitate Honorable Mr. Justice A.H.M. Dilip Nawaz. Thank you, Honorable, for accepting the token from our side. Thank you very much. Ms. Seema Agrawal, District Judge, may we have you on the stage, please? Yeah, she's coming. Madam, you have to felicitate Mr. Jyotirado. Please, she's gone. Thank you very much. Ms. Yogita Parikh, please come on the dais, on the stage to felicitate Mr. Vikas Singh, President, Supreme Court Bar Association. Thank you very much. Ms. Savitri Anand. Madam, please felicitate Mr. Rishabh Gandhi. Thank you very much, Madam. Thank you, Rishabh. Thank you very much. And last, Ms. Suman Saharan to please come and felicitate Ms. Nandini Gore, General Secretary, Nivaran. Thank you very much. So with this, we come to an end. Ladies and gentlemen, thank you very much for being here. We now proceed to dinner. Before that, we'll have a group photograph, I believe.
I would like to have a photograph. And before that, I would like to convey my thanks and regards to the panelists, chair, the session chair, and all the delegates, and the persons who are sitting on that side for their patience and yes, I just wanted to say that have a big round of applause for yourself and for us also.
Thank you very much. After the group photograph, we'll all proceed towards dinner. So as honorable judges will move towards left-hand side, so kindly make way for them to move comfortably to the dome side. And rest for all of us, the lunch is at, the dinner is at first floor, Balochi. I repeat, all the honorable judges to please make way for them so that they can comfortably move towards the dome area. And for all of us, please enjoy the dinner at first floor on the Balochi restaurant. Thank you very much. Good night. See you tomorrow at 9:30 hours.